Fresh matter tomorrow, my lord.
ಕೊಡಿ.
Tomorrow.
Tomorrow ಅಂತ ಬರ್ದ್ ಕೊಡಿ. Fresh matter.
Fresh matter tomorrow. Name tomorrow. You could.
Separate ಆಗಿ ತಗೊಂಡ್ಬಿಡಿ. Tomorrow.
RFA for admission.
You yavagana ಕೊಟ್ಟು. You yavagana ಕೊಟ್ಟು.
First appeal not pending matter for admission.
Conviction appeal under section POCSO Act, he was in jail for more than 7 years.
ಅದು ಸೀನಿಯಾರಿಟಿ ಬರುತ್ತೆ. ಸಸ್ಪೆನ್ಷನ್ ಕನ್ಸಿಡರ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಬರ್ಲಿ, ಆಮೇಲೆ ನೋಡೋಣ. ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಆಯ್ತು, ಕೊಟ್ಟಿರಿ ನೋಡೋಣ.
Page wise adjournment, page number 7 till number 20 to 26. Page number 8 till number 27 to 32. Page number 9 till number 33 to 35. Page number 10 till number.
Serial number 45, my lord. Well, at serial number 45, I request on short accommodation.
36 to 39, page number 11 till number 40, page number 12, 41 to 44, page number 13 till number 45 and 46. 45.
Serial number 45, my lord. I request on short date. I am appearing for appellate.
Inform the other side.
Yes, ma'am.
Deal with the matter at request. Very difficult.
28.
Yes.
Non-compliance objections, 5th time, AG, serial number 1.
1 week time may be granted.
Weeks time granted for necessary compliance.
Two also.
Same.
Serial number 3, Liaquat Farid Ustad.
Yes.
Appearing for appellant, my lord.
Nandila.
Suit is dismissed for non-prosecution. This court has direction to file the paper. I filed the paper.
Dismissed, suit is dismissed for non-prosecution.
Yes, my lord.
ಕೊಡಿ. ಅಲ್ಲ, but notice ಆಗಿಲ್ವಲ್ಲ? Notice,
Well,
we'll have to wait till the notice comes.
Please.
We may consider your case,
Yes, my lord.
but we have to, you have to complete the service. ನಿಮ್ ನೋಟಿಸ್ ಅಲ್ಲೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಗಾಗುತ್ತೆ?
Please.
You place it on record, whatever paper book you want.
Please.
You see that you want to take out notice by way of hand summons, you try it. ತಗೊಂತೀರಾ?
Yes, my lord.
A week's time granted for compliance with the office objections raised. Full stop. The appellant is also permitted to take out notice by way of hand summons to the respondents.
Please.
Yes. Date coding, week after next. If complete madidre, we may be in a position to give you relief.
Please.
But it's your headache to see that the notice is served. Yes.
20 minutes. Serial number 4, Shivkumar R. Tengli.
May I kindly seek password in the matter?
Serial number 5, Mahantesh Patil.
Yes.
R2 has to comply.
Huh?
R2 has to comply.
R2.
Please.
Affidavit is filed by R2.
Please.
Have they served copy on you?
Yes, my lord.
Affidavit.
Yes.
Comply ಆಗಿದೆಯಾ?
Already serve again.
No, we are asking. R2 has filed some affidavit, isn't it?
Yes, my lord.
They have served you a copy.
No.
ಇಲ್ಲ.
ನಮಗೆ ಕೊಟ್ಟೆ.
Pass over.
Copy ಕೊಟ್ಟಿದ್ದೀನಿ.
Gaurish Kashampur.
Gaurish Kashampur.
Compliance ಆಗಿದೆ ಅಂತ next week ನೋಡ್ರಿ ಅವ್ರು. Compliance ಆಗಿದೆ ಅಂತ ರಿಪೋರ್ಟ್ ಮಾಡ್ತಾರಂತ.
No, you have filed a memo. What is the affidavit you have filed?
ಅದೇನೋ ಅಲ್ಲ, ನಮ್ದು ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ಎಮರ್ಜೆನ್ಸಿ
Let us see overlay. You. Endorsement ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ. What was the direction? Consider ಅಂತನಾ?
Yes, ma'am.
What was the direction?
Compensation of
Consider
damage. my lord.
representation. Now they have considered by issuing endorsement at R1 and R2. You have a look at it.
I don't have any get affidavit.
Correct, we'll give you the file.
Yes, ma'am.
At least copy ಕೊಡ್ಬೇಕಲ್ಲ?
I'll arrange, my lord. I'm the
Pass over. You have a look at it.
Yes.
From the court file. We'll see. If according to you, that endorsement is requires to
Taken
be
tomorrow, it
challenged-
may be taken, my lord.
challenged separately, it's a different matter. Then you can challenge it, will reserve liberty. If the direction is only consideration, they're considered, there ends the matter. Pass over, you have a look at it.
ನಾಳೆ ಇಟ್ಕೊಂಡು
Six, VK Nayak.
This matter, my lord, we comply the direction of the Lord single judge, my lord.
Filing a retirement memo. Last occasion, my lord, the government has submitted some documents. Said that there is a compliance to my client. My client said, will engage someone.
So complainant is.
Is there, client is there.
Sir, complainant is present, affidavit ಎಲ್ಲ file ಮಾಡ್ತೀವಿ 2 days time ಬೇಕು.
No, on the mic, on the mic,
Complainant is present, my
on
lord.
the mic, man.
Complainant is present, my lord. Filing affidavit 2 days time.
What for affidavit?
Filing affidavit, my lord.
For what?
And
What is the direction?
Kindly
So
see my
it's of
page number
order.
8, my lord.
Page number 8.
Page 8. Under these circumstances, the respondents are directed to comply the process of survey in terms of the annexure A and E and pass appropriate orders within a period of 2 months from the date of receipt of the order copy. But earlier, my lord, on same ground, my lord, he filed the writ petition. Kindly see, my lord, my affidavit filed on 7/1/2025, my lord. On same cause of action, again he has filed.
No, no, that is okay. Now, right now, process of survey
Yes, my lord.
in terms of annexure A and E.
Yes, my lord. That is
So-
done.
Huh?
That is done, my lord, and also issued the, my lord, sketch, 11 is sketch and for number 10 also.
What is A and E now?
That is representation to make the, my lord, issue for number 10. On page number 27, my lord.
Proceed the petition. No, so what is the stand now? That survey is not complete or what? Ian, what is your?
I'm proxy counsel, my lord. Senior had told me that take 2 days time for filing affidavit, my lord.
Now you will file wakalat, fresh wakalat.
Yes, my lord.
The memo of retirement filed by counsel Shri VK Nayak is accepted and taken on record. Party is present and represented by counsel. He submits that they undertake to file wakalat on his behalf.
Yes, ma'am.
Office to show the name of so-and-so is representing the complainant.
Yes, ma'am.
Relist the matter on Monday,
Oh, obliged, my lord.
Monday.
Obliged.
But you have to produce the writ petition annexures. You must produce the writ petition annexures. We want to see what annexure A and E is.
Obliged.
The complainant to produce the writ petition with annexures.
Obliged.
Till number 7, Harshavardhan R. Malipati.
This matter, my lord, there is a direction, my lord.
Respondent 6 is a pro forma party, my lord. The government may be direct take notice. They are already served.
They have filed an affidavit.
Yes, my lord. Respondent number 4, accused number 4 has filed an affidavit saying that, my lord, he has processed and sent the file to the deputy commissioner. He is supposed to take the call.
What is the direction?
Direction was to, my lord, consider representations and, my lord, if the land is acquired, the initiate acquisitions. Para 4, my lord, consideration. Para 5, my lord, running page 14 and 15, my lord, directions.
So notification is to be issued under 6.
Yes, but that is, my lord, we asked the beneficiary to deposit that amount, my lord. And my lord, we also sent the, my lord, release of that amount. 50% amount, my lord, has to be deposited by the beneficiary, my lord. That, my lord,
Beneficiary
request
is
is made,
not a party.
but he is not party. That's why we requested, my lord. And they are also written letter to the, my lord, government to release that
So
amount.
then we'll adjourn it till you finish
Yes,
whatever.
yes. I
2
will,
weeks. Sir.
within, my lord, 1 week, my lord, that amount will be
1 week.
released, my lord. We'll proceed with the acquisition.
Hmm.
That
We'll have it
regarding
next week. You update us what is happening.
2 weeks will also pay, my lord, because, my lord, that
At request on behalf of the state, relist the matter on 29th.
please.
Respondent 6, my lord, process may not be necessary. Government
Yes,
advocate.
directed to accept notice for R6.
R4 is, my lord, is already retired from the service, my lord. R4. Maybe subsequent, my lord, any other officer is there, my lord. I also mentioned in the memo. Lordship may direct him to, my lord, substitute the name of the,
AGA submits that the R4 has retired from service.
on 31/5/2000.
Submits that the necessary steps may be taken to substitute R4 by the present official.
Yes.
Counsel for complainant.
Yes.
Submits that
We'll do the needful.
the necessary steps should be taken. Will permit now.
Yes, my lord. The name is there, my lord.
Counsel for the, he's already there.
He is not there, my lord. One of the new officer, my lord, Mallikarjun Dandin. I also mentioned in the memo. my lord.
So 4 must be substituted by Mallikarjun Dandin.
Yes, my lord. Notice has to go to him.
In light of
Mallikarjun
Dandin.
H. Mallikarjun H. Padi, Mallikarjun Dandin. Okay.
Hmm,
I'll
le-
substitute. my lord.
counsel for the complainant makes an oral request that in light of the subsequent events, he may be permitted to substitute R4 with the present, with the official who is holding present charge, that is Mallikarjun M. Dandin,
Please.
who is working as Assistant Executive Engineer, PWD Subdivision, Kalagi.
Yes.
In light of such oral submission made, substitution is permitted, necessary amendment to be carried out to the cost title, issue notice to the substitute, to the official now substituted in place of accused number 4.
Please. Great.
Number 8, Satish Kumar Gadkar.
I'm appearing, my lord. File but the affidavit, my lord, I am not satisfied, my lord.
Huh?
I am not satisfied, my lord. File the respondent number 2, file the affidavit.
They filed an affidavit.
Yeah, but I am not satisfied, my lord.
What is the direction?
But to consider the representation and
Page?
page 13, my lord.
13.
Yeah.
Now they've considered it.
Yeah, my lord, but I am reading, my lord, in affidavit, page number Ranger RX6, my lord.
Huh?
File by the respondent, file number of respondent number 6, my lord. R6, I'm reading, my lord. ಸದರಿ ಪಂಚನಾಮ ವಿಷಯದಲ್ಲಿ ಕಣ್ಣು ತಪ್ಪು ಗ್ರಹಿಕೆಯಿಂದ ಸಲ್ಲಿಸಲಾದ ಪಂಚನಾಮ ವರದಿಯನ್ನು ರದ್ದುಪಡಿಸಲು ಮಾನ್ಯರು ವಿನಂತಿಸುತ್ತಾ ಹಾಗೂ ಸದರಿ ಪಂಚಿನ ವಿಷಯದಲ್ಲಿ ಕಣ್ಣು ತಪ್ಪಿ ತಪ್ಪು ಗ್ರಹಿಕೆಯಿಂದ ಬರೆಯಲಾದ
You're reading it?
Yeah, my lord, page number 11, my lord. Affidavit filed by the respondent two. ಕಣ್ಣು ತಪ್ಪಿಯಿಂದ ಗ್ರಹಿಕೆಯಿಂದ ಬರೆಯಲಾದ ತಪ್ಪು ಪಂಚನಾಮದ ತಪ್ಪಿಗೆ ಕ್ಷಮೆ ಕೊಡುತ್ತೆ ಇನ್ನು ಮುಂದೆ ಸರಿ ಕೆಲಸದಲ್ಲಿ ಈ ರೀತಿ they are actually in my lord respondent to Tashildar and they are ready to the verifying the petitioner's reports, village assistants.
No, what was the direction to consider what? What was your grievance before the single judge?
Yeah. Only consider representation,
In
my
the
lord.
writ petition, what was your grievance? What did you want consideration?
My representation consider, my lord, under the report.
Appointment is the post of village
Village
assistant.
assistant, my lord.
On what ground you wanted appointment?
My lord, one recommendation of their particularly the excess work. They're ready to the one representation of the petitioners and ready to the post, vacant post there. And writ number, my lord, I'm the writ page number. Their Panchanam also, they are ready and report also submitted the petitioners. In the writ number, page number, writ filed by my lord.
No, they may be ready. What is the rule applicable for appointment of village assistant?
Yeah, my lord, excess work because they are ready to the one more.
Those all is discretionary stopgap arrangements.
No, because he ready to the department respond with Tashildar and the authority ready to the his representation and verifying his character and verify the reports and Panchanama also ready to the respond. Thereafter issue this affidavit, my lord. I'm read, my lord, on 17, page number 17 in a red petition number. And post is vacant, my lord, another post is vacant there. Itel ಆದ್ಮೇಲೆ ತೊಮಲ್ ಅಂತ ಹೇಳ್ತಾರೆ.
My lord, what happened, my lord? Here, my lord, he was the, my lord, working as a, my lord, without, my lord, any payment and all, he is working in that office. Then, my lord, he also made the one representation to the deputy commissioner to appoint him as a assistant Grama Sevaka. Thereafter, my lord, concerned officer, Tasildar and another revenue inspector, even report in his favor only. Yes, he is capable and that post is there, you can, that is a recommendation. Then, my lord, after noticing that representation, we asked again to them, how you recommended? Then, my lord, they said that Kantapininda we recommended. So there is no post. That is my annexure R4, my lord, kindly.
ಅವ್ರ ರಿಪೋರ್ಟ್ ಹಾಕ್ತಾರೆ ಈ ಕಣ್ ತಪ್ಪಿನಂತೆ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ my lord.
R4.
R4, my lord. Para number 3, my lord. Page number 9, my lord. There is a direction by this one to consider, my lord, reasoning order is written, my lord, that is, I am not disputing that one. ಮುಂದುವರೆದು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಆದೇಶದಂತೆ 11/7/2024 ಮತ್ತು 18/7/2024 ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಕಾರ್ಯಾಲಯ ಯಾದಗಿರಿ ವಿಚಾರಣೆ ಕೈಗೊಳ್ಳಲಾಗಿದ್ದು, ಸದರಿ ವಿಚಾರಣೆಗೆ ಗ್ರಾಮ ಆಡಳಿತ ಅಧಿಕಾರಿ, ಕಂದಾಯ ನಿರೀಕ್ಷಕರು, ಗುರುಮಿಟ್ಕಲ್ ಎದುರುದಾರರು ಶ್ರೀನಿವಾಸ್ ತಂದೆ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಸಹ ಗುರುಮಿಟ್ಕಲ್ ಹಾಜರಾಗಿರ್ತಾರೆ. ಸದರಿ ಪ್ರಕರಣದ ಕುರಿತು ವಿಚಾರಣೆಗೆ ತೆಗೆದುಕೊಂಡು ಎದುರುದಾರರ ಅರ್ಜಿ ಮತ್ತು ಸರ್ಕಾರದ ಸುತ್ತಲೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿಯವರು ನಿಯಮಾನುಸಾರ ಪ್ರಸ್ತುತ ಗ್ರಾಮ ಸಹಾಯಕನೆಂದು ನೇಮ ಮಾಡಿಕೊಳ್ಳಲು ಬರುವುದಿಲ್ಲ.
Now, annexure R4 is the consideration.
Yeah, but
Understand?
no. The report is R4 is wrong, my lord, because
That you have to
No, no,
challenge.
no.
Not here.
No.
What is R4?
ಕಣ್ ತಪ್ಪಿನಿಂದ
No. Go to the operative portion of the order. You read. PTK ಅಲ್ಲಿ ವಿವರಿಸಿದಂತೆ read.
No, that no. Page
So
number
read
11,
the
my lord.
operative portion of R4.
ಶ್ರೀನಿವಾಸ್ ತಂದೆ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಗುರುಮಿಟ್ಕಲ್
Allowed.
ಜೋರಾಗಿ ಹೋಗಿ.
ಪೀಠಿಕೆಯಲ್ಲಿ ವಿಷಯದಂತೆ ಶ್ರೀನಿವಾಸ್ ತಂದೆ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಗುರುಮಿಟ್ಕಲ್ ಯಾದಗಿರಿ ಅವರಿಗೆ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ನೇಮಕ ಮಾಡಿ ಕಾನೂನಿನ ಅವಕಾಶ ಇರುವುದಿಲ್ಲ ಹಾಗೂ ಗುರುಮಿಟ್ಕಲ್ ಕಾನೂನು ಪ್ರಸ್ತುತ ಯಾವುದೇ ಹೊಸ ಗ್ರಾಮಾಶಯ ಹುದ್ದೆ ಸೃಷ್ಟಿಯಾಗಿರುವುದಿಲ್ಲ. ಆದರೆ ಶ್ರೀನಿವಾಸ್ ತಂದೆ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಗುರುಮಿಟ್ಕಲ್ ಅವರ ಅರ್ಜಿಯನ್ನು ಮೂಲಕ ತಿರಸ್ಕರಿಸಿ ಆದೇಶಿದೆ.
So ಅದನ್ನ
But
challenge.
no, my lord, I'm challenged the secondary, my lord, but this department already the verify my character and Panchanama ಊರ ಬಂದಿಲ್ಲ ಪಂಚನಾಮ ಮಾಡಿಲ್ಲ
Maybe.
ತೋಲ
If there is no post, how you can be appointed?
ಇಲ್ಲ ಬೇರೆ ಕಡೆ ಒಕ್ಕಂಟ್ ಇದೆ my lord, ಬೇರೆ ಕಡೆ ಒಕ್ಕಂಟ್ ಇದೆ ಅದು
Challenge it, not in contempt.
ಇಲ್ಲ ಬೇರೆ ಕಡೆ ಒಕ್ಕಂಟ್ ಇದೆ ಡೈರೆಕ್ಷನ್.
The observation of the single judge.
Ah.
Respondent deputy commissioner is directed to consider written representation and to pass appropriate orders strictly in accordance with law. But
But
they
my
say
lord-
law doesn't permit.
No,
it.
no, one my submission. My read petition number, page number, I read in
We
one.
can't go beyond that. That direction you agitate it separately, not in these.
At least one direction, my lord, gives one more representation, I'm ready to the
Not
vacant.
again madakagala. You can't get a post so easily. There are rules.
No, vacant is post there, another post is vacant there, my lord.
Maybe not in contempt. It's not a case of willful disobedience. The present proceedings have been initiated alleging violation of the direction passed in WP 203303 of 2023, whereby the learned single judge had directed the Deputy Commissioner Yadgir to consider representation of the petitioner and to pass appropriate orders strictly in accordance with law within a period of 8 weeks. The writ petition was filed seeking for issuance of a writ in the nature of mandamus to direct respondent Coke to appoint the petitioner as village assistant. That direction has been considered in terms of annexure R4 produced along with the affidavit. Operative portion of the order would reveal that there is no provision for appointment of the petitioner in law. Further, it is submitted that there is no fresh post of village assistant that is created. Full stop. Learned counsel for the complainant has raised various contentions, including that vacant post is available. Full stop. However, taking note of the direction for consideration in accordance with law and in light of the stand in R4, it cannot be stated that there is any willful disobedience of the order. Full stop. Accordingly, proceedings are dropped. Liberty is reserved to challenge annexure R4 if the complainant is so advised. ನೀವು ಅಲ್ಲಿ ಬಾಯ್ಬಿಟ್ಟು ಹೇಳ್ಬೇಕಲ್ವಾ
Really, but that list I furnished, my lord, there is there, but he can apply with the procedure will appoint. That one post is there. If he made the representation, my lord, but
Yes. Don't use the court to get appointments done. You do it at, if you want to give him and take him on contract, you take him. Why
Where-
put the court there?
where he given, my lord, there is no vacancy. Wherever vacancy, my lord, if he is given. my
Correct,
lord,
but you have made some note, your officers have also given some promise to him, that you do it. Yes.
Nine, Nitesh Padia, Sudarshan, you.
One kind submission, my lord.
Yes.
Lord, Lord, the matter which against my lord contempt proceedings initiated. Lord, these matters, my lord, interconnected to my lord writ appeals which are pending before my lord SLP. I mean, is the matter which my lord pending consideration in SLP have come before the my lord board. Today, my lord, it is at serial number 8. So kindly, my lord, small accommodation we request for, my lord. Whatever the outcome of that, my lord, today's matters before the Honorable Supreme Court, we, my lord, go ahead with, my lord.
Any
that,
date may be fixed, my lord.
That request made on behalf of the respondent, relist the matter, next week date code.
obliged, much,
Yes.
much obliged, much.
Till number 10, Preeti Patil.
If the cross objector.
Notes, proxy counsel notes, week's time may be given for taking out paper publication for R4 minutes.
Matter was heard, my lord, in the last sitting. Lordships wanted to hear the matter, my lord, on merit. This was a case, my lord, where they make the insurance company, my lord, makes private investigation and my lord comes up with a claim that the driver was not the one who was driving the vehicle.
Who is R4?
For his owner, my lord, technically is necessary party. But your lordships, my lord, there was an interim order subject to deposit and release of 50%. But my lord, your lordships modified that and there was an absolute stay and your lordships wanted to hear, my lord, one terminology, my lord. I made a submission, my lord, that on 13/9, my lord, I made a submission that there is no pleading to the effect that, my lord, they contest the 39, my lord, your lordship, sir.
Correct, now who's R4 is a necessary party,
Sorry.
then you carry it out.
Yes, my lord.
When?
Weeks time, my lord.
Relist the matter on date code. Necessary steps to be taken as regards service of notice to R4.
Yes.
Right. 20? Yes.
Number 11, Kojalagi Chandrakant.
Award is maybe correct. Judgment is the accident date of the difference, but award is corrected. I think to judgment only 19 is there, award only 18 is there. But 18 is correct, date of the action.
Keeping open the office objection raised by the office, the clerk counsel is directed to issue notice. Keeping open the office objection raised, issue notice to R1, she so and so. Anuradha M. Desai.
United Insurance Company is United India Insurance. Hospital ಹಾಕಿದ್ದಾರೆ.
Hospital
ಹಾಕಿದ್ದಾರೆ. ಅವರಿಗೆ take notice.
She hospital is directed to take
Take
notice for
okay.
respond number 2,
2 sir.
respond number 2. Wherein records ಬೇಕಾ?
ಅವ್ರದ್ದು ಅವ್ರ ಅಪೀಲ್ದಲ್ಲಿ ಆಗಿದೆ, ಬಂದಿದೆ ರೆಕಾರ್ಡ್ ಆಗಿದೆ. ಅವ್ರ ಅಪೀಲ್ದಲ್ಲಿ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ ಆಗಿದೆ, ಇನ್ಶೂರೆನ್ಸ್ ಅಪೀಲ್.
Yes. Right. Tag this appeal with the MFA 202.
Connected.
ಬಟ್ ಅದನ್ನ ನೀವು ರೆಕ್ಟಿಫೈ ಮಾಡ್ಕೊಬೇಕು.
ಮಾಡ್ತೀನಿ ಸರ್. ಇಲ್ಲ
ಅಲ್ಲಲ್ಲ, ಆಫೀಸ್ ಒಬ್ಜೆಕ್ಷನ್ we have kept it in abeyance, but to ensure that the record is correct, ಅದು ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಮಾಡ್ತೀನಿ ಸರ್. ಬಂದ ನೀನೇ ತಂದು ಕೊಟ್ಟಾರ ಸರ್.
ಏನದು
ತಂದಿದ್ದೀರಾ ಡಿಗ್ರಿ?
ತಂದಿದ್ದು.
ಅವಾರ್ಡ್ ತಂದಿದ್ದೀರಿ?
ತಂದಿದ್ದು.
ಆಯ್ತು, ಹಾಗಾದ್ರೆ ಮಾಡ್ಬೇಡಿ. ನೆನ್ಪಿಟ್ಬಿಡೋಣ, ಹಾಗಾದ್ರೆ ಬೇಡ. ಕೀಪಿಂಗ್ ಓಪನ್ ಏನಕ್ಕೆ?
ಕರೆಕ್ಷನ್ ಮಾಡಿಕೊಟ್ಟು.
ಹಾಗಾದ್ರೆ ವೀಕ್ಸ್ ಟೈಮ್ ಗ್ರಾಂಟೆಡ್ ಟು ಹಂಗೆ ಹಾಕೊಳ್ಳಿ. ವೀಕ್ಸ್ ಟೈಮ್ ಗ್ರಾಂಟೆಡ್ ಟು ಕಂಪ್ಲೈ ದಿ ಆಫೀಸ್ ಒಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಇದನ್ನ ಹಾಕ್ಬಿಟ್ಟಿದೆ, ಕಂಪ್ಲೈ ಮಾಡಿ. ಆಯ್ತು, ಮೀನ್ ಟೈಮ್ ಇದನ್ನ ನೋಟಿಸ್.
ಅಲ್ಲ ಅದು ಓವರ್ ಆಲ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ನಾ ಇದು ಮಾಡ್ತೀನಿ. ಇದು ಅಲ್ಲಿ ಅಟ್ಯಾಚ್ ಮಾಡ್ತೀನಿ, ಓವರ್ ಆಲ್ ಮಾಡ್ಬಿಟ್ಟು.
ಅಟ್ಯಾಚ್ ಮಾಡಿಬಿಡಿ. ಓವರ್ ರೂಲ್ ಏನಕ್ಕೆ? ಅಟ್ಯಾಚ್ ಮಾಡಿಬಿಡಿ. ಮೀನ್ ಟೈಮ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಮಾಡಿಬಿಡಿ.
Number 12, Mahantesh Patil.
Yes. What's the office objection raised regarding furnishing of translated copies kept in abeyance for the present.
The husband of the petitioner, my lords, went missing from 25/11/2024. The complaint was lodged, my lords, and the FIR was also registered.
Still not traced.
Not traced.
Yes, learn government advocate is.
Please, I take note.
Yes, take notice. Directed to take notice and file report.
Please.
Within a week, within
10 days. 10 days.
Yes, denotify.
One date.
Denotify.
20. ಯಾವಾಗ ಹೇಳಿದ್ರು?
8 days ಅಲ್ಲಿ ಕೊಟ್ಬಿಡಿ. 8 days. 22nd.
ಆಯ್ತು.
22nd.
Number 30, DP Ambedkar.
Office has raised an objection that court fee has to be paid on the consideration amount. Plaintiff's appeal, first appeal, suit for declaration, permanent injunction and cancellation of registered sale deed with respect to an agricultural land. Under section, the suit, my lord, for declaration is valued under 24B of the Court Fee Act.
D.
So B.
Hmm.
And so far as this thing is concerned, cancellation, it is valued under section 38. What section 38 of the Code Fee Act?
No.
Ah.
Valuation is as per section 39.
38
Valuation.
valuation.
No, appeal valuation.
Section
49.
47.
40,
47.
40. Court fees. Same as that in the trial court.
But where irtadu. Valuation is same.
No, have you paid same or no?
Lesser amount, correct amount I have paid. We have paid excess amount before the trial court unnecessarily.
So now how we can sit and enter into that?
Actually, that was not required. In fact, we can reclaim also where excess court fee has been paid.
Huh?
There is provision.
That we'll see. That let us see.
Ah.
Now you have paid, you pay as per the 49.
49.
Huh.
Even as per 49 also, I have paid the correct court fee. Independently, we have to access as if this is a suit. 49.
Anyhow, we'll keep it open. Let us see, let the state, because matter of
In fact,
revenue,
it is.
let the state
please.
take you serve a copy on the state. State, you examine it because it's a matter of revenue. Court fee, some objection. He's saying that what is payable has been wrongly paid on a higher thing. You examine that point. The government advocate is directed to be served with copy of the appeal insofar as aspect of payment of court fee. Full stop. As the matter relates to an aspect of revenue, government advocate to have a say on that matter. Yes. Now, what is the other?
Only one.
Main caveator is there.
Caveator is copy is served.
Copy served.
Copy is served.
Relist next week. Date.
Please. Kindly it may be admitted, Manas. A first appeal is there. Keeping open question of court fee. Kindly it may be admitted.
What is the difference in the court fee?
1,13,000 was paid before the trial court.
Here
we have paid 50 rupees. Please.
We'll hear them.
Please. In fact, it is covered by decision. Is there?
No, Aditli. Now you have only paid there. 49 say what is payable. Let us see.
Please.
You get ready on that point.
Please.
Number 40, Mrutyunjaya Mallaya Shetty.
Password means. Password.
Password. Yes.
It's held up in court on.
Hearing on I, still number.
Happy court.
Yes.
In this matter, my lord, may I request for a 10 days time, my lord, because earlier KNL counsel is appearing, my lord. My name is shown. I'll collect the copies and submit the argument.
What are these matters?
The matter pertaining the enhancement, the connected matter 200,097 is the condoned delay of the same day, 4,04,072 days, subject to condition they not entitled to interest. Another 200,099 of 15 also condone the delay.
Let us see, let them take.
Please.
Week after next, you take your stand. How many days delay was condoned?
4,072 days.
In 10 varsha mail ಮಾಡಿ
11 years.
Connected matter
11
subject
years.
to condition, they not entitled to interest. Same foreign notification, same common judgment of the reference court. Out of the common judgment, 4 appeal is pending.
Why you didn't appeal?
Because of the enhancement,
Why did you wait till that was decided?
because of the exhibit P9 is the relying the judgment of the neighboring village of the Maga village. that judgment will be challenged by the beneficiary as well as the claimant. The Honorable High Court will be remanded to the matter to reference court to consider thereafter the reference court will be enhanced the 13 rupees 88 paisa. I realize the exhibit P9.
You had not filed reference.
I filed a reference because of I realized the judgment of the Maga village, that matter pertaining to the Kamlapur, to just to adjusting village to acquire for the rehabilitation center for the same purpose.
Consider.
I relied the judgment of the Maga village exhibit P9. The subsequently claimant as well as beneficiary challenges the exhibit P9 to Maga village to subsequently be remanded to the reference court. Reference court will be considered the both side and enhance the 13 rupees 88 paisa pertaining 97 notification. Thereafter, I came to know that I relied that judgment, the subsequently enhanced. Therefore, I filed an appeal to seeking the parity ground on the ground of the exhibit P9 subsequently will be enhanced.
Yes.
Till number 60, Harshvardhan. Audit party.
Yes.
Would appeal by the claimant for enhancement, delay of 1,100 and
Yes, government.
not the issue regarding, my lord, enhancement is concerned, my lord, this honorable court, my lord, in another connected matters, my lord, has disposed of awarding higher compensation.
Same notification. Same village.
Yes. My land is, my lord, the present land is survey number 56.
Ah.
The land involved therein was, my lord, survey number 53. My lord, one additional issue that is, my lord, arises in this case is, my lord, regarding Port Kharab land. An extent of 2 acre 5 guntas has been treated as, my lord, Port Kharab land. So, my lord, my dispute was that, my lord, this classification, one, my lord, is wrong. Even if it is assumed, my lord, the Port Kharab A belongs to the government that, the claimants, my lord, the landowners, that has to be compensated.
Akarband settlement is there.
My lord, the
Last date your lordship directed to get the Akarband.
directed Allah.
Open, that is the Bible to the survey number.
ನೀವೇ ತರ್ಸಿ.
ಆಯ್ತು.
Do you have it or we'll have it next week?
Yes,
Next
I'll
week.
try to
You
second
try.
that.
ನೀವೇ ತರ್ಸಿ.
ಆಯ್ತು ಸ್ವಾಮಿ.
We'll list the matter on
23rd or
23rd. Check ಮಾಡಿ ಅದು. ಇವಾಗ A na B na unclassified.
Yes,
And then he'll make his arguments on it.
Seventy. Srinivas, Shyam Sundar.
ಅದು ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಸ್ಕ್ಯಾನ್ ಇಲ್ವಾ? Some documents on the website, survey records, etc. Scanned.
Irbodu, my lord, I have produced ROR, my lord, which shows it is a Kharab land only.
Correct, but you get that one document that will clarify if doubt if it.
I'll say
Even
that.
village map also required. ಯಾಕೆ ದಾರಿ ಇತ್ತು ಏನಿತ್ತು ಒಂದೊಂದ್ ಸರ್ತಿ A ಆಗಿರುತ್ತೆ ಸ್ವಾಮಿ B ಆಗಿರುತ್ತೆ B.
ಅಲ್ಲ, but if you have classified, then there ends the matter. You ask your official, revenue official, to give the necessary document.
Please.
Number 70, Srinivas, Shyam Sundar Rao.
Yes, Hiramat.
Party has taken NOC and also the advocate Srinivasa is no more, my lord. Our expiry is tomorrow about 4-5.
Apte.
Vinayak Apte.
17 months, there is delay of 19 days.
No, correct. Now that delay will condone.
NOC ತಗೊಂಡೋಗ್ಯಾರ ಅಂತ ಹೇಳಕತ್ತಿ.
ಅದೇ my lord, earlier Mr. Srinivas Siddhapurkar was appearing. It is mentioned, my lord, I have not obtained NOC, but my lord, he is no more.
That will. The endorsement in the cause list that NOC is not obtained is overruled as it is submitted that the previous counsel has died. Accordingly, wakalat of filed by learned counsel Vinayak Apte is accepted. Will condone the delay. IA 1 of 2023 is allowed, accepting the cause shown and delay is condoned. So what is the matter now?
That's a small matter, my lord. Section 7 of the family court. Have it, my lord, next week, any date.
What is the point?
Point involved is, my lord, suit for declaration is filed before the family court. Initially, family court, my lord, returned the plaint, directing that it has no jurisdiction. Later on, my lord, I presented the plaint before the civil judge senior division. Senior division also, it has returned the plaint, my lord. Again, it has no jurisdiction. So then again, I filed, my lord, before the same matter before the family court. Family court recorded evidence, heard arguments on merits, and when she, after hearing the arguments, my lord, the plaint is again returned. So where I am to go? This is the only point. Section 7 is
what is the relief that you have sought?
relief plaint, my lord. The respondent is not the wife of the plaintiff. Appellate.
Respondent is?
Not the wife, legally wedded wife of the appellate.
You produced the plaint, huh?
Yes. Earlier, advocate was appealing, my lord. My request, have it tomorrow, my lord.
No, correct. So Justice Thakur once remarked, suit was filed, stated, seeking for a declaration, she is not my wife.
Please, sir.
So he was already married. He was already married.
No, she was married, sir.
No, hypothetical. So Justice Thakur was saying, the suit was filed to declare that this person is not my lawfully wedded wife. That person was already married, in the context of which he filed the second suit. Second suit is dismissed. So what is the consequence? Lawfully he can have two wives. In negative prayer,
but though, my lord, my submission, though it is a negative, facts are totally different, my lord.
No, correct. So what is the prayer now in your plaint?
My lord, the appellant is having two.
No, let us see, but let us see whether
Thanks, my lord.
jurisdiction is there. What is the prayer in your plaint? To declare defendant number 1 is not the legally wedded wife of the plaintiff, and defendant 2 and 3 are not the children of the plaintiff. Okay, so now what does section 7 say, Family Courts Act?
Any dispute, my lord, which pertains with regard to dispute between the relationship of husband and wife, my lord, section 7. Dispute suit lies before the family court only. Civil court can't adjudicate such dispute.
After Justice Anant Hegde ಅವರು ಬರ್ದಿದ್ದಾರೆ ಅಂತ ನೋಡಿದ್ರು. Justice Anant Hegde ಅವ್ರ judgment. Justice Anant Hegde ಅವ್ರ judgment ಯಾವ್ದು ಇರ್ಬೇಕಾ? ನೋಡಿ ಬಿಡಿ ಅದು. Time for.
The explanation B. Explanation B nodi. Now the family court has returned.
Returned, sir. There are 3 orders, my lord. Earlier suit was filed, properly filed before the family court
That
only.
is okay. Adupidana. Now the present family court has returned.
Returned, sir.
Go to the order. Let us have a look. Correct. Correct.
Paper seal. Paper seal.
Go to the order. Let us
The
see.
order copy, my lord. It is dated 27/2/22, sir.
Ah,
This is the suit filed by the plaintiff against the defendants to declare that defendant number 1 is not his legally wedded wife and defendant number 2 and 3 are not his children, and also to restrain them from claiming as a wife and children respectively by permanent injunction and such other reliefs. Initially, the suit was filed before this court, which is registered in OS number 26/2007. Thereafter, by order dated 18/8/2012, holding that this court has no jurisdiction to entertain the suit, ordered to return the same to the plaintiff to present the same before the proper court. Thereafter, the plaintiff has presented the same before the senior civil judge, Kalaburagi, and it was registered as OS number 189/2013. And on 19/1/2018, again the plaintiff was presented before this court as it was returned from the senior civil judge court, Kalaburagi. Accordingly, this case is registered. The defendants appeared through their advocate and filed written statement. On the basis of the pleadings of the party, this court has framed the following issues: whether the plaintiff proves that defendant number 1 is the legally wedded wife and defendant number 2 and 3 are his children, whether the plaintiff is entitled for the relief sought for what order or decree. In the written statement, the defendant number in para 15 had taken contention that the suit in the present form is not maintainable. The court cannot grant the negative relief, but nowhere taken contention that the suit, this suit can be decided by the court. So there is no issue framed on this point. Both the parties have adduced their evidence. After hearing arguments of both sides, matter was also reserved for judgment. During the course of argument, the learned counsel for the defendant has argued that this court has no jurisdiction to entertain the suit. For that, the learned counsel also relied upon the decision reported in 2012 4 KCCR 2690 DB, Bhuneshwari versus so and so, my lord.
Ladana, have you gone through that judgment?
No, my lord, I am not telling, my lord, today. I have it tomorrow, my lord.
Only on that point.
Only on that, my lord. Small point will not. Have it tomorrow, my lord. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿನೂ ಇಲ್ಲ ಇಲ್ಲಿನೂ ಇಲ್ಲ where I am to go, my lord, that is the issue. Only short point is involved. Have it tomorrow, my lord, please.
Tomorrow.
No, but it should be taken on 28th.
On?
28th.
ಅಲ್ಲಿ
I will
ಏನಾಗಿದೆ
intimate.
ಅಲ್ಲಿ 17th ಡೇಟ್ ಇಟ್ಟಿದ್ದಾರೆ ಸರ್.
ಎಲ್ಲಿ?
ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬೇರೆ several suits are going on, my lord.
Several
That is,
suits.
ಅದು ಬೇರೆ suits
So it is posted on 17. So therefore, with that intention, my lord, I move memo.
No, ಆಯ್ತು. Let him also get ready.
I will intimate to them. NOC ತಗೊಂಡು ಹೇಳೋದು.
Let him also get ready. List on 20th.
Oblige, sir, please. Oblige.
No, but prima facie, we have not seen the division bench judgment of the coordinate bench. Prima facie, explanation B says a suit relating to marital status of any person. So now he is saying she is not my wife. That relates to the marital status of the petitioner and that lady. Isn't it covered then at the 7th?
And moreover, my lord, interestingly, she pleads, my lord, in earlier proceedings, in 1987, she married with me, the appellant. But whereas her earlier husband was different and that divorce petition has been ended in 2001.
No, that's on the merits. Sir.
So that is also pleading, my lord, pleaded.
No, that is on merits. We will not enter into merits. We are only on the prayer.
Scope is limited, my lord.
Let us.
Oblige.
Number 80, Rahul R. Asture.
Filed the IF for withdrawal of the deposited amount, my lord. They have deposited the 50% amount.
23. Records ಬೇಕಾ ಮುಗಿಸ್ಬಿಡಲ್ಲ?
Records
Yes,
ಇದೆ, my lord.
records have been secured here, my lords.
Claimants appeal for enhancement.
Corporations appeal, my lords, challenging quantum. Only on one ground, my lords, that the director of the company who has given evidence before the tribunal, he says, I am a D.Ed pass, and the certificate shows that he is a director of an engineering company. My lords. That is the only ground. My lords. If date may be fixed, it may be taken up for finally.
ಬಂದಿದೆ. Final dispose.
Yes, sir.
Please, my lord.
Instead of considering IA for withdrawal, finally once for all.
One short date, my lord, because the heart operation of the respondent's son is.
ನಾಳೆ ಆಗ್ತಾನ? ನಾಳೆ ರೆಡಿಯಾ? ನಾಳೆ ರೆಡಿ ಆಗ್ತೀರಿ? Tomorrow.
Monday.
Request, joint request, re-notify Monday.
Blessed.
Number 90, Subhash Mallapur.
Okay, my lord, could be condoned, my lord. I am for the respondent in MFA. Cross objection, my lord, I need a week's time for compliance.
Day 2 of 24 is allowed. Delay in filing the appeal is condoned except in the R5 and notice must go, is it?
My lord, I have entered caveat for R1 to 4.
5 and 6. Who is 5 and 6? Whether you can appear.
No, I'm for the claimant. 5 and 6, I suppose they are the owners, my lord. Notice.
So notice must go. Issue notice to R5 and 6. What about in your
Yeah, my
MFA crop?
my lord, I will do the compliance, my lord, within a week's time. My lord, I'm required to file application for. contempt.
Correct.
Yes.
Now there.
Yes.
You have to. R2 to
2 and 3, my lord, I will have to take.
issue notice to R2 and 3.
Yes. One, my lord, Mr.
Malapur
Subhash.
accepts notice for R1.
R1.
Office objections to be complied forthwith.
Great.
My lordship in MFA number 202480, my lordship. Main appeal, my lordship. Kindly stay granted, my lordship.
Huh?
Grant stay, my lordship.
Stay of the order.
Yes, my lordship.
That, my lord, I will file my objection. I will file my objections, my lord, and contest, my lord.
No, but
Ground.
now execution or what is the
Yes, my lordship. Execution.
file agide?
Yes, my lordship.
ಇಲ್ಲ, execution.
Execution file ಆಗಿಲ್ರಿ ಮಾಡ್ಬೋದು.
Lordship, may have it, my lord, tomorrow day after. I'll make my submissions regarding, my lord. That. Since there is
As
delay,
the
my lord,
amount
it's
is
not-
deposited.
Ground, you are only on the ground of enhancement or what?
My lordship, we are for appellant, my lordship,
Correct.
quantum and liability, my lordship.
On liability also.
Yes, my lordship.
Okay, you then don't precipitate till the next.
Like, I'll instruct, my lord, but lordship may have it on 23rd, my lord. By that time, if you can, my lord.
Released on 23rd.
Much obliged.
Then the hearing matter till number 20, RJ Busare.
Hearing for petitioner. Lord, the petitioner is seeking, my lord, the appointment on compassionate ground.
No, the application filed by you,
Yes,
you are the son.
I am the son, my lord.
You filed in 2016.
No, that is the wrong, my lord. The honorable tribunal has failed to consider, my lord. Your lordship,
Mother gave, no doubt.
my mother, my lord, made an application
Give it to
within
my son.
time. Within time, as on that day, my lord, I was 17 years of age.
But that some finding is given, that finding is.
Your lordship, page number 208, my lord. Page number 208. This is the, my lord, 208, internal communication of the department, my lord.
So what is your age, correct age?
17 years, my lord.
As on the,
As on date of death of my father, my lord, I was 17 years age.
208.
208 second para, your lordship. ಅನುಕಂಪದ ಆಧಾರದ ನೇಮಕಾತಿ ನಿಯಮಗಳ 1990 ನಿಯಮ 5 ಅನ್ವಯ ಮೃತ ಅಧಿಕಾರಿ ನೌಕರ ನಿಧನ ಹೊಂದಿದ ದಿನಾಂಕದಿಂದ 1 ವರ್ಷದೊಳಗೆ ಅನುಕಂಪದ ಆಧಾರದ ನೇಮಕಾತಿಗೆ ನಿಗದಿತ ನಮೂನೆಯಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಬೇಕಾಗಿದ್ದು, ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯು 1 ವರ್ಷದೊಳಗೆ ಇದ್ದು ನಿಗದಿತ ನಮೂನೆಯಲ್ಲಿ ಇರೋದಿಲ್ಲ. The format, my lord, is not filed, my lord, in the particular format. This has, my lord, not been, my lord, looked by the honorable tribunal.
Now you were a minor as on the date of that 1 year.
Yes, my lord.
So where is the proof of your age? Any
Yeah, my lord.
document? here?
Age proof, my lord, the birth, the certificate I have not produced. By oversight, my lord, my mother has stated in the application that, my lord, I was 20 years, my lord, age as on the date of death.
So we are saying now.
Yes, ma'am.
You produce some
Yes,
document.
I'll produce, my lord, the birth certificate I'll produce.
Huh,
Because my date of birth is 2/1/1986. 2/1/1986. The date of death is, my lord, 17/11/2003.
But you should have followed it up, isn't it? You kept quiet for such a long
No, because, my lord, the civil suit was going on because there are 2 wives, my lord. My father had 2 wives, my lord. There is a dispute between, my lord, between the wives, my lord, saying that, my lord, she is the first wife. Then, my lord, the Maya Devi, my lord, who claims to be the wife of my father, my lord, filed a suit.
No, correct. But now the apex court has said, irrespective of whatever, after a long time, it may not be appropriate to grant relief is what it says. You examine that. It says irrespective of whose end the delay is, irrespective of. It says finally that if that period has crossed, then court should not, that's what it is.
Yes, my lord.
Examine it.
The very
2023 SEC online SC 219.
Yes.
2023 SEC online SC 219. State of West Bengal versus Deba Brata Tiwari and others. Court has said irrespective of whosoever instance delay is caused, court cannot grant relief. Now 2003.
Yes,
We are 20 years late now.
my lord.
So irrespective of the delay, now there may be delay, we don't dispute that. But if the difficulty has tided over for 20 years, then we cannot consider what effects code. You also have a look at this one and you come back. WP 6955 of 2023. So the test appears to be that if you have sustained for so long.
Yeah, and that is
the
my
very
lord.
purpose of compulsory appointment will be defeated.
My lord, this inquiry has been held in the earlier occasion, my lord, at the instance of my lord, the second wife of my father.
Maybe. So here also in the writ appeal, the court said merely because it took time to get into RTI, etc. Finally, if the crisis has tided over, then the court can't grant. You have a look at this one and you come back. Relist the matter next week. 22nd. Because it's an exception, we have to strictly.
But 21, SS Mamadapur.
For the petitioner, Lord's order of detention, Lord's
Must file a habeas corpus.
Lord's has been clarified. It has to be posted before a bench which deals with habeas corpus matters, not Lord's. It should not be
correct. We are saying your substantive order. Suppose you are merely challenging a detention order, merely.
Yes.
Then there is a appeal under the statute, under some of the acts. One though. However, if there is no bar on you filing a habeas corpus in which court will visit the correctness of the detention order. So you will have to amend your prayer. It's maintainable, but you have to amend the prayer and seek for issuance of writ of habeas corpus.
Yes, Lord. So one judgment. Adun clarify ಮಾಡಿದ್ದಾರೆ.
Although subsequently that judgment
I will
will be
not,
clarified.
yes, Lord. So if possible, Lord, I will get that judgment also. And
No, the legal position is habeas corpus. So
I will
amend-
file an application seeking Lord's amendment of prayer. In the meantime, Lords may also direct the learned government advocate to accept.
Will accept your oral request, amend your prayer.
Yes,
Then we'll issue notice.
please.
Huh?
Yes.
Counsel for the, we'll allow the amendment, and then you take notice and you get it.
Classification change ಆಗುತ್ತೆ sir. Numbering will be.
WPHC ಆಗ್ಬೇಕಾಗುತ್ತೆ. Prayer.
Numbering change ಆಗುತ್ತೆ.
Now for
It will be totally a different.
So then what to withdraw ಮಾಡಿ ಹಾಕ್ತೀರಾ?
Yes, my lord. That is the proper, for statistical purpose, it has to be closed.
Because I will do that.
Memo file.
Yes.
Petition is dismissed as withdrawn, liberty is reserved to to challenge the validity of detention order by filing writ of habeas corpus in light of the submission made.
Please, office may kindly be.
Then the certified copy of the annexures produced.
Yes.
Forthwith.
Yes.
Forthwith. All contentions are kept open. It's clarified that there is no adjudication as regards the correctness of the orders impugned.
Please.
Accordingly, the writ is disposed of.
Inform the bar member to file only habeas corpus, the detention order, not a statutory.
Please.
Kuleppa Heru,
Lord, I am for the petitioner. Second round litigation.
The proceedings before KT are pending.
Blood, I have been transferred, fourth respondent has been transferred in my place, annexure A6. My Lord will find at page number 54. Relevant page 57, item number 36.
Page?
Page 57. Item number 36.
The page number tally.
Page 57. Transfer order, annexure A6.
ಇಲ್ಲ page tally ಆಗಲ್ಲ.
I'm sorry.
ನಿಮಿಷ ತೋರ್ಸಿ.
74, 75 ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಯಾವುದು?
Page number 54. And
71.
relevant page.
ಎರಡೆರಡು ನಂಬರ್ ಇದೆ. ಇದು 70, 56.
ಅಲ್ಲ,
ಎರಡು
ಕರೆಕ್ಟ್ ಇದೆ. ಅವ್ರದ್ರಲ್ಲಿ ನಿಮ್ದು ಅಲ್ಲ, ಇದು ಪೆನ್ನಲ್ಲಿ ಫೈನಲ್ ಇಲ್ಲ 71. 71. Yes. No, now matter is pending before the KT.
Yes, they have declined to grant interim stay of annexure A14, where the KT has though referred the judgment. See, Misa, where the posting is not sure, transfer order has to be interfered with. That has not been done in my case.
No, now in that dummy counseling.
Yes.
You are posted where?
I am posted to Sindhgi Taluka. Sindhgi Taluka, dummy counseling. I am a headmaster. Counseling is supposed to be done at division level, whereas they have done at Taluka level.
No,
and in my options.
No, correct. But that there is some dispute, you were absent, etc. That we'll see. That we'll see.
I was ill.
No, that we'll see. Now, where is that order of posting you in Sindhgi? Let's have a look.
Annexure A14.
A14.
Page number 80. I'm sorry, my lord, there is this.
Page 98.
Number 14.
Annexure A14, page number 80.
Serial number?
Page number 80, my lord, in my.
Suya. ಮುಖ್ಯ ಶಿಕ್ಷಕರು ಸರ್ಕಾರಿ ಪ್ರೌಢ ಶಾಲೆ ಗಂಗನಹಳ್ಳಿ ಸಿಂದಗಿ ತಾಲೂಕು.
Yes.
So you are posted as a headmaster at Sindhgi.
Gangenahalli. on conducting dummy counseling in my options. And I am entitled to hold counseling at division level. Division level for counseling is done. I will be having the option to exercise and choose the place. Here only in Taluka, two places. And they themselves decide without my.
Let us see. You find out.
Please, but the papers are not proper here.
I will attend it. I will attend it.
8 ವರೆಗೆ ಇದೆ ಅದು ಬೇರೆ ವೈದ್ಯಾಧಿಕಾರಿಗಳದಿದೆ.
Let us see.
I shall attend, my lord. I'll attend.
AGA is directed to accept notice for the respondents 1, 2, 3.
1, 2, 3.
Who is 4 now?
4 emergent notice.
Emergent notice to respondent number 4.
Annexure A14 interim order. Annexure A14.
We'll get instructions.
I will go on. Kindly till then.
No, next week we'll have it. Let him find out. ಅದೇನಾಗಿದೆ ಏನೋ
ಇಲ್ಲಾದದ್ದು ಎಲ್ಲಿರ್ತದೆ ದಯವಿಟ್ಟು
no.
interim stay, my lord, consider.
We'll consider it next week. Let him get instruction.
Monday.
Relist on
Monday, my lord.
22nd.
22nd. You get instruction, what is the position? Or if he can be accommodated somewhere, vacancy is there, up to you. But you get instruction.
Grateful.
Commission till number 23, Sharana Basappa Babashetti.
Now
Appearing for appellant in this case.
TCR may be required.
Call for LCR is required, my lord. Exhibit P1 to P7 or stands in the name of my father, my lord.
No, my doubt was that the mother, after the father's death,
Please.
that lady got one share of some property. That is the mother. Her property goes to whom?
It is not clear.
That is not clear.
Clear, my lord.
The mother's share must also go to the legal representative.
Please.
Including the daughters. Now only the sons are given. Isn't it?
Please.
TCR to be summoned. List obtain TCR through telephonic communication. Relist the matter on date 29. But you have to show from your pleadings that the earlier partition of 1978
79.
related only to the two sons.
Survey numbers.
But after the father died, the mother's share was what you were seeking partition. That you have to show from your pleading.
Please.
Yes.
Number 24, BK Hiraman, Shivanand Patil for respondent.
Where is Shivanand Patil?
Shivanand.
Here for the response.
The appellant filed a decree for a dissolution of marriage under section 13(1)(b) of the Hindu Code on the ground of desertion.
Ground of desertion.
Desertion. The respondent Harshal filed a MC number 48 of 2013 before family court for restitution of conjugal rights.
What happened to that?
It was allowed and both parties have agreed to live together. And the appellant has made separate residential house, madam.
After that?
After the, before desertion, madam. The respondent filed a.
Correct. After restitution order, he made a separate house.
Separate house, but she herself is not joined in the company of appellant, not joined. Therefore, the appellant filed a dissolution of marriage under Desertion Act, madam.
On the ground of desertion.
Desertion.
Have you let in evidence, sir?
It was taken, madam. in internal page number 10, my lord. And current page 18, my lord.
Page
18, my lord. Para number 14.
Now, when did you make the house? When did you file the petition?
No, she filed in the year 2013, my lord.
No, we're saying 108 of 2017
Yes.
for desertion was filed on which date?
On 14/12/2017, my lord.
14/12.
2017.
When did you make that other house?
So after compromise between appellant and respondent,
When was that? When was that?
there is no specific date in.
Started living together, my lords, again on 27/5/2015.
27/5/2015.
From that period, they started living together.
Living together.
Yes.
After the restitution order.
Yes, my lords.
Then you left the house is what they're alleging.
Lords, in fact, if I may bring it to lordship's notice, she conceived, my lords, second child during this period only. That is during the order of the conjugal rights. When separate house was made, my lords, she conceived for her second child, and it was specifically alleged, my lords, by the wife herself, that there was no good care taken by husband.
And then she left.
No, my lords, it was she was driven out of the house, and my lords, thereafter she went back to her. It was during the pregnancy period, my lords, she had to be taken good care of. So for that reason, she started living with the parents. And thereafter, my lords, he never approached wife after the birth of second child.
Settlement
Earlier, it was referred to mediation on 31/3/2022.
So one time.
Wherein, my lord, she requested that in the separate house, she is ready to, my lords, lead her marital life. Even today, she is, my lords, agreeing to
go back.
Cause, my lords.
So question is, my lord, I have filed also application under section 151.
That application is also dismissed.
It was not considered, my lord.
Application for
151 CPC for
DNA
DNA,
test
my lord.
ಕೇಳಿದ್ದಾರೆ.
So whether the child was born to appellant or not, that was taken in this plea, my lord.
This court, my lords, on the earlier occasion has dismissed that.
It was dismissed, my lord. I do consider, ಇಲ್ಲ ಅಂತ ಹೇಳಂಗಿಲ್ಲ. But we tried level best.
Settlement ಆಗಲ್ಲ.
Settlement ಏನು ಹೇಳಕ್ ಬರಲ್ಲ, try ಮಾಡ್ತೀನಿ.
She is ready, my lords.
ಅಲ್ಲ ಆಗಲ್ಲ ಅಂದ್ರೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡೋಣ.
Your client only for reunion.
Yes, my lords.
His client only for permanent alimony. You are for permanent alimony.
ಇಲ್ಲ try ಮಾಡಮ್ ಸರ್, ಏನ್ ಒಂದ್ಸಲ try ಮಾಡ್ತೀನಿ, ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ we go. Please.
Parties could be if they are.
No, ಇಲ್ಲ ಒಂದ್ಸಲ ಏನಾಗಿದೆ ಸರ್, ಒಂದ್ಸಲ appellant was come before the mediation. On that time, the respondent was not present. Another date was respondent present, ಹಿಂಗಾಗಿದೆ ಸರ್. Madam,
you come.
Please.
On that day only we'll refer it for mediation. Both of you come. On that day itself we'll refer for mediation,
please.
Then you try. Both parties to be present on date 23rd. When date, next date.
23.
Keep them present.
Please.
Number 25, Krupa Sagar party. Desh.
I appear for the appellant in this case, my lord, being agreed by the order of the learned single judge. I appear for the respondent. My lord, being agreed by the order of the learned single judge, wherein compassionate appointment is allowed by rejecting the by quashing the endorsement issued by the JESCOM,
My lordship, I'd like to take your lordship to page 22, the reasoning of the learned single judge. Para 15,
Service is complete.
complete, my lord.
Please, I appear for the respondent.
Page 22, para 15.
KG?
Page 22, para 15. My lord, the petitioner for attained majority and is stated to have been made an application on 16/8/2008 in furtherance of the representation made by the petition number 1 on 17/6/2005 to the respondent. Though application dated 16/8/2008 produced along with the petition does not bear any endorsement of having been received by the respondent, the application is filed today under a memo which bears the endorsement of the respondent to have been received on 17/8/2008. My lord, here I'd like to submit 17/8/2008 is Sunday. There is no any such representation given. If lordship looks at the representation at page 37, the original, the one which was filed in the writ petition, doesn't bear the endorsement at all. They say 15/8/2008, 16/8/2008. It doesn't bear an endorsement. On the very same day when the order was being dictated, then they file along with the memo the application saying that on 17/8/2008 they had given an endorsement. 17/8/2008 is Sunday, my lord, and no any such application was given. By way of additional documents, I have produced the inward.
No, but where is their 17/8?
My lord,
Where is that, their document?
my lord, along with the memo, the records have to be secured, my lord. Along the very same day they are produced to the court, my lord, not to
You
the.
have to get the writ petition.
Yes, writ petition
records.
papers.
Office to put up. No, so you are saying it was not filed.
It was not filed. It is a fabricated document. Even I have produced the additional documents to show, my lord, there is an insertion made in the inward certificate which clearly makes the difference of the wordings, my lord.
Who took it?
My lord,
That is your writ.
my lord.
That is your writ.
Yes, my lord. We have issued a show cause notice to the concerned officer, my lord. There is no any endorsement also on that. If lordship looks at the additional documents, page 7, my lord,
Page
7.
uh,
Additional document. 428 is inserted.
420.
8. If lordship can look, it is clear, my lord, it is inserted and there is no any endorsement.
And there's no signature.
Yes, my lord. This is later on inserted, my lord, whereas the very first endorsement itself, there is no any.
Produce the original book.
I'll secure the original book also, my lord. On the next date of hearing, I'll secure the original book.
Your
Also.
book.
Yes, I'll have book. Irrespective of that, my lord, he is not entitled for compassion appointment because there is a belated application made and Honorable Apex Court.
Application is made when?
Application, they say it is in 2008. Petitioner, the father of the petitioner died in the year 2005, in January 2005. He was minor as on the dead date, my lord. He has to attain majority within 1 year from the date of death of the father. He has not attained majority. He has attained a majority in the year 2008. Not even a single word is mentioned on what date he has attained majority in the writ petition. Learned single judge on assumption says that in 2008 he has attained majority. And their case is that in 2008 the son has given a representation to appoint him on the compulsion ground, which itself is not maintainable, my lord.
It says in 1 year of.
1 year from the date of death, the son has to attain majority as per the guidelines. Guidelines is also.
The minor.
My lord,
If he's a minor.
if he's a minor, he was a minor within 1 year of the death. If any one of the person attains majority, then only they can make an application. Otherwise, not permissible. That's the rule. Irrespective of that, my lord, even the Honorable Apex Court has latestly held, my lord, even if there is a delay in considering the application also, my lord, as they have survived for so many years, question of appointment of compassionate ground does not arise, my lord. I would like to rely on the judgment of the Honorable Apex Court.
Paragraph.
Delay matter has been considered in para 16. Para 16 of impugned order.
No, correct. Let us see. We are not deciding today.
Please.
Let the record.
Please.
My lord, page.
Page.
My lord, page 13, para 7.5. Page 13. Page number is at the below, my lord.
Yes.
Para 7.5. These are the guidelines issued by the Honorable Apex Court.
So
Considering the second question.
Para 7.5.
I am permitted to read, madam.
Yes.
Considering the second question referred to above, in the first instance regarding whether application for compassionate appointment could be considered after delay of several years, we are view that in case where for a reason of prolonged delay, either on the part of the applicant in claiming compassionate appointment or the authorities in deciding such claim, the sense of immediacy is diluted and lost. Further, the financial circumstances of the family of the deceased may have changed for the better since the time of the death of the government employee. In such circumstances, courts or other relevant authorities are to be guided by the fact that for such prolonged period of delay, the family of the deceased was able to sustain themselves, most probably by availing gainfully employment from some other sources. Granting compensation appointment in such cases, as noted by the High Court in Hakim Singh case, would amount to treating a claim for compassion appointment as though it was a matter of inheritance based on line of succession, which is contrary to the Constitution. This is what the law has been laid down, my lord, by the Honorable Apex Court.
We are saying as on this date, we should not,
Yes, my lord.
irrespective of.
Irrespective,
delay.
even if there is a delay on the part of the, but on our part of the authorities, there is no any delay. But also, my lord, even if there is a delay on the part of the authorities also, my lord, as for so long years they have survived, from 2005 to 2025, they have survived. Question of considering appointment on compassionate ground does not arise. These are the guidelines from 7.1 to 7.65. The guidelines have been issued by the Honorable Apex Court.
Now you produce the register.
I'll produce, my lord. And even the learned single judge records may be called for, my lord. Learned single judge records, the memo which they have produced.
The office to put up records of writ petition number.
My lord, writ petition number. So I'll just
204-232, 2014. 204-232 of 2014 minutes.
20423 of 14. 32.
The matter on.
My lord, not on Wednesday. Wednesday service matters will be posted in portal 3. Any other date, 24th or 25th.
24.
Please.
But you must produce.
I'll produce the records of inward records from the office also, my lord. And because the endorsement says on 7/8 it has been received, that was Sunday. 7/8 question of receiving the endorsement does not arise because endorsement says 17.
Calendar tanni, idunu tanni.
Please, my lord.
ನಿಮ್ಮವರು ಏನು ಸಾಯಂಕಾಲ ರಾತ್ರಿ ಆಫೀಸ್ ಇಟ್ಟಿರ್ತಾರೆ ಯಾವಾಗ ಬೇಕು.
ಇಲ್ಲ ಸಂಡೇ ಪ್ರಶ್ನೆ ಬರಲ್ಲ. ಅಲ್ಲ, even if lordship looks at the records, lordship will find out how it has been inserted in various.
Are open on holidays also.
Please.
Oblige.
Video.
And even lordship judgment is also there. Next date I'll produce, my lord. Division, your lordship judgment is also there. In case of compassionate appointment, it should not be taken in a lenient view. That also I'll produce on next date of.
Shivakumar Kallu.
Yes. You have read the judgment.
My lord, I'm sorry for Lakships.
No, you have read the judgment.
That Tiwari's case,
Huh?
West State of West Bengal versus the Tiwari's case.
We are following that.
Yes, my lord, I have gone through that judgment also. My lord, this judgment with respect, I would like to submit. It is not applicable to our case. Because there the matter involved was court office. The Tiwari case, just I forward on this.
Yes.
What's it for? This was a case, my lord. In this case, what has happened is, there was no scheme, my lord, or policy. So the court held, my lord, that kindly come to the Had note C, my lord. No doubt delay question is also there. In absence of policy and scheme, my lord, the court held, my lord, they are not entitled for appointment and compassionate ground. This is this sum and substance according to me. No doubt delay is also one of the factor, my lord, which has been considered by the apex court. Here is a case. The petitioner's father was working in a minority institution. And till 2009, my lord, there were no rules or scheme, my lord, by the, and for,
At page 12,
yes, my lord,
7.5.
7.5.
From 7.4 over.
Yes. Seven point four.
As noted above.
Yes. Actually, my lord, what I'm submitting is regarding the financial, my lord, was regarding the finance of these persons. The inquiry should be held. Straight away, they can't presume that since he is able to maintain, my lord, that is one of the Supreme Court judgment says. My lord, saying that regarding financial constraint is concerned, you cannot assume that the person is having financial constraint. That is why, my lord, the court cannot assume and pass an order saying that he was able to maintain sustain for so many years. That is why that's not correct as per the Supreme Court judgment.
No, but what is the date of death now?
My lord, I will come to that.
86.
No, date of death is, my lord, 26/6/1986. His mother filed application, my lord, immediately on 19/6/1987, within 1 year. Thereafter, this person attained majority.
Now, what was the rule?
My lord, his claim was rejected by the respondent herein. Against that, a writ petition was filed because it is a minority institution.
No, so what was the rule?
My lord, rule is, I have produced at page number 75 for minority institution. '98, '99, 2002 rules were followed by the Honorable Single Judge. With respect, my lord, those rules were not applicable to my case. This 2011, my lord, that is 2009, 10, 11, 2009, were made applicable to the private aided colleges, schools, for claiming compassionate appointments. I think, my lord, I think your lordship got page number 75, the my lord, existing rules for these institutions.
Yes.
That, my lord, these rules are made applicable to the persons who have died. And rule 1996, my lord, has been made as applicable to this particular rules, this notification for appointment of the compassionate ground. Even this notification goes to the extent of saying that if accommodation is not available in that institution, they can be given posting at any other places. Case number, my lord, 77, if I'm correct. Any minority institutions. So this has to be taken note, my lord, because it was in the year 2009. In case of dependent from a religious or linguistic minority institution seeking appointment and compassionate body shall be appointed against a vacancy in any of the aided private educational institution imparting primary and secondary education belonging to the religious and linguistic minority. And for this, my lord, this notice, these rules, my lord, 1996 rules have been made applicable. Kindly come to the next. Nothing in the rule 9 of civil suit appointment of so on shall be applicable to any aided institutions. So if you consider the 1996, my lord, rules, my lord, the limitation is 1 year, my lord, within the date of attaining majority. And 2002, my lord, amendment was there. Your lordship knows if there is a minor.
No, after you made the application in 1987.
After attaining majority, I made another application. That is, my lord, 2000 he attained majority. And 12/11/2000 he filed application for appointment on compassionate ground.
Now, under the rules in force.
Yes,
you
my lord.
were required, what was the, if you.
When this order was passed, already these rules were there in existence. That is 2009 rules were in existence.
On the date of application, what was the rule in force?
My lord, there was no rules at all for these private institutions, my lord, for appointment of compassionate grounds.
Then you can't.
The rules came into force only in there.
There is no rule, then you can't claim compassionate.
No, my lord,
That's what Apex.
the apex court says, if there are no schemes or policy.
Then you can't. So that is on which date? On the date of death.
On the date of death.
Then
But these rules were not there. Subsequently.
Then you can't claim. That Apex court only has reiterated that. If as on that date, there is no scheme.
No, your lordship will find it at 2.8 million, 2.7 and 2.8 million. I could not have applied. .7 there.
16.4 no.
Just I will take your lordship to 2.
Page 22, page 22, conclusion.
Yes. Page 22, my lord.
16.4 no.
Yes. 16 point.
16.4. Page number 20. Mumtaz Yunus Fulani SBI versus Surya Narayan Tripathi 2014 within bracket 15 62 739. We just check up these two judgments in 16.4. Ali, error judgment is there. Have a look at it. And then we'll take it up tomorrow. We'll take it up tomorrow, have a look at it. Existence of a policy issued by the government is sine qua non for making appointment on compassionate basis. So if there's no policy, then it says the appointment must follow stipulation made in the policy. It is therefore a no-brainer that in the absence of policy governing compassionate appointment to post and local authority, no appointment could be made to such authority on compassionate grounds. So as on the date of death, there must be a policy, not on the day, on subsequent day. Have a look at it. We'll have it tomorrow. You also have a look at it. Release tomorrow.
Yeah, it's true, can't have till Friday, my lord.
Friday. Friday, but Monday.
Agli,
Monday.
Kandre, the Supreme, there are several judgments on this point.
Correct, but it appears to say on the date of death, suppose there is no policy, then we cannot because this is an exception to general. Have a look at. Released on Monday.
But there are other two judgments of the apex court, just I will pass on those judgments, my lord. Think, latest judgment of Supreme Court, my lord, some passed in the month of December. That I will just pass on those.
Good.
Huh?
But if there is no policy, then there is a doubt.
Court office. Court.
As on the date of death, there were no rules. Afterwards it came. Nim prakara.
2009 ದಲ್ಲಿ ಬಂತು, but subsequently 2013 ನಲ್ಲಿ they passed an order.
Correct.
The authorities passed an order.
But in 86, there was no.
No, man. There, for minority institutions, there were no rules or policy schemes, my lord.
Just get instruction. Yes.
But the division bench of Justice Ravindran and another two judgments. As on the date of taking application, Justice Gopal Gaudru's one judgment, the division of apex court.
Correct, rule. But as on the date of death, there must be a policy. Your decision taking is okay. But you could not have filed an application itself if there was no policy as on 80s. That is the point.
No, the question is, my lord, 1996 rules are made applicable to these rules.
You are not eligible.
No, the court says, my lord, within 1 year of attaining majority, they should make an
That is
application.
96 rules.
96 rules.
But 86, 87, there's no rule on this.
86, 90, highest, my lord.
Then there's a difficulty. Examine.
But this notification makes 1996 rules applicable.
Correct, but the 96 rules is applicable by the notification 10 years later. As on 86, 87, there's no rule.
Yes.
So there's no
Yes,
rule. Then
yes,
we can-
yes, my lord.
Yes.
Number 27, DP Ambedkar.
Lordship, this appeal has been filed challenging the dismissal of decree of resolution that was sought by the plaintiff appellant in this case.
Issue notice. So both the addresses shown in the cost item.
Please,
PCR to be summoned forthwith.
obliged.
28, BK Hireman.
See, dependent number 5 is,
Huh.
suit of the plaintiff is barred by limitation. So I have purchased suit property in the year 2006, my lord. The respondent outtake of file in the year 2012, but he was filed in the year 2018, my lord, after 15 years, my lord. So partition and declaration.
You are the purchaser.
I am the one of a purchaser. I purchased the suit property in the year 6, my lord, 2006.
2006.
So suit has to be filed on 2018, my lord. But it was filed on 2021. Suit has been declared by the trial court. So by that order, I have filed seeking a interim order.
What is the finding on issue number 4?
It was taken from the date of knowledge, my lord.
Which article you are referring to? Article 50? Limitation Act.
Limitation.
Article?
Article 55, my lord. I think.
Huh?
58, my lord.
58. Put it. Date of sale deed is?
2006, my lord. In page number 18, my lord, para number 5.
15/5/2006.
15/5/2006, my lord.
Huh.
So suit has to be filed in the honor about 15/6/2018, my lord. So suit has been filed in the year 2021, my lord.
Article 58.
8, I see. Issue number 4 has taken.
No, article. No. Pass over Raja, how article source. Pass over, just see how article. Pass over. You show us that you should have filed within 12 years, we'll consider interim relief. Yes, please.
29 came Bhate.
Appear for appellate, my lord. Plaintiff's appeal. Suit was decreed in part only with regard to relief of declaration of ownership. With regard to the other reliefs, my lord, there is correction of RORs, survey, demarcation, and sale deed of defendant number 1 was also challenged, my lord. Those reliefs are not been considered, and the honorable trial court holds, my lord, for challenging the sale deed of defendant number 1. Suit is barred by limitation. My submission, my lord, the suit was filed during the year 2018. The defendant number 1 filed an application for survey and demarcation. He wanted to sold away his property. During the year 2015, the application was filed and thereafter notice was issued and we filed objections, my lord. So thereafter the matter was referred to the Tahsildar. Then Tahsildar referred to the Deputy Commissioner, my lord. So immediately 2018, we filed the suit, my lord. Cause of action as such, we came to know that regarding the incorrect ROR entries regarding the entire suit property, we filed a suit in the year 2018, my lord. The suit is in time and there was no allegation by either of the contesting defendant. Defendant number 1, my lord, was contesting earlier. Later on, he entered into compromise. And defendant number 4, during pendency of the suit, my lord, defendant number 1 sold the property in favor of defendant number 4, my lord. That sale deed also we challenged. And when the suit was filed, my lord, there was already a temporary injunction order as against the defendant number 1 not to alienate the property. The honorable trial court holds, my lord, there are the sale deed of the plaintiff and defendant number 1, they are different sale deeds executed on different dates. So on account of that, the trial court holds, my lord, the sale deed executed by defendant number 1 during pendency of the suit cannot be found as null and void. On that ground, my lord, the other reliefs were being negative findings have been made on the issues, my lord. Therefore, my humble submission, when I have been declared the owner of the property, the other reliefs, my lord, they are the consequential reliefs, my lord. So they were supposed to be considered.
No, the scheduled property is only one item, isn't it?
Yes.
Now, once you are declared as the owner.
Please, my lord, 2 acres, 38 guntas.
Correct. No, then there other reliefs can be worked out before the revenue office on the basis.
No, what happens here, my lord? The revenue entries as such, even prior to sale deed, after the sale deeds, my lord, what happened here? The sale deeds in respect of this survey number have taken place from the year 74 onwards, my lord. 74, 76 and 77, my lord. In these 3 years,
So where is
sale,
the plain? Take us to your plain.
please, my lord.
Now, what we are saying, now you are declared to be the owner, isn't it?
Yes, my lord.
Correct. Once you are declared to be the owner,
Please, my lord.
if you approach the revenue authorities, consequentially,
No,
they
no,
will
there,
found by.
there lies one more dispute, my lord. The revenue authorities, since there is no form number 10, HISA 40 has been done. Now, unless a survey is conducted of the entire property, my lord, the sale deeds, respective sale deeds or the RORs, even as per the possessions.
So we agree with you, but what we are saying is those are matters before the authorities, you can agitate those matters before the
Please, my lord.
authority.
Yes.
Because substantive relief is granted.
Yes. No, one submission, lord. Regarding the sale deed of defendant number 1, Defendant number one, my lord, by entering into compromise, admits that though my sale deed refers as 5 acres 34 guntas,
There's no finding on that prior.
there is no prior finding. My lord.
Okay, you take out notice.
Please, my lord. I filed application as against defendant number 4, my lord. Now, since during pendency of the suit he has purchased, he is likely to transfer the property in favor of third parties once again by taking undue advantage of
So he has purchased which one?
from defendant number 1, my lord. During pendency of the suit, I was already having temporary injunction order in my favor.
14/6/2020.
Please, my lord.
14/6/2020.
Yes, my lord. That is during pendency of the suit. And the honorable trial court has already granted injunction in my favor
Where is that?
on 12/10/2018.
You have a copy of that?
Here I have, but it has come in discussion of the judgment, my lord.
Okay.
Judgment al bantide.
Point out.
Para 57, my lord, of the judgment, page 44 of my paper book. Para 57 ದಲ್ಲಿ relevant line on page 45, my lord. The learned advocate for plaintiff has argued that there is a stay order not to annul the suit property, even though defendant number 1 has sold the property to defendant number 4. In this case, the suit property is different from the property of the defendant number 1 also. So they are different. There is no relation in between between two properties. Therefore, violation of the court order by the defendant does not arise. So therefore, my humble submission, my lord, the entire issue was pending before the trial court with regard to how far the defendant number 1 was the owner of the property.
But the court says that property is different, identity is
That is wrong finding, my lord. It is the same property, my lord. What property I have challenge of the defendant number 1, same property is being sold away in favor of defendant number 4, my lord. That is on 14/5/2020.
Now, what is the TI you are seeking?
Temporary injunction not to annul it was there, my lord, in the suit. Now I am seeking same relief, my lord. Let the defendant number 4, who is now came on record subsequently, and according to me, my lord, his alienation is hit by section 52 of the Transfer of Property Act. So he may not take a chance to alienate the property in favor of third parties once again during pendency of the appeal, my lord. That is the relief I have sought.
The court says identity is different.
Identity is different only by reading the boundaries of both the sale deeds. But here what happened, my lord, the very sale deed of defendant number 1 I have challenged, my lord. I said if that sale deed is taken on record, the total extent of this survey number is 15 acres 34 guntas. Now taking into account about the 4 sale deeds, my lord, the total area is coming 17 acres and odd, my lord. So thereby, so my rights, because I am the subsequent purchaser, and my rights have been affected, my lord, because of the wrong RR entries maintained subsequently, even prior to that, my lord. And based upon the sale deed also, there are no RR entries, my lord.
No, otherwise, you take out notice, we'll have it next week. You have the notice served, we'll decide in their presence.
Till then, at least let us go, because what happened here, my lord, the defendant number 4, by taking the certificate copy of this judgment, he has approached the Tahsildar, my lord. And the Tahsildar is likely to change the RTCs. Then again, I will be suffered, my lord. Under that, my lord, I request the honorable court that IA1 is, may kindly be considered, my lord. Because ultimately he is during pendency of the suit, my lord.
Counsel for the appellant plaintiff submits that defendant number 4
Please.
had purchased from defendant number 1
Yes.
property during the pendency of the suit. During the operation of an order of interim injunction.
Interim injunction, my lord. And that was made available up to suit, my lord.
Operating against defendant number 1.
1.
Full stop. In light of the contention raised, there will be an order directing respondent number 4 to maintain status quo as regards property which was the subject matter of the sale deed bearing document number 109/2020-21 dated 14/6/2020.
14/5,
14/5.
5/2020.
14/5/2020.
Yes, 14/5.
This
Document is already marked.
order would be in operation till the next date. Emergent notice to the respondents, TCR to be summoned forthwith.
Much okay.
30, BK Hiramand.
This is my lord, similar to the serial number 21. This is Gunda Act matter. Writ petition is not maintainable.
You amend the prayer to include habeas corpus.
I do consider, my lord.
Huh?
I do consider, but the facts of this case, that means the petitioner is known very well. They have obtained signature of the petitioner, and same was intimated to the parents of the petitioner. And even parents are also known the order of the impugned order, my lord. So under such circumstances, the question of
ಅಲ್ಲ prayer amend ಮಾಡಿ permission ಕೊಡಿ.
I will amend and pass the order because of since he is more than 7 months he is under a detention order. Man.
That will do, but you amend.
Yeah,
it.
sorry.
The-
It was passed on 30th for 24, my lord. Since from 30th for 24 he is under custody detention order. Man. So around about 9 months he has been. So in the meanwhile, I may.
What is the ground now?
Only allegation is that he is involved in the criminal cases, my lord. He was on bail, my lord. Subsequently, it was taken that he has made some piece of public tranquility. And again, that order was passed by the respondent number 2 and 3. So they have taken detention order, man, on 30th for 24.
How many cases against him? How many cases were?
Totally, there were 8 cases, my lord. Out of 8 cases, 5 cases were acquitted as per Annexure A to E, my lord. So one case is that he is himself is in SC/ST, my lord. So that section doesn't arise, my lord. Only regarding other sections will be applicable to him. So another 2 cases were posted for entire evidence is also completed. Maybe it will be for argument or for still remain. Only after 7 cases. So one case even, that is SC/ST.
Advisory board, what happened?
They have taken only he has involved in the 8 cases.
Advisory.
ಇಲ್ಲ
board-
ಅದೇ 8 ಕೇಸ್ ಇದ್ದಾನೆ ಅದ್ರ ಪ್ರಕಾರ ಅವ್ರು ಆರ್ಡರ್ ಮಾಡಿರೋದು.
Given the copy, madam.
And the order was passed on 30th.
Correct. Advisory board, High Court advisory board, detention.
ಅವ್ರೇನು ಇದು ಮಾಡಿಲ್ಲ.
ಅದೇನಾಯ್ತು ಅದು?
Copy ಕೊಟ್ಟಿದೆ.
ಇಲ್ಲ ಸರ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಯ್ತಪ್ಪ ಅಂದ್ರೆ
ಆಯ್ತು.
ಸರ್ ದೇವದಾಸ್ ಸಾಹೇಬ್ರು ಬಂದಿದ್ರು. ಅದು ನಾನೇ ಒಬ್ರು ಅಡ್ವೈಸರಿ ಬೋರ್ಡ್ ಮೆಂಬರ್ ಇದ್ದೀನಿ, ಅದಕ್ಕೆ ನನ್ನ ಹತ್ರ ಬೇಡ ಅಂತೇಳಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ರು. ಯಾಕಂದ್ರೆ ಅವರೇ ಒಬ್ಬರು ಅಡ್ವೈಸರಿ ಬೋರ್ಡ್ ಕಮಿಟಿ ಮೆಂಬರ್ ಇದಾರಲ್ಲ. ಸೊ ಇದು ನನ್ನ ಹತ್ರ ಬೇಡ, ಅದಕ್ಕೂ ಅವರು ಇಟ್ ಮೇ ಬಿ ಮೇಡ್ ಓವರ್ ಟು ಅನದರ್ ಕೋರ್ಟ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಸೊ ದಟ್ ಗ್ರೌಂಡ್ Chief Justice was passed an order to place before another bench.
Madam.
Now, you amend it. Immediately, we'll give you permission, you amend it. You take your stand on the merits. ಒಂದ್ ವರ್ಷ ಅಲ್ಲೇ ಆಗ್ತಾ ಬಂದಿದೆ. Suppose ಸರಿಯೋ, ಅದು ಬೇರೆ ಪ್ರಶ್ನೆ. But now it's April 24, isn't it? So it's already, we have crossed.
More than 9 months, about 9 months.
You get instruction, let us know. Now that judgment that I passed.
Yes.
Have a look at that order. ಅದು ಕೊಡಿ ಅವ್ರಿಗೆ ಒಂದು ಅದನ್ನ. I've considered in detail, public order, law and order, etc. Detailed, I've considered and set aside the detention order of this bench.
But in the ground, my lord, there is no any ground is made out in this present case, except saying that, my lord, 8 cases is there, 5 cases acquitted. There is no allegation against the respondent. This rule is not followed, not consider the representation, nothing, no grounds. Pardon me.
What is the charge against him in those 8 cases?
The 8 cases, my lord, that is, my lord, one, my lord, threatening to the public and, my lord, attempt to, least also punished.
Whether it comes on within the ambit of public order?
Yes, but that is not observed in the. Even least also, my lord, what is the stage also I produced along with the memo. One is 307, my lord.
You carry out the amendment, then you file your objection. We'll have it on Tuesday or Wednesday. Old matter.
But on the, my lord, writ petition, my lord, it is not maintainable.
No, correct.
Because, my lord, he has to.
ಅಲ್ಲ convert ಮಾಡ್ಸನೆ ಇವಾಗ ಅವರು ಪಾಪ withdraw ಮಾಡಿ
No, the,
8 ತಿಂಗಳಾದ್ಮೇಲೆ
on 30th/4/2024 detention order clear cut ತೊಗೊಂಡಿದ್ದಾರೆ sir.
ಅಲ್ಲ ಸರಿ.
Totally 8 cases were ಅಂತ ತೊಗೊಂಡಿದ್ದಾರೆ.
No.
ಇಲ್ಲ ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ ಬಂದಿದ್ದು ತೊಗೊಂಡಿದ್ದಾರೆ ಸರ್.
Now you convert this into a writ of habeas corpus. You file a memo.
Yes, ma'am.
We'll permit you to convert it into a writ of habeas corpus.
Yes, ma'am.
You file a memo.
Yes.
Seeking for conversion of the present to a writ of habeas corpus.
Yes, ma'am.
Because it will have to be renumbered by the registry. Memo filed. The counsel for the appellant submits, the petitioner submits that the petitioner may be petitioner may be permitted to include the prayer for issuance of writ of habeas corpus. Taking note that the matter relates to preventive detention and has been filed on 24th July 2024. In the ends of justice, it would be appropriate to permit the petitioner to include the prayer for issuance of writ of habeas corpus. In light of the memo filed, registry is directed to convert the present writ petition into a writ for habeas, issuance of writ of habeas corpus with the necessary change in classification. For statistical purpose, the present petition is disposed of. Office to renumber the petition and list the matter on next Wednesday. You take your stand.
Please.
ಅದು ನಂಬರ್ ಅವ್ರು ಕೊಡ್ತೀರಿ ಅದು ಆರ್ಡರ್. You just have a look at that order.
Yes, ma'am.
ಇವಾಗ ಫೈನಲಿ ಮೆರಿಟ್ಸ್ ಅಲ್ಲಿ ನೋಡೋಣ. ಕೇಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ, ಆಲೆ ನಿಮ್ ಪರ್ಪಸ್ ಸರ್ವ್ ಆಗಿದೆ. ಬಟ್ ಯು ಟೇಕ್ ಯರ್ ಸ್ಟ್ಯಾಂಡ್, ಲೆಟ್ಸ್ ಎಕ್ಸಾಮಿನ್.
31 Maruti S.
31 minutes, I prepare the minutes, petitioner minutes. That's the applicant minutes presently work as a order minutes. That's the honorable minutes, Karnataka Administrative minutes, Kalaburagi bench must dismiss the minutes, application filed by the minutes, petitioner at another A1 minutes. But this is a case where minutes, kindly take minutes, that's annexure A6 page number 78, my lords. Plus the minutes, promotion of the applicant was minutes withdrawn. After minutes granting minutes, without any reason minutes, only the intent to minutes initiate department inquiry proceedings. And that ground minutes, the promotion applicant has been withdrawn. And but this is case minutes squarely applicable to minutes, Janikaraman and Anil Sarkar case minutes. The honorable minutes tribunal has not considered that aspect of the matter minutes to dismiss the application of the applicant. On that ground minutes, I have filed the present petition before this honorable court minutes. And a similar situation minutes, one of the person who is also order minutes, who is also involved in these cases minutes, the honorable minutes, High Court of Karnataka Bangalore bench minutes allowed the minutes petition filed by the one Ramanna, who is also same situation person minutes. I will file judgment along with memo last occasion minutes.
You have filed.
Yes, my lords, already filed, my lords. Along with memo, I will file, my lords. The writ petition number, my lords, 19407 of 2023, my lords. The same issue is already considered by the, my lords, Honorable Principal Bench, Karnataka High Court, my lords.
No, what is the point?
Point is, my lords, kindly see, my lords, page number 78.
78,
Page number 78, my writ petition, my lords.
yes.
Otherly, my lords, page number 2 may be permitted to read, my lords.
Annexure A6.
Another ESC page number 78, my lords. Otherly, para 2 may kindly, my lords, permitted to read, my lords. ಬಳ್ಳಾರಿ ಕೇಂದ್ರ ಕಾರಾಗೃಹದಲ್ಲಿ ವೀಕ್ಷಕರಾಗಿ ಕರ್ತವ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಅವಧಿಯಲ್ಲಿ ಶಿಕ್ಷಾಬಂದಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಯೂಸುಫ್ ಬಚ್ಚಾಖಾನಿತನು ಕಾರಾಗೃಹದಿಂದ ಮೊಬೈಲ್ ಮೂಲಕ ಮುಂಬೈ ವ್ಯಕ್ತಿಯೊಬ್ಬನಿಗೆ ಬೆದರಿಕೆ ಒಡ್ಡಿದ ಪ್ರಕರಣದಲ್ಲಿ ಸದರಿಯವರ ಕರ್ತವ್ಯಗಿರುವ ಕುರಿತು ಶಿಸ್ತುಗಳನ್ನು ಜರುಗಿಸಲು ಉದ್ದೇಶಿಸಲಾಗಿರುತ್ತದೆ. On this ground, my promotion has been withdrawn. They are not issued any article charges. They are not kept under suspension. There is no notice also, and only to intend inquiry against me, my promotion has been withdrawn. Subsequently, after granting my promotion, they issued article with a subsequent date. My contention is, as on the date of promotion, DPC, there is no charge sheet, there is no notice also against me,
When was the DPC proceedings?
Yes, DPC proceedings, and 12/4/2022, promotion has been granted. That earlier, the DPC has been done,
From order of promotion 12/4/22.
Yes, sorry, 38/2022, 38/2022.
30th of August 22.
22 promotion,
DPC?
DPC earlier date, as per annexure A3, 12/4/2022.
Annexure A?
Annexure A3, circular.
As on the date of DPC, there was no inquiry against.
No, kindly say they are filed replace statement along with article of charges. That is on article of charges issued me, on annexure R4, that is on page number
141.
Please, annexure R4, 141. The date 24/11/2022.
No, this is the show cause date.
Yes, along with that, charges are issued. ಅನುಬಂಧ 1-2 ಜೊತೆಗಿದೆ ಸ್ವಾಮಿ.
Articles of charges.
Yes, my lords.
24/12/22.
24/11/2022, my lords.
Now the order withdrawing your promotion is passed on?
Passed on as per under A6, my lords, dated 26/9/2022.
So you are saying that it cannot be done
Yes.
as on the date of DPC and order of promotion if there is no articles of charges that cannot
Yes, my
be
lords.
withdrawn.
Yes, that issue are already considered, my lords, in my lords, writ petition number 19407 of 2023. 19407 of 2023. Memo hakidin, Swami. Same person also involved in this case also, my lords.
When did he escape from the jail?
My lords, that I don't know, my lords. That's earlier issue, my lords.
Alla charge alli.
Charge ಇದೆ ಸ್ವಾಮಿ, charge ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
Just have a look at it.
Please, my lords. ಎಸ್ಕೇಪ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವನು ಬೆದರಿಕೆ ಒಡ್ಡಿದ್ದ ಅಂತ, ಇನ್ನೊಬ್ಬರಿಗೆ ಫೋನ್ ಅಲ್ಲಿ ಬೆದರಿಕೆ ಒಡ್ಡಿದ್ದ ಅಂತ ಸ್ವಾಮಿ.
What is the date of incident?
Please, my lords.
31/1/21 ರಿಂದ 7/6/21. Between this period, he with phone call, he threatened the persons in Bombay.
Correct.
From
Correct. So when did you come to know about it?
My lord, it is earlier to the DPC meeting. My lord, as per, my lord, I request your lordship to, the impugned order here in at page number 38. It was discussed.
Page number
Page number 38, internal page 26.
Correct, but in your DPC, should you not have taken note of this?
My lord, here it was between the two, my lord, officers, the Director General and additional. There was correspondences on as many as 41 officers. There is a, my lord, directions to take, my lord, action for disciplinary
No, correct, we are on the point.
departmental inquiry.
Page 30.
38 ಅಲ್ಲಿ. The point to be noted, first starting in that the Deputy Inspector General of Prisons submitted his report on 4/3/22. It is much earlier to the DPC meeting.
The only report.
To respond number 2, and the respond number 1 made recommendations to the government to initiate disciplinary proceedings against 41 officers and staff, including the applicant, on so and so, so and so.
On 17/8/22.
Please, my lord. The promotion is on 30th/8/22.
No, no.
The,
but,
the proceedings
correct,
were,
okay, technically,
my lord,
under the KCSR rules,
on the date of promotion.
the articles of charge is the date for commencement of the proceedings. Articles of charge, when you frame the charge, is the date for commencement of the proceedings. If you have not initiated proceeding.
But the prima facie, my lord, there is a, my lord, they have, letter was issued for taking this.
Correct, but then you should have taken note in the DPC. If it's not taken note in the DPC, if there's no article of charge framed, technically is out. No doubt, you are at liberty to take action and
Yes,
promote him later. That's a different matter. That he can also not protest.
After concluding.
At the same point, my lords, one Brahman earlier memo, I will produce, same person also involved in this case.
That order we don't have. You have
I will
produced
file
it.
along with memo last occasion, my lords.
So that's not there in the record. Adilwa adu? Which is that citation? Let us see.
19407 of 2023, my lords.
WP number?
WP number 19407/2023.
ನಮಗೆ ಸರ್ವ್ ಮಾಡಿದರೆ ಕಾಪಿ ಇದೆ.
ಇದೆಯಾ? ಕೊಡಿ ಅದನ್ನ ನೋಡೋಣ.
Our person, my lords, involved in this case.
He is promoted.
He is promoted now, my lords. His application also dismissed. He has filed writ petition before the Honorable High Court Karnataka Principal Bench. The said issue considered, my lords, at para, my lords, 8 and 9. 9 will consider ಮಾಡಿದ್ದಾರೆ sir.
Now he was one of the 41
Yes,
officials.
yes, my lords. Yes, my lords.
Okay, you read that paragraph.
My lords, para 9, can I read, my lords? Page 6 only. We have considered the contention advanced to
Just
either
one
side.
minute.
It is admitted
one
that, my lords,
Just 1 minute. You read from para 5.
it is submitted that, my lords, it was on 38/2022, the juniors of the petitioners was promoted as evidenced by the Annex A5. It is submitted that the representation preferred by the petitioner as well as the publication before the tribunal have been rejected without considering the contention raised in items of the legal provisions. Para 6 must learned AGF for the respondent submits that a detailed statement of objections have been placed on record in this writ petition. It is stated herein that the Director General of Prisons and Correctional Services had directed the Deputy Inspector General of Prisons, North Range, Belagavi, by letter dated 31/1/2022 to carry out the details inquiry and submit a report with regard to the allegations against the prison staff, including the petitioner, had failed to prevent the use of the mobile phones by prison during the period from 31/1/2021 to 7/6/2021. Para 7, my lords, it is submitted that as per these directions, the Deputy Director General of Prisons, North Range, had conducted the preliminary inquiry and submitted his report on 4/3/2022. As per the report, it is evident that the petitioner had exhibited negligence in the carrying out his duties, and since the allegations leveled against the petitioner were grave in nature, it was intended to being in disciplinary proceedings against 41 prison officers and staff, including the petitioners, and the recommendations were made to the government to initiate the same office letter dated 75/2022. It is submitted that thereafter disciplinary proceedings were also initiated against the petitioners, and that charge memo had been issued on 24/11/2022. This is also same, my lords.
Now, was it a joint inquiry or separate?
No, my lord, separate charge memo issued against all of them, my lords. Same date to separate charge, my lords.
Yes.
Subsequently, my lords, para 8 months, the learned counsel of the petitioner has placed a reliance on the judgment of co-equal bench of this court in report number so and so, wherein it has been held as under. My lords, the Janakaram case has been retreated here, my lords. And subsequent page number 9, para 9 may be consideration, my lords. Consideration para 9, Swami. We have considered the contentions advanced on either side. It has admitted that the petitioner was within the zone of the consideration for promotion to the post of head order. It is not disputed that DPC postings was held on 26/2022. It is contended that the learned AGA that has on the date of convening the DPC proceedings has also that date for the promotion of junior officers. There was a prima facie case made out against the petitioners for conducting disciplinary inquiry. That disciplinary inquiry was later dated initiated on 24/11/2022. We noticed that as on the date of convening the DPC proceedings, there was no charge memo issued against the petitioners and no disciplinary proceedings were pending as against him. In the above factual situation, we are the opinion that the contemplation of disciplinary proceedings as alleged in the reply statement cannot be ground to decline promotions. In view of the fact that as of the date of convening DPC postings and the date of promotions granted to the juniors, there were no disciplinary postings against the petitioner. We are of the opinion that the petitioner was entitled to succeed the application.
Only on the only ground.
Same only.
As on the date of the DP.
Date of promotion.
Date of promotion order.
There is no charge sheet and charge number.
They were framed subsequently, that is not a bar.
Please.
So this on parity, same it will have to be allowed. You just read para 8 for a minute.
This
that
order.
extraction of Janki Ram's case.
Please.
My request was this order shall not come in the way of their inquiry, departmental inquiry, which is going to be.
Yes, yes, please, that will clarify.
Please.
Just read that extraction from Janki
Please.
Ram's case.
Please, minutes. Para 8 minutes, page number 5. As rightly conveyed that learned counsel for the petitioner as perusal of the state government circular dated 14/7/1993 will indicate that the procedure of maintaining the sealed court and refusing promotion can be adopted by respondent only in case where charge sheet has already been filed or article of charges has already been issued as against the alleged delinquent official as on the date of DPC meeting. In this case on hand, the material on record indicate that as on the date of DPC meeting, which was held on 20/12/2021, neither charge sheet had been filed nor article of charges had been issued to the petitioner. And the charge sheet was filed subsequently on 1/2/2022. Under these circumstances, there was no warrant on the petitioner to adopt a sealed court procedure and deny promotion to the petitioner in its meeting held on 20/12/2021, particularly in the absence of either the article of charges being issued or the charge sheet being filed against the petitioner. The learned counsel for the petitioner is also correct in this submission that the impugned order passed by the tribunal is contrary to the judgments of apex court KV Janakaraman's in case and in Anil Kumar Sarkar's Supra, and on this ground also the impugned order passed by tribunal adverse to be set aside and the application filed by the petitioner diverse to be allowed.
Now just take us through the relevant paragraphs in the order of the tribunal.
Please, my lords.
Reasoning part.
Reasoning part, my lords.
Para number 9.
Para 9.
9.
Para 9.
Read.
We have considered the contentions advanced on the either side in the it's appeared that the petition was within the zone of consideration for promotion to post of head order.
No, you are reading at page.
In which judgment, minutes? KT judgment, minutes.
KT judgment.
KT judgmental minutes reasoning para minutes is the last para 20 page number 26 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ.
Page
26 ಅಲ್ಲಿ there minutes
discussion starts from 9. 11 is the my lord with reference to the State Bank of India.
Where does it
Patiala.
Read the discussion. We want to see the discussion.
Para 11 ಅಲ್ಲಿ ಇದೆ madam, 9, 10, 11, but 11 is relevant.
Para 11.
Yes, ma'am.
Para 9 ಅಲ್ಲಿ. Starts from para 9. Para 9 ಇಂದ ಓದ್ಬೇಕು.
ಹೌದು 9 ಇಂದ ಇದೆ ಸ್ವಾಮಿ actually.
ಓದಿ.
May I read, my lord?
Yes.
Please. In another decision of the Honorable Apex Court rendered in case of Union of India versus Cable Kumar, reported in air so, wherein their lordships have ruled that date of commencement of disciplinary proceedings is from the date when the department took a decision to initiate action against the delinquent employee by way of filing a criminal complaint, FIR, and also by issuance of articles of charge. Their lordship observed in the said decision that when the department, after applying its mind, so far as the allegations against DGO, took a decision to initiate disciplinary inquiry proceedings for imposing major penalty from that date itself, it can be said that disciplinary inquiry proceedings are initiated. It is also observed by their lordships that when the FIR is also registered or there is a sanction for the prosecution from that date itself, the disciplinary inquiry is said to have been initiated. Though actual issuance of articles of charges may be at subsequent dates, it is the observation of their lordship that the department itself is important and the subsequent acts of issuance of article charges is only ministerial act. In this connection, para 3, 4, 5, 6 of the said decision are relevant for our purpose and they are read as under. All those paras are my lord extracted. And thereafter, as per the above rules, I will straight away come to page number 33, my lord, after those observations of the Supreme Court. As per the above rules, the government employee is deemed to be officiating in the promoted post from the date of his joining in the promoted post. In the instant case, the promotion order was reverted before the applicant joined in his promoted post as head warder. An order passed by the competent authority in violation of rules, regulations, statutory provisions governing the service issues of the employees cannot be set aside automatically, whether such provision is violative of a substantive nature or whether it is procedural in character has to be ascertained. It has to be ascertained whether such violation is in the interest of the employee or in public interest. The ultimate test is the test of prejudice. In accordance with the rule audi alteram partem, the authority should take proceedings as per the procedure and whether the employee.
Tomorrow, I'll dictate it tomorrow.
Please, madam.
Have a look at it.
Please, madam.
But now, prima facie.
When the order is passed by this, my lord, I think it was not brought to the, anyhow order is there, I leave to this honorable court.
Okay, relying on para 25. Come to para 25.
Please. Page 25. Howದು para 11 ಅಲ್ಲಿ ಅದರಲ್ಲೂ ಡಿಸ್ಕಸ್ ಇದೆ.
Events.
Subsequent, yes, madam.
The date of FIR, report by the DCP and all, 31/1/2022 and 4/3/22. Before the DPC.
Before the DPC, my lord, correspondence, ministerial acts are going on. The decision was taken by the government to initiate the, my lord, inquiry against 41 officers.
Negligent act committed by the applicant before DPC itself.
Yes, my lord.
So report also secured by that.
Yes, my lord. January 21 ರಿಂದ June 21 ವರೆಗೆ he allowed, my lord, he was the, my lord, key person wherein this man was Suleiman.
Who has issued that report? DIG, yeah? DIG of prison. DIG of prison. Where is those reports and?
My lord, I will. A report ಇಲ್ಲ ಇದರಲ್ಲಿ ಬಂದಿದೆ. ಅದೇ
Tomorrow.
Please.
KCSR ಅಲ್ಲಿ there is that rule which says that the date of framing of the articles of charge is the date to be taken when a formal inquiry is commenced.
Yes.
So if no formal inquiry is commenced as on that date, technically there is no bar which the coordinate bench. Tomorrow.
Please, madam.
ಅದು ಮೇಲ್ ಬರಲಿ, mail ಬರಲಿ. Anyone parity, right or wrong? Parity. Then orders listener, the admission, mail per. The admission is the. Oh.
Till number 40.
Just show, till number 40, please.
Yes, 173, 40.2. Yes, my lord. It's PW5 is evidence, my lord. It's page 194. Is a eyewitness to the incident, my lord. His sole eyewitness along with PW6. Narayan, my lord. ನನ್ನ ತಾಯಿ ನೀಲವಳ ತವರ ಮನೆ ಕಂಬಾಗಿ ಗ್ರಾಮ ಇದೆ. ನನ್ನ ತಾಯಿ ನೀಲವಳ ಅಕ್ಕನ ಹೆಸರು ಭಾಗವ. ನನ್ನ ದೊಡ್ಡಮ್ಮ ಭಾಗವನಿಗೆ ಗುಣದಾಳ ಗ್ರಾಮದ ಸೈದಪ್ಪ ತಮ್ಮಣ್ಣ ದಳವಾಯಿ ಇವರಿಗೆ ಮದುವೆ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. ಭಾಗವ ಮತ್ತು ಸೈದಪ್ಪನಿಗೆ ಬಸಪ್ಪ ಹೆಸರಿನ ಮಗನು ಇದ್ದಾನೆ. ಕಂಬಾಗಿಯ ನಾಗವಳಿಗೆ ಕಂಬಾಗಿ ಗ್ರಾಮದ ಹನುಮಂತ್ ಕುಮಟ್ಗಿ ಇವರಿಗೆ ಮದುವೆ ಮಾಡಿ ಕೊಡಲಾಗಿದೆ. ನಾಗವಳ ಗಂಡ ಹನುಮಂತ ಇಬ್ಬರು ಹೆಂಡತಿಯರು. ಹನುಮಂತನ ಮೊದಲನೇ ಹೆಂಡತಿ ಕಂಬಾಗಿಯ ನಾಗವ್ವ. ಹನುಮಂತನ ಎರಡನೇ ಹೆಂಡತಿ ಕಲಬಿಳಗಿ ಗ್ರಾಮದ ನಾಗವ್ವ ಇದ್ದಾಳೆ. ಹನುಮಂತನ ಮೊದಲೇ yes notes.
Complaint. Just come to ದಿನಾಂಕ 5 next page.
Yes notes. ದಿನಾಂಕ 5.
Rest of the things are
introduction notes, please. ದಿನಾಂಕ 5/1/2014 ಮೃತ ಬಸಪ್ಪ, ಆತನ ಹೆಂಡತಿ ರಂಗವ್ವ ಮತ್ತು ಅವರ ಮೊಮ್ಮಕ್ಕಳಾದ ಕಲ್ಮೇಶ್ ಹಾಗೂ ಪೂಜಾ ಕೂಡಿ ಹನುಮಗೇರಿ ಗ್ರಾಮದಲ್ಲಿನ ತನ್ನ ಮಗಳು ದಾನವಳ ಮನೆಗೆ ಹೋಗಿದ್ದರು. ದಿನಾಂಕ 7/1/2014 ಇವರು ಹನುಮಗೇರಿ ಗ್ರಾಮದ ದಾನವಳ ಮನೆಯಿಂದ ವಾಪಸ್ ಬಂದರು. ಈ ರೀತಿ ಬಸಪ್ಪ, ಆತನ ಹೆಂಡತಿ ರಂಗವ್ವ ಹಾಗೂ ಮೊಮ್ಮಕ್ಕಳಾದ ಕಲ್ಮೇಶ್ ಮತ್ತು ಪೂಜಾಳೊಂದಿಗೆ ಹನುಮಗೇರಿಯಿಂದ ಬರುವಾಗ ದೊಡ್ಡ ಗಲಗಲಿ ಗ್ರಾಮದಲ್ಲಿ ನನಗೆ ಕಿರಾಣಿ ಅಂಗಡಿ ಮುಂದೆ ಭೇಟಿ ಆಗಿದ್ದರು. ಆಗ ಮಧ್ಯಾಹ್ನ 3 ಗಂಟೆ ಸಮಯ ಆಗಿತ್ತು. ಬಸಪ್ಪ ಮತ್ತು ರಂಗವ್ವ ನನಗೆ ಊರಿಗೆ ಬರುವಿರೋ ಎಂದು ಕೇಳಿದಾಗ, ನೀವು ಮುಂದೆ ಹೊರಡಿರಿ, ನನಗೆ ಸ್ವಲ್ಪ ಕೆಲಸ ಇದೆ, ಕೆಲಸ ಮುಗಿಸ್ಕೊಂಡು ಬರುತ್ತೇನೆಂದೇ ಅವರಿಗೆ ಹೇಳಿದೆನು. ಬಸಪ್ಪ, ರಂಗವ್ವ ಮೊಮ್ಮಕ್ಕಳ ಸಮೇತ ಗುಣದಾಳ ಕಡೆ ಹೊರಟರು. ಅವರು ಹೊರಟು ಹೋದ 10 ನಿಮಿಷದ ನಂತರ ನಾವು ಸಹಿತ ಹೊರಟೆವು. ಬಸಪ್ಪ, ರಂಗವ್ವ, ಅವರ ಮೊಮ್ಮಕ್ಕಳಾದ ಕಲ್ಮೇಶ್ ಮತ್ತು ಪೂಜಾ ಹನುಮಗೇರಿ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಹೋದವರು ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ವಾಪಸ್ ಹೊರಟಿದ್ದರು. ನಾನು ಸಹ ದೊಡ್ಡ ಗಲಗಲಿಯಿಂದ ಒಂದು ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಕಂಬಾಗಿ ವಾಪಸ್ ಹೊರಟಿದ್ದೆ. ನಾನು ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಈ ರೀತಿ ಹೋಗುತ್ತಿರುವಾಗ ಚಿಕ್ಕಗಲಗಲಿ ಕ್ರಾಸ್ ಹತ್ತಿರ ಒಂದು ಕ್ರೂಸರ್ ಜೀಪ್ ಒಂದು ಮೋಟಾರ್ ಸೈಕಲ್ ಅನ್ನು ಹಿಂದೆ ಹಾಕಿ ಮುಂದೆ ಹೋಯಿತು. ಆ ಕ್ರೂಸರ್ ಜೀಪಿನಲ್ಲಿ 1ನೇ ಆರೋಪಿ ಮಾಳಪ್ಪ, 2ನೇ ಆರೋಪಿ ಪರಮಾನಂದ, 4ನೇ ಆರೋಪಿ ಕೃಷ್ಣಪ್ಪ ಇದ್ದರು. ಈ ಕ್ರೂಸರ್ ಜೀಪಿನ ಹಿಂದುಗಡೆ ಒಂದು ಮೋಟಾರ್ ಸೈಕಲ್ ಸಹ ಬಂತು. ಆ ಮೋಟಾರ್ ಸೈಕಲ್ ಅನ್ನು 3ನೇ ಆರೋಪಿ ಮುರಪ್ಪ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದನು. ಹಾಗೂ ಮೋಟಾರ್ ಸೈಕಲ್ ಹಿಂಬದಿ ಸವಾರನಾಗಿ 5ನೇ ಆರೋಪಿ ರೌಂಡ್ ಸಿದ್ದಪ್ಪ ಪ್ರಯಾಣಿಸುತ್ತಿದ್ದನು. ಸದರಿ ಮೋಟಾರ್ ಸೈಕಲ್ ಸಹ ನನ್ನ ಮೋಟಾರ್ ಸೈಕಲ್ ಹಿಂದಕ್ಕೆ ಹಾಕಿ ಕ್ರೂಸರ್ ಜೀಪ್ ಹಿಂದೆ ಹೊರಟಿತ್ತು. ನಾನು ಕ್ರೂಸರ್ ಜೀಪ್ ಹಾಗೂ ಮುರಪ್ಪ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಹೊರಟಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ ಹಿಂದಗಡೆ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಹೊರಟಿದ್ದೆ. ಕ್ರೂಸರ್ ಜೀಪ್ ಅನ್ನು ಬಸಪ್ಪ ದಳವಾಯಿ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಹೊರಟಿದ್ದ. ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಹಾಯಿಸಿದರು. ಆಗ ಬಸಪ್ಪ, ರಂಗವ್ವ, ಕಲ್ಮೇಶ್, ಪೂಜಾ ಮೋಟಾರ್ ಸೈಕಲ್ ಸಮೇತ ಕೆಳಗೆ ಬಿದ್ದರು. ಆಗ ಕ್ರೂಸರ್ ಜೀಪ್ ಮತ್ತು ಮುರಪ್ಪ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ ನ ನಿಲ್ಲಿಸಿದರು. ಆಗ 2ನೇ ಆರೋಪಿ ಪರಮಾನಂದ ಕ್ರೂಸರ್ ಜೀಪಿಂದ ಇಳಿದನು. ಮಾಳಪ್ಪನು ಇಳಿದನು. 1ನೇ ಆರೋಪಿ ಮಾಳಪ್ಪನು ಜಾಲಿ ಬಡಿಗೆಯಿಂದ ಬಸಪ್ಪನಿಗೆ ಹೊಡೆಯ ಹತ್ತಿದನು. 4ನೇ ಆರೋಪಿ ಕೃಷ್ಣಪ್ಪ ಕಬ್ಬಿಣದ ರಾಡಿಂದ ರಂಗವಳಿಗೆ ಹೊಡೆಯ ಹತ್ತಿದನು. 3ನೇ ಆರೋಪಿ ಮುರಪ್ಪ ಜೀಪಿನ ಹಿಂದಿನ ಬಾಗಿಲನ್ನು ತೆಗೆದು ಅದರಲ್ಲಿದ್ದ ಸೀಸದ ಗುಂಡನ್ನು ತೆಗೆದುಕೊಂಡು ಬಸಪ್ಪ ಮತ್ತು ರಂಗವಳಿಗೆ ಹೊಡೆಯ ಹತ್ತಿದನು. ಕಲ್ಮೇಶ್ ಮತ್ತು ಪೂಜಾ ಚೀರಾಡುತ್ತಾ ಓಡುತ್ತಾ ಹೋಗಿ ಹತ್ತಿರದಲ್ಲಿದ್ದ ಮುಳ್ಳು ಕಂಟಿಗಳಲ್ಲಿ ಅವಿತುಕೊಂಡಳು. ನಾನು ಹೆದರಿಕೆಯಿಂದ ಈ ಘಟನೆ ಜಾಗದಿಂದ 115 ಫೂಟ್ ದೂರದಿಂದ ನೋಡುತ್ತಿದ್ದೆನು. ರಂಗವ್ವ ಸ್ಥಳದಲ್ಲಿಯೇ ಮೃತಳಾದಳು. 5ನೇ ಆರೋಪಿ ರೋಣಿಸಿದ್ದನು ಬಸಪ್ಪನ ಕಾಲುಗಳನ್ನು ಹಿಡಿದುಕೊಂಡಾಗ ಪರಮಾನಂದ ಕ್ರೂಸರ್ ಜೀಪನ್ನು ಬಸಪ್ಪನ ತಲೆಯ ಮೇಲೆ ಚಾಲನೆ ಮಾಡಿ ಹಿಂದಿನ ಗಾಲಿಯನ್ನು ಬಸಪ್ಪನ ತಲೆ ಮೇಲೆ ಹಾಯಿಸಿದರು. ಆಗ ಬಸಪ್ಪನ ಮೃತನಾದನು. ಅದೇ ಜೀಪಿನಲ್ಲಿ ಆರೋಪಿ 1 ಮಾಳಪ್ಪ, ಆರೋಪಿ 4 ಕೃಷ್ಣಪ್ಪ ಹಾಗೂ ಆರೋಪಿ 2 ಪರಮಾನಂದ ಜೀಪ್ ತೆಗೆದುಕೊಂಡು ಹೊರಟರು. ಆ ವೇಳೆಗೆ 3ನೇ ಆರೋಪಿ ಮುರಪ್ಪ ತಾನು ನಡೆಸಿಕೊಂಡು ಬಂದಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ ಅನ್ನು 5ನೇ ಆರೋಪಿ ರೋಣಿಸಿದ್ದಪ್ಪನಿಗೆ ಕೂಡಿಸಿಕೊಂಡು ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಹೋದರು. ನಂದಿ ಫ್ಯಾಕ್ಟರಿ ಕಡೆ ಹೋದರು. ಆಗ ಸಾಯಂಕಾಲ 4 ಗಂಟೆ ಸಮಯ ಆಗಿತ್ತು. ನಾನು ಕಲ್ಮೇಶ್ ಮತ್ತು ಪೂಜಾರನ್ನು ಹುಡುಕಿಕೊಂಡು ಹೋಗಿ ನೋಡಲಾಗಿ ಕಲ್ಮೇಶ್ ಬಲಕೆನೆಯ ಮತ್ತು ಮೆಲಕಿನ ಮೇಲೆ ರಕ್ತ ಗಾಯ ಆಗಿತ್ತು. ಸ್ವಲ್ಪ ಹೊತ್ತಿನಲ್ಲೇ 2ನೇ ಆರೋಪಿ ಪರಮಾನಂದ ಬೇರೆ ಪಿಕಪ್ ವಾಹನವನ್ನು ತಂದು ರಂಗವ್ವ ಮತ್ತು ಬಸಪ್ಪ ಮೃತರಾದ ಜಾಗೆ ಹತ್ತಿರ ಬಿಟ್ಟು ಹೋದನು. ಕಲ್ಮೇಶ್ ಫೋನ್ ಮುಖಾಂತರ ತನ್ನ ಮಾವ ತಮ್ಮಣ್ಣ PW1 ತಂದೆ ಬಸಪ್ಪ ದಳವಾಯಿ ಇವರಿಗೆ ಫೋನ್ ಮಾಡಿ ವಿಷಯ ತಿಳಿಸಿದನು. ಫೋನ್ ಮಾಡಿದ ನಂತರ PW1 ತಮ್ಮಣ್ಣ ದಳವಾಯಿ ಘಟನಾ ಸ್ಥಳಕ್ಕೆ ಬಂದನು. PW1 ತಮ್ಮಣ್ಣ ಬಂದ ನಂತರ CW12 ಮಲ್ಲೇಶಿ, ಶ್ರೀಶೈಲ್, ಸದಾಪ್ಗೋಳ್ ಬಂದು ಕಲ್ಮೇಶ್ ಮತ್ತು ಪೂಜಾರಿಗೆ ಗಲಗಲಿ ದವಾಖಾನೆಗೆ ತೆಗೆದುಕೊಂಡು ಹೋದರು. This is my lords, they are taken to the hospital. Now my lords, in the cross-examination itself, the first third lines, my lords, in page 200.
How old was Kalmesh at that point of time?
Pardon, my lord?
Kalmesh.
He was 8-year-old.
8 years.
Yes, my lords. And that Pooja is of 13-year-old. She was more aged than this Kalmesh. But however, she has been not examined. And MLC, actually, she has been taken to the hospital.
From whose mobile he called this?
That is also one of ground from the defense, my lord. He has taken the help of one tractor driver who was standing there. From the driver's phone, my lords, he called PW1. But tractor driver has been not examined, not even as a charge sheet witness, my lords. That is a missing link, my lords, of the prosecution case. He should have been examined, my lord, to say that he called the PW1, because PW5 also very much available on the spot, as he is a very close relative of the deceased family.
Who shifted this Kalmesh to hospital?
That is Srishail, and this, as per evidence of PW1 and this Srishail has shifted to the hospital, my lords. But doctor says it is only that Srishail who has not been examined. He has brought this guy.
The outpatient register, Shishal's name forthcoming.
Yes.
Not this man.
Not this man. That is what I'll establish in a cross-examination of the doctor. Doctor says it is only Srishail had come along with the Kalmesh. But PW1 and others says that due to his medical emergency, all went along with the Kalmesh. But where was he there about up to 10:30 minutes? That has been suppressed. Because he is also very close relative. According to my lords, my argument would be he is a planted eyewitness to the incident, because he was very much available on the spot. He has seen the entire incident, and he is elder to the Kalmesh. But however, he did not make any venture to call this PW1, neither the relations. Only that extent he was available. And the another.
But what is this one, column number 4 of in question? Yaru Akerige Kandavaru? Akerige Kandavaru yaru? Column number 4 of the in question.
63, 46 minutes. ಕಲ್ಮೇಶ್ ಅಂತ ಇದೆ. ಕಲ್ಮೇಶ ಸಿಂಧ್. ಅಂತಿಮ ಜೀವಂತವಿದ್ದಾಗ
ಏನಂತ ಇದೆ ಅದರಲ್ಲಿ ಕಾಲಮ್ ನಂಬರ್ 4 ಅಲ್ಲಿ
page 48 my lord, it is ಕಲ್ಮೇಶ್ ತಂದೆ ಬಸಪ್ಪ PW6. ಜೀವಂತ ಇದ್ದಾಗ ಅಂತಿಮವಾಗಿ ಕಂಡವರು ಯಾರು, ಎಲ್ಲಿ, ಯಾವಾಗ ಮತ್ತು ಯಾರ ಜೊತೆಯಲ್ಲಿ. Page 48.
ಎಕ್ಸಿಬಿಟ್ ಎಷ್ಟು?
That is my lords,
48,
P6 my lords.
Exhibit
P6 at page 46 it starts.
48
48 is, yes. ಕಂಡವರು ಕಲ್ಮೇಶ್ ತಂದೆ ಬಸಪ್ಪ ಕುಮ್ಮಟಗಿ ಈತನು 7/1/2014 4 ಗಂಟೆ ಸುಮಾರಿಗೆ ಇದರಲ್ಲಿ ಮೃತ ಬಸಪ್ಪ ಸೈದಪ್ಪ ದಳವಾಯಿ ರಂಗವ ಸೈದಪ್ಪ ದಳವಾಯಿ ಇವರೊಂದಿಗೆ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ತನ್ನ ಮಾವನ ಮಗಳು ಪೂಜಾ ವಯಸ್ಸು 12 ವರ್ಷದೊಂದಿಗೆ ಬರುತ್ತಿದ್ದಾನೆ.
Any mention of this PW5 in the company exhibit P1?
No.
By PW1?
No.
Not said.
Yes. And apart from this, the most important aspect of my lord to say that they have suppressed the genesis of the crime, my lords. The most strongest circumstances would be as per evidence of PW1, as per the evidence of PW5, as per evidence of PW7, my lords. This PW5 has informed my lords about the involvement of 8-5 because he was very much available on the spot. He immediately, my lord, when the PW1 had come to the place, my lord, after this Kalmesh called, my lords, PW5 informed the PW1 saying that AFI also, my lords, committed offense. In spite of that, my lords, in exhibit P1, he did not mention the name of AFI.
Yes.
Yes, my lords. My submission would be, my lords, as per evidence of PW1, 5, 7, all consistently stated, it is PW5 was very much available. He informed the PW1 about involvement of A5. In spite of that, he did not mention in exhibit P1, my lords. That is, my lords, one of, my lords, the ground we could make out to say that they have suppressed the genesis of crime because he was not available on the spot at all. He is a planted eyewitness to the incident, my lords. And page 200, lordship may kindly see that is a cross-examination part. I have marked few part, my lords.
Yes.
Page 200. Third line, my lords. ಮೃತ ಬಸಪ್ಪ ನನಗೆ ಸಂಬಂಧದಲ್ಲಿ ಅಣ್ಣನಾಗಬೇಕು. CW12 ಮಲ್ಲೇಶಿ ದಳವಾಯಿ ನನಗೆ ಸಂಬಂಧದಲ್ಲಿ ಅಣ್ಣನಾಗಬೇಕು. PW1 ತಮ್ಮಣ್ಣ ಸಂಬಂಧದಲ್ಲಿ ಮಗನಾಗಬೇಕು. Admittedly, is very close relation of the deceased. He was very much available on the spot. He did not make any venture of registering the case. My lords, that is, my lords. And page 206, my lord.
That itself may not be a ground to discard. the
Definitely, my lords.
evidence.
Some, it is one of strongest circumstances we can doubt, my lords, because why this kid, my lords, he did not take the help of PW5. He went to some other person who was standing there, tractor driver, took the phone of him, my lords, he called it. But this fellow did not do any efforts, my lords. It has to be looked into, coupled with, my lords, not mentioning the name of AFI in the exhibit P1.
What is the omission and contradiction
Please.
in the evidence?
exhibit D2 to D6, my lords, at
How many
page 203, my lords.
D2, D2 to D6, huh?
Yes, page
ಎಲ್ಲಿದೆ?
page 203, my lords. ಸೆಕೆಂಡ್ ಲೈನ್, ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆ ಕೊಡುವಾಗ ನನ್ನ ಹೇಳಿಕೆಯಲ್ಲಿ ಇರುವ ಈಗ ನನಗೆ ಓದಿ ಹೇಳಿದ ವಿಷಯದಂತೆ ಜೀಪ್ ಚಾಲಕನು ಜೋರಾಗಿ ನಡೆಸಿಕೊಂಡು ಹೋದವನೇ ರಂಗವ ಮತ್ತು ಬಸಪ್ಪನ ಕುಳಿತು ಹೊರಟ ಮೋಟಾರ್ ಸೈಕಲ್ ಡಿಕ್ಕಿ ಹೊಡಿಸಿದನೆ ಎಂದು ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಲ್ಲ. ಈ ರೀತಿ ಇರುವ ನನ್ನ ಹೇಳಿಕೆಯಲ್ಲಿ ವಿಷಯ ಇರುವ ಭಾಗವನ್ನು D3 ಎಂದು ಗುರುತಿಸಲಾಯಿತು.
Next also there. Read that.
ಎಸ್ ಪ್ಲೀಸ್ ಮಿನಟ್ಸ್. ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆ ಕೊಡುವಾಗ 1ನೇ ಆರೋಪಿ ಜಾಲಿ ಬಡಿಗೆಯಿಂದ ಬಸಪ್ಪನಿಗೆ, 4ನೇ ಆರೋಪಿ ಕಬ್ಬಿಣದ ರಾಡಿಂದ ರಂಗವಳಿಗೆ, 3ನೇ ಆರೋಪಿ ಜೀಪಿನ ಬಾಗಿಲು ತೆಗೆದು ಅದರಲ್ಲಿದ್ದ ಸೀಸದ ಗುಂಡ ತೆಗೆದುಕೊಂಡು ರಂಗವ ಮತ್ತು ಬಸಪ್ಪ ಇಬ್ಬರಿಗೆ ಹೊಡೆಯುತ್ತಿದ್ದನೆಂದು ಹೇಳಿಲ್ಲ ಎಂದರೆ ನಿಜವಲ್ಲ. ಈ ರೀತಿ ಹೊಡೆಯುತ್ತಿರುವಾಗ ಕಲ್ಮೇಶ್ ಮತ್ತು ಪೂಜಾ ಓಡಿ ಹೋಗಿ ಮುಳ್ಳು ಕಂಟಿಯಲ್ಲಿ ಕುಳಿತರು ಎಂದು ಪೊಲೀಸರ ಮುಂದೆ ಹೇಳಿಲ್ಲ ಎಂದರೆ ನಿಜವಲ್ಲ. ಹೇಳಿಕೆ ಕೊಡುವಾಗ ನಾನು ಪೊಲೀಸರಿಗೆ ಕಂಟೆಯ ಮರೆಯಲ್ಲಿ ಹೋಗಿ ಕುಳಿತರು ಎಂದು ಹೇಳಿದ್ದೇನೋ, ಅಂದರೆ ಅಲ್ಲಿ ಮುಳ್ಳಿನ ಕಂಟೆಗಳು ಕುಳಿತಿದ್ದೆ ಎಂದು ಹೇಳಿದ್ದೇನೆ. ನಾನು ಪೊಲೀಸ್ ದಟ್ ಇಸ್ ಬುಷ್ ಮಲೋಟ್ಸ್, ಗ್ರೋನಿ ಬುಷ್ ವಿತ್ ಆಲ್ ದಟ್ ಸ್ಕ್ರಬ್ಸ್ ಮಲೋಟ್ಸ್. ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆ ಕೊಡುವಾಗ ಮುಳ್ಳಿನ ಕಂಟೆಯಲ್ಲಿ ಹೋಗಿ ಕುಳಿತರು ಎಂದು ಹೇಳಿಲ್ಲ ಎಂದರೆ ನಿಜವಲ್ಲ. ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆ ಕೊಡುವಾಗ ಅವರ ಮೊಮ್ಮಕ್ಕಳು ಅಂಜಿ ಓಡಿ ಮರೆಯಲ್ಲಿ ಹೋಗಿ ಕುಳಿತರು ಎಂದು ಹೇಳಿಲ್ಲ. ಈ ರೀತಿ ಇರುವ ನನ್ನ ಹೇಳಿಕೆಯಲ್ಲಿನ ವಿಷಯವನ್ನು D4 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಬಸಪ್ಪ ಮತ್ತು ರಂಗವಳಿಗೆ ಹೊಡೆಯುವುದನ್ನು ನಾನು 150 ಫೂಟ್ ದೂರದಿಂದ ನಿಂತು ನೋಡಿದೆನು ಅನ್ನುವ ವಿಷಯವನ್ನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಲ್ಲ ಎಂದರೆ ನಿಜವಲ್ಲ. ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆ ಕೊಡುವಾಗ ನಾನು ಭಯದಿಂದ ಅವರು ನನಗೂ ಸಹ ಕೊಲೆ ಮಾಡಬಹುದು ಅನ್ನುವ ಅಂಜಿಕೆಯಿಂದ ಅವರ ಸಮೀಪ ಹೋಗಿಲ್ಲ ಎಂದರೆ ಹೆದರಿ ಓಡಿ ಹೋದೆನು ಎಂದು ಹೇಳಿಲ್ಲ. ಈ ರೀತಿ ಇರುವ ನನ್ನ ಹೇಳಿಕೆಯನ್ನು ವಿಷಯವನ್ನು D5 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. 2ನೇ ಆರೋಪಿ ಜೀಪಿನ ಹಿಂದಿನ ಗಾಲಿಯನ್ನು ಬಸಪ್ಪನ ತಲೆ ಮೇಲೆ ಹಾಯಿಸಿದ್ದೇನೆ ಎಂದು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಲ್ಲ ಎಂದರೆ ನಿಜವಲ್ಲ. 2ನೇ ಆರೋಪಿ ಜೀಪ್ ಹಾಯಿಸಿದ ಎಂದು ಪೊಲೀಸರಿಗೆ ಹೇಳಿದ್ದೇನೆ. ಹಾಯಿಸಿದ ಮೇಲೆ ಆರೋಪಿ 1, 2, 4 ಅದೇ ಜೀಪ್ನಲ್ಲಿ ಹೋದರು ಎಂದು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ನಿಜವಲ್ಲ. ಅದೇ ರೀತಿ 3ನೇ ಆರೋಪಿ 5ನೇ ಆರೋಪಿಯನ್ನು ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಕೂಡಿಸಿಕೊಂಡು ನಂದಿ ಫ್ಯಾಕ್ಟರಿ ಕಡೆಗೆ ಹೋದರೆಂದು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ನಿಜವಲ್ಲ. ನಾನು ಕಲ್ಮೇಶ್ ಮತ್ತು ಪೂಜಾಳಿಗೆ ಹುಡುಕಿದೆನು ಹಾಗೂ ಕಲ್ಮೇಶಿನ ಮೂಗು ಬಲ ಮೆಲಕಿನ ಮೇಲೆ ರಕ್ತಗಾಯ ಆಗಿತ್ತು ಎಂದು ನಾವು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ನಿಜವಲ್ಲ. ಸ್ವಲ್ಪ ಹೊತ್ತಿನ ನಂತರ 2ನೇ ಆರೋಪಿ ವಾಹನವನ್ನು ತಂದು ಬಿಟ್ಟು ಹೋದರೆಂದು ಪೊಲೀಸರಿಗೆ ನಾನು ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ನಿಜವಲ್ಲ. ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆ ಕೊಡುವಾಗ ಪರಮಾನಂದ ಈತನು ಬಸಪ್ಪ ಮತ್ತು ರಂಗವ ಇವರಿಗೆ ವಾಹನ ಹಾಯ್ದು ಅಪಘಾತವಾಗಿ ಆಗಿದೆ ಅಂತ ಜನರು ತಿಳಿದುಕೊಳ್ಳಿ ಅನ್ನುವ ದೃಷ್ಟಿಯಿಂದ ಅನಂತರ ಮಹೇಂದ್ರ ಮ್ಯಾಕ್ಸ್ ವಾಹನ ಸೋ ಅನ್ನೋದನ್ನು ಸ್ಥಳದಲ್ಲಿ ಹಚ್ಚಿ ಓಡಿ ಹೋಗಿದ್ದಾನೆ ಅನ್ನುವ ಹೇಳಿ ಗೊತ್ತಾಯಿತು ಎಂದು ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಲ್ಲ. ಈ ರೀತಿ ಇರುವ ನನ್ನ ಹೇಳಿಕೆಯನ್ನು ವಿಷಯವನ್ನು D6 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಕಲ್ಮೇಶ್ ಫೋನ್ ಮಾಡಿ ತಮ್ಮಣ್ಣನಿಗೆ ವಿಷಯ ತಿಳಿಸಿದ ಅನ್ನುವ ವಿಷಯ ನಾನು ನಂತರ ತಮ್ಮಣ್ಣ, ಮಲೇಶಿ, ಶ್ರೀಶೈಲ್, ಸದಪ್ಗಳು ಬಂದು ಕಲ್ಮೇಶನೇ ದವಾಖಾನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋದರು ಅನ್ನುವ ವಿಷಯನೂ ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಲ್ಲ ಎಂದರೆ ನಿಜವಲ್ಲ. 2ನೇ ಆರೋಪಿ ಕ್ರೂಸರ್ ಜೀಪ್ ನಡೆಸುತ್ತ ಅನ್ನುವ ವಿಷಯನ ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಲ್ಲ ಎಂದರೆ ನಿಜವಲ್ಲ.
Have you confronted all these D series to IO?
Yes, not.
IO ಗೆ ಕೇಳಿದಿರಿ?
But not that extent. Somewhat, not in detail. Fully covered.
Not all these D series.
Not all this. Not all this.
Then it cannot be relied. That is the law. You have to confront with the IU.
12 is. ಎಲ್ಲ ಕೇಳಿಲ್ಲ.
Mere marking the statement, it's not sufficient. You have to confront to the IO.
Yes.
If IO admits that,
then it will
then
become
only it's admissible.
omission. Yes.
Right, next.
Yes, my lords. Then, my lords, page 207, my lords.
Yes.
Page 208, my lords,
Ah.
the cross examination itself.
Ah.
From the top, my lords, it is a 8th line, my lords. ಜೀಪ್ ಡಿಕ್ಕಿ ಹೊಡೆದಾಗ ಬಸಪ್ಪ ರಂಗಾವ ಕಲೇಶಿ ಪೂಜಾ ರಸ್ತೆ ಬಲಬದಿಗೆ ಬಿದ್ದರು.
ಹೊಡೆದಾಗ ಬಸಪ್ಪ.
ಎಸ್ ಮೈ ಲಾರ್ಡ್ಸ್. ಹೊಡೆದಾಗ ಬಸಪ್ಪ ರಂಗಾವ ಕಲೇಶಿ ಮತ್ತು ಪೂಜಾ ರಸ್ತೆಯ ಮೇಲೆ ಬಲಬದಿಗೆ ಬಿದ್ದರು. ಡಿಕ್ಕಿ ಹೊಡೆದ ಸ್ಥಳದಲ್ಲಿ ಜೀಪ್ ಬಿದ್ದಿತ್ತು. ಕೆಳಗೆ ಬಿದ್ದ ಬಸಪ್ಪ ರಂಗವ ಅವರ ಮೊಮ್ಮಕ್ಕಳು ರಕ್ಷಿಸಲು ನಾನು ಘಟನೆ ಜಾಗೆ ಹೋಗಲಿಲ್ಲ. ಆ ವೇಳೆಗೆ ನಾನು ಘಟನಾ ಸ್ಥಳದಿಂದ 50 ಫೂಟ್ ದೂರಲ್ಲಿ ನಿಂತಿದ್ದೆ. ಆ ವೇಳೆಗೆ ರಸ್ತೆಯಲ್ಲಿ ವಾಹನಗಳು ಘಟನಾ ಸ್ಥಳದ ಹತ್ತಿರ ತಿರುಗಾಡುತ್ತಿದ್ದವು. ಹೇಗೋ ಎಂದರೆ ಒಂದು ಟ್ರ್ಯಾಕ್ಟರ್ ಮಾತ್ರ ಘಟನಾ ಸ್ಥಳದಿಂದ ಸ್ವಲ್ಪ ದೂರದಲ್ಲಿ ಇತ್ತು. ನಿಂತ ಟ್ರ್ಯಾಕ್ಟರ್ ನಲ್ಲಿ ಒಬ್ಬ ಚಾಲಕ ಮಾತ್ರ ಇದ್ದ. ಘಟನೆ ಮುಗಿದ ನಂತರ ಟ್ರ್ಯಾಕ್ಟರ್ ಚಾಲಕ ಘಟನಾ ಸ್ಥಳಕ್ಕೆ ಬಂದ. ಮೂರನೇ ಆರೋಪಿ ಮೋಟಾರ್ ಸೈಕಲ್ ಕ್ರೂಸರ್ ಜೀಪ್ ಬಲಬದಿಗೆ ನಿಲ್ಲಿಸಿದ. ಜೀಪ್ ಡಿಕ್ಕಿ ಹೊಡೆದ ನಂತರ ಕೆಳಗೆ ಬಿದ್ದಿದ್ದ ಬಸಪ್ಪ ಎದ್ದು ಕುಳಿತನು. ರಂಗವ ಎದ್ದು ನಿಂತಳು. ಆ ವೇಳೆಗೆ ಕಲ್ಮೇಶ್ ಪೂಜಾ ಚೀರಾಡ್ತಾ ಓಡಿ ಹೋದರು. ಕಲ್ಮೇಶ್ ಮತ್ತು ಪೂಜಾ ರಸ್ತೆ ಬಳಿಗೆ ಓಡಿ ಹೋದರು. ಘಟನೆ ಜಾಗ ಹತ್ತಿರ ಕಂಟೆಗಳು ಇಲ್ಲ ಎಂದರೆ ನಿಜವಲ್ಲ. ಅಂಡ್ ಮೈ ಲಾರ್ಡ್ಸ್, ಅಬೌಟ್ 2 lines ಫರ್ದರ್. ಘಟನೆ ಜಾಗದಿಂದ ಸ್ವಲ್ಪ ದೂರದಲ್ಲಿ ಸುಮಾರು 10 ಜನರು ನಿಂತು ನೋಡುತ್ತಿದ್ದರು. ನೋಟ್ಸ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್, ಮೈ ಲಾರ್ಡ್ಸ್. 209. ಫ್ರಮ್ ದ ಟಾಪ್, ಮೈ ಲಾರ್ಡ್ಸ್, ಇಟ್ ಇಸ್ ಅ 10th line. ಆರೋಪಿಗಳು ಹೊರಟು ಹೋದ ನಂತರ ಸುಮಾರು 20 ಜನರು ಸೇರಿದರು. ಆ ವೇಳೆಗೆ ನನ್ನ ಬಳಿ ಮೊಬೈಲ್ ಫೋನ್ ಇರಲಿಲ್ಲ. ನಿಂತ ಟ್ರ್ಯಾಕ್ಟರ್ ಚಾಲಕನು ಕೊಟ್ಟ ಮೊಬೈಲ್ ಫೋನ್ ಅಲ್ಲಿ ಕಲ್ಮೇಶ್ ಫೋನ್ ಮಾಡಿದ. ರಾತ್ರಿ ಸುಮಾರು 10 ಗಂಟೆವರೆಗೂ ನಾನು ಘಟನೆ ಜಾಗದಲ್ಲೇ ಇದ್ದೆ. PW1 CW12 ಎಷ್ಟು ಗಂಟೆಗೆ ಜಾಗೆ ಮೇಲೆ ಬಂದರು ಅನ್ನೋದು ಕಲ್ಮೇಶ್ ಫೋನ್ ಮಾಡಿದ ಸ್ವಲ್ಪ ಹೊತ್ತಿನ ನಂತರ ಬಂದರು. ನಾನು ಘಟನೆ ಆಗುವುದನ್ನು ನೋಡಿದ ವಿಷಯವನ್ನು PW1 ತಮ್ಮಣ್ಣನಿಗೆ ಹೇಳಿದ್ದೇನೆ.
Just a minute. Complaint lodged?
It is at 10:30 in the night, my lords.
10:30, yeah?
Yes.
Thereafter spot.
Yes.
Thereafter spot and engage.
Next day.
Next day morning.
Yes, next day morning, not immediately on the same day.
10 ಹತ್ರ ತನಕ ನಾನಿದ್ದೆ.
ಅದೇ ಅಂಡ್ ಘಟನೆ ಬಗ್ಗೆ ನೋಡಿದ ವಿಷಯವನ್ನು PW1 ದಟ್ ಇಸ್ ಕಂಪ್ಲೇಂಟ್ ಗೆ ಹೇಳಿದ್ದೇನೆ. ರಾತ್ರಿ ಸುಮಾರು 10 ಗಂಟೆ ವೇಳೆಗೆ ಘಟನೆ ಜಾಗದಲ್ಲಿದ್ದ ಬಸಪ್ಪ ರಂಗಾವಳ ಮೃತದೇಹವನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋದರು. Who has taken shifted the body also not established by the prosecution, my lords. That is also under caution. Then, my lords, ಜಾಗದಲ್ಲಿ ಬಸಪ್ಪ ರಂಗಾವಳ ಮೃತದೇಹವನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋರೋದು. ನಾನು ಮೃತದೇಹವನ್ನು ತಂದ ವಿಜಯ ಅವರಪ್ಪ ಬರಲಿಲ್ಲ. ನಾನು ಘಟನೆ ಜಾಗದಿಂದ ಗುಣದಾಳಕ್ಕೆ ಹೋದೆ. ಮರುದಿನ ಸುಮಾರು 1:30-2 ಗಂಟೆ ವೇಳೆಯಲ್ಲಿ ನಾನು ಘಟನೆ ಜಾಗಕ್ಕೆ ಬಂದೆನು. ಪೊಲೀಸರು ಕರೆದ ಕಾರಣ ಮರುದಿನ ಈ ರೀತಿ ಜಾಗಕ್ಕೆ ಹೋಗಿದ್ದೆ. ಘಟನೆ ದಿವಸ ರಾತ್ರಿ ಸುಮಾರು
Statement recorded on next day, na?
ನೆಕ್ಸ್ಟ್ ಡೇ 8:1, my lords.
Yes.
ಘಟನೆ ದಿವಸ ರಾತ್ರಿ ಸುಮಾರು 7ರಿಂದ 7:30 ಗಂಟೆ ಅವಧಿಯಲ್ಲಿ ಪೊಲೀಸರು ಘಟನಾ ಜಾಗಕ್ಕೆ ಬಂದರು. ಆ ವೇಳೆಗೆ ಪೊಲೀಸರು ನನಗೆ ವಿಚಾರಿಸಿಲ್ಲ. 7/1/2014 ನಾನು ಕಂಬಾಗಿಲಿನಿಂದ ಗಲಗಲಿಗೆ ಶೇಂಗಾ ಬೀಜ ತರಲು ಹೋಗಿದ್ದೇನೆ. ಆ ವೇಳೆಗೆ ಬಸಪ್ಪ. Police visited at about 7 to 7:30 to the place of his incident. They did not inquire about him. And, my lords, 212, my lords. 212, my lords, on the top, my lords, 10th line, ನಮ್ಮ ಊರಿಂದ.
Page number 212 ಅಲ್ವಾ?
212, 212.
From
the top, my lords, it is a 10th line. ನಮ್ಮ ಊರಿಂದ ಗಲಗಲಿಗೆ ಹೋಗುವಾಗ ಗುಣದಾಳ ಶಿರಬೂರ್ ನಂದಿ ಫ್ಯಾಕ್ಟರಿ ಬರುತ್ತದೆ ಅಂದರೆ ನಿಜ. ಗುಣದಾಳದಲ್ಲಿ ಪೊಲೀಸ್ ಔಟ್ಪೋಸ್ಟ್ ಪೊಲೀಸ್ ಠಾಣೆ ಇದೆ ಅಂದರೆ ನಿಜ. ಘಟನೆ ದಿನ ರಾತ್ರಿ 10 ಗಂಟೆಗೆ ನನ್ನ ನಮ್ಮೂರಿಂದ ಗುಣದಾಳಕ್ಕೆ ವಾಪಸ್ ಬಂದ ನಂತರ ಗುಣದಾಳ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಹೋಗಿ ನಾನು ಫಿರ್ಯಾದಿ ಕೊಟ್ಟಿಲ್ಲ. Police outpost was very much available to them, my lords, to register a complaint. And one side he says that he was very much available there. Police visited, but they did not, my lords, record his statement. On the other hand, he had an opportunity to register it, my lords. He crosses the police station. He did not make any venture, my lords. And my lords, now evidence of PW7, my lords.
Where is the statement of, just read once the statement of, we'll go through the statement of this man, this
PW5, 5 minutes.
Page is to?
It is not part of paper book, it seems.
Records, yeah.
Original. Manila.
Narayan alva?
Yes, my lord, Narayan. His further statement, my lords, at dated 8/1/2014. ಪುನಃ ಹೇಳಿಕೆ.
ಬೇಡ, statement.
Oh, sorry, PW5, my lords. Yes. ನಾರಾಯಣ್ ಮಲೋಟ್ಸ್, ನಾನು ನಾರಾಯಣ್ ತಂದೆ ಸೊ ಅಂಡ್ ಸೊ ಮಲೋಟ್ಸ್. ಅಲ್ಲಿ ಸ್ಟಾರ್ಟ್ ವಿತ್ ದ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ. ನಮ್ಮ ಊರು ಕಂಬಾಗಿ ಗ್ರಾಮ ಇರುತ್ತದೆ. ನನ್ನ ಬಾಬತ್ ಹೊಲ ಮನೆಗಳಿದ್ದು ಒಕ್ಕಲ್ತನ ಕೆಲಸ ಮಾಡುತ್ತೇನೆ. ನನ್ನ ತಾಯಿ ನೀಲವಳ ತವರ ಮನೆ ನಮ್ಮೂರು ಇರುತ್ತದೆ. ನನ್ನ ತಾಯಿ ನೀಲವಳ ಖಾಸ್ ಅಕ್ಕ.
ನೆಕ್ಸ್ಟ್ ಪಾಠ ರಂಗವನಪ್ಪ.
ಎಸ್, ರಂಗವನ ಅಪ್ಪ ಹನುಮಂತ್ ಕುಮಟಗಿ. ಇವನು ಮೊದಲನೇ ಹೆಂಡತಿ ನಾಗವ್ವ. ಇವಳ ತವರು ಮನೆ ನಮ್ಮೂರ ಕಂಬಾಗಿ ಇದ್ದು ಅವಳಿಗೆ ತವರು ಮನೆಯ ಆಸ್ತಿ 9 ಎಕರೆ ಜಮೀನು ಇದ್ದು ಅದನ್ನು ನಾಗವ್ವ ಇವಳು ತನ್ನ ಹೆಣ್ಣು ಮಕ್ಕಳಾದ ರಂಗವ್ವ ಭೀಮಾ ಇವಳಿಗೆ ಮಾಡಿದ್ದು ಇರುತ್ತದೆ. ಹನುಮಂತ್ ಕಮಟಗಿ ಈತನ ಮೊದಲ
ಇನ್ಸಿಡೆಂಟ್.
ಪಡನ್
ಡೇಟ್ ಆಫ್ ಇನ್ಸಿಡೆಂಟ್.
ಡೇಟ್ ಆಫ್ ಇನ್ಸಿಡೆಂಟ್ ಇಸ್ 7 ಮೈಲಾಟ್ಸ್.
7/7 ಆ ಪಾರದಿಂದ ಬನ್ನಿ. ಕಮ್ ಟು ನೆಕ್ಸ್ಟ್ ಪೇಜ್
ಪ್ಲೀಸ್.
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 3. ಪ್ಯಾರಾ 3 ದಿನಾಂಕ 7/1.
7/1 ಮೈಲಾಟ್ಸ್. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನೋಟ್ಸ್. 7/1/2014 ನಾನು ಗಲಗಲಿಗೆ ಹೋಗಿದ್ದೇನು. ಅಲ್ಲಿ ರಂಗವಳ ಗಂಡ ಬಸಪ್ಪ ಸಿಕ್ಕಿದ್ದು. ಅವರಿಗೆ ಮಾತಾಡಿಸಲು ಮಗಳು ದ್ಯಾಮವ್ವ ಇವಳ ಊರಿಗೆ ಹೋಗಿ ಪರ್ತ್ ಊರಿಗೆ ಹೊರಟಿರುವಾಗ ಹೇಳಿದರು. ಅವರಿಬ್ಬರು ಮೋಟರ್ ಸೈಕಲ್ ಮೇಲೆ ತಮ್ಮ ಮಗ ಕಲ್ಮೇಶ್, ಮಗನ ಮಗಳು ಪೂಜೆಯವರೆಗೆ ಕರೆದುಕೊಂಡು ಮಧ್ಯಾಹ್ನ ಸುಮಾರು ಊರ ಕಡೆಗೆ ಹೊರಟರು. ನಾನು ಸಹ ಅವರ ಹಿಂದಿನಿಂದ ಊರ ಕಡೆಗೆ ಹೊರಟಿದನು. ಮುಂದೆ ಗಲಗಲಿ ದಾಟಿ ನಂದಿ ಶಾಲೆ ಹತ್ತಿರ ಅವರು ಹೊರಟಾಗ ಹಿಂದಿನಿಂದ ಒಂದು ಕ್ರೂಸರ್ ಜೀಪ್ ಜೋರಾಗಿ ಹೊರಟಿದ್ದು. ಆ ಕ್ರೂಸರ್ ಜೀಪಿನ ಹಿಂದೆ ಮುರಪ್ಪ, A3, ಹನುಮಂತ್ ಕುಮಟಗಿ, ಅವನ ಗೆಳೆಯ ರೇವಣಸಿದ್ದ A5, ಶೇಖಪ್ಪ ಬಾಡಿಗೆ ಜೀಪಿನ ಹಿಂದೆ ಹೊರಟಿದ್ದರು. ಅವರ ಹಿಂದೆ ಸ್ವಲ್ಪ ಅಂತರದ ಮೇಲೆ ನಾನು ಇದ್ದೆನು. ಕ್ರೂಸರ್ ಜೀಪ್ ಚಾಲಕನು ಜೋರಾಗಿ ನಡೆಸಿಕೊಂಡು ಹೋದವನೇ ರಂಗವ್ವ ಮತ್ತು ಬಸಪ್ಪ ಕುಳಿತು ಹೊರಟ ಮೋಟರ್ ಸೈಕಲ್ಗೆ ಡಿಕ್ಕಿ ಹೊಡಿಸಿದರು. ಅವರೆಲ್ಲ ಮೋಟರ್ ಸೈಕಲ್ ಸಮೇತ ಕೆಳಗೆ ಬಿದ್ದರು. ಚಾಲಕ ಜೀಪ್ ನಿಲ್ಲಿಸಿದನು. ಮುರಪ್ಪನು ಸಹ ತನ್ನ ಮೋಟರ್ ಸೈಕಲ್ ಅನ್ನು ಜೀಪಿನ ಹತ್ತಿರ ನಿಲ್ಲಿಸಿದನು. ಅದನ್ನು ನೋಡಿ ನಾನು ಗಾಬರಿಯಾಗಿ ಹೆದರಿ ದೂರದಲ್ಲಿಯೇ ಮೋಟರ್ ಸೈಕಲ್ ನಿಲ್ಲಿಸಿ ನಿಂತನು. ಆಗ ಜೀಪಿನಲ್ಲಿ ಕುಳಿತವನು ಕೆಳಗೆ ಇಳಿಯಲು ಅವರು ಮಾಳಪ್ಪ, ಹನುಮಂತ್ ಕಮಟಗಿ, ಪರಮಾನಂದ, ಕೃಷ್ಣಪ್ಪ ಅಂಗರ್ಗಿ ಇವರು ಇಳಿದರು. ಮಾಳಪ್ಪನು ಬಡಗಿ ಹಿಡಿದುಕೊಂಡು ಕೃಷ್ಣಪ್ಪ ಕಬ್ಬಿಣರಾಡು, ಮುರಪ್ಪ ಜೀಪಿನಲ್ಲಿದ್ದ ಸೀಸದ ಗುಂಡು ತೆಗೆದುಕೊಂಡು ರಂಗವ್ವ ಮತ್ತು ಬಸಪ್ಪನಿಗೆ ಹೊಡೆಯಲಿಕ್ಕೆ ಹತ್ತಿದರು. ಅವರು ಚೀರಾಡಲಿಕ್ಕೆ ಹತ್ತಿದ್ದು ಅವರ ಮೊಮ್ಮಕ್ಕಳು ಅಂಜಿ ಓಡಿ ಮರೆಯಲ್ಲಿ ಹೋಗಿ ಕುಳಿತರು. ನಂತರ ಪರಮಾನಂದ ತಾನು ನಡೆಸಿಕೊಂಡು ಬಂದಿದ್ದ ಜೀಪ್ ನಂಬರ್ ಸೊ ಅಂಡ್ ಸೊ ನನ್ನು ಬಸಪ್ಪನ ಮೇಲೆ ಹಾಯಿಸುವ ಕಾಲಕ್ಕೆ ರೇವಣಸಿದ್ದನು ಬಸಪ್ಪನ 2 ಕಾಲಗಳನ್ನು ಒತ್ತಿ ಹಿಡಿದಿದ್ದನು. ಪರಮಾನಂದ ಜೀಪನ್ನು ಬಸಪ್ಪನ ತಲೆ ಮೇಲೆ ಹಾಯಿಸಿದನು. ಇಬ್ಬರು ಸ್ಥಳದಲ್ಲಿ ತೀರಿಕೊಂಡರು. ನನ್ನ ಭಯದಿಂದ ಅವರು ನನಗೂ ಸಹ ಕೊಲೆ ಮಾಡಬಹುದು ಅನ್ನೋ ಅಂಜಿಕೆಯಿಂದ ಅವರ ಸಮೀಪಕ್ಕೆ ಹೋಗ್ಲಿಲ್ಲ. ಹೆದರಿ ಓಡಿ ಹೋದನು.
Come to the evidence of PW 6.
Yes, 6. Yes, One last line, my lords, at same cross examination, page 206. Last para, my lords. ನನಗೆ ಮೋಟರ್ ಸೈಕಲ್ ಚಾಲನೆ ಮಾಡಲು DL ಇಲ್ಲ ಎಂದರೆ ನಿಜ. His version is that, my lords, he was riding the vehicle, but he did not own the license. What extent? Some extent, but it is contributed, my lords, as a cumulative effect.
ಹೆಲ್ಮೆಟ್ ಹಾಕೊಬೇಕು ಅಂತ.
But ಇಲ್ಲ ಅವರು of course most of them yes.
ಇಲ್ಲಿ ಯಾರು ಹಾಕೊಂಡಿಲ್ಲ. ನಾನು ಒಂದಿನ ಯಾರೋ ಪೊಲೀಸ್ ಹಾಕೊಂಡಿದ್ವಿ. ನಾನು ಗನ್ಮ್ಯಾನ್ ಹೇಳಿದೆ ಯಾರಪ್ಪ ಅಂದ್ರೆ ಸರ್ ಅವನು ನಮ್ಮ ಸಾಯಿ ಗನ್ಮ್ಯಾನ್ ಬೆಂಗಳೂರಿಂದ ಇಲ್ಲಿ
And page 212, my lords. Last time.
The statement of.
Page 212, my lords.
2 and 4.
212, my lords. 2 and 12, last lines.
2 and 2,
Yes, my lords.
Yes, yes.
10. 2 and 10, 10, 12 ಇದೆ. 12, my lords. Last 5 lines, my lord. ಆ ವೇಳೆಗೆ ಘಟನೆ ಮರುದಿನ ಮಧ್ಯಾಹ್ನ 12 ಗಂಟೆಗೆ ತಮ್ಮಣ್ಣ ನನಗೆ ಭೇಟಿ ಆದನು. ಆ ವೇಳೆಗೆ ನಾನು ತಮ್ಮನಿಗೆ ಫಿರ್ಯಾದಿ ಕೊಟ್ಟಿರನು ಹೇಗೋ ಎಂದು ಕೇಳಿಲ್ಲ. ಮನೆಯಲ್ಲಿ ನಾನು ನನ್ನ ತಂದೆ ಮತ್ತು ನನ್ನ ಹೆಂಡತಿ ಮಕ್ಕಳೊಂದಿಗೆ ಕೂಡಿರುತ್ತೇನೆ. ನಾನು ಘಟನೆ ವಿಷಯನ್ನು ಆ ದಿನ ನನ್ನ ತಂದೆ ಮತ್ತು ಹೆಂಡತಿಗೆ ಹೇಳಿಲ್ಲ. He did not inform anybody, my lord. That is in PW 6, my lords. Now injured eyewitness. I'll start with.
We'll continue it.
Please.
Court officer.
ಹೇಳ್ರಿ ಸರ್.
Cell number 32 reach ಆಗಲ್ಲ ಮೇಡಮ್ ಇವತ್ತು.
ಸರ್ ಇನ್ನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ನಡೀತಾ ಇದೆ. ಅದು ಎಷ್ಟೊತ್ತಾಗದ ಗೊತ್ತಿಲ್ಲ ಸರ್ ನಮ್ಗೆ. ತಂದು ಕೊಡ್ಲಿಲ್ಲ ಅದು ಪ್ರಿಂಟ್.
ಮೇಡಮ್ ತೆಗಿಲ್ರಿ.
ಕೊಟ್ಟಾರಲ್ಲ ಪ್ರಿಂಟ್ ಬೇಕಂತಾರೆ. ಕಂಪ್ಯಾಷನೇಟ್ ನಿಮ್ಗೆ ಹೇಳಿದ್ವಿ. ಈಗ ಹೇಳಿದ್ವಿ. ನಿಮ್ದು ಇದನ್ನ ಜೆರಾಕ್ಸ್ ಅಂತ ಪ್ರಿಂಟ್ ಕೊಡು. ಇದ್ರಲ್ಲಿ ಕೊಡ್ಬೇಕಾ? ಅದ್ರಲ್ಲಿ ಬರ್ತಾ ಇಲ್ಲ. ಬಂದ್ರೆ ಕೊಟ್ಬಿಡ್ರಿ. 3 ಪೇಜ್ ಇದೆ. ಆಗಲ್ಲ. ಯಾವ್ದಿದೆ ಅದು? ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ ಅಂಡ್ ಅದರ್. ಸೂರ್ಯನಾರಾಯಣ ತ್ರಿಪಾಠಿ. ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಸೈಟೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. 5000 ಇದು ಬೇಕು ಪ್ರಿಂಟ್.
ಮೇಡಮ್ ತೆಗಿಲ್ರಿ. ಬರ್ರಿ.
2 ಪ್ರಿಂಟ್ ಕೊಡಿ ಅಂತ ಹೇಳಿ. ಕಳಿಸಿದ್ದಾರೆ. ಬೇರೆದ್ರ ಕಳಿಸಿದ್ದಾರೆ. ಇದ್ರ ಪ್ರಿಂಟೇ ಕೊಟ್ಟಿಲ್ಲ.
ಹಲೋ
ಪ್ರಿಂಟೇ ಕೊಟ್ಟಿಲ್ಲ. ಬುಕ್ ಕೊಟ್ಟಾರ. ಒಂದೇ ಪ್ರಿಂಟ್ ಕೊಡು ಅಂತ ಹೇಳಿದ್ರು.
ಯಾವ ಕಳಿಸಿದ್ರೆ KRS ಕೊಟ್ಟಿಲ್ಲ.
ಬುಕ್ ಕಳಿಸಿದ್ದಾರೆ. ಸಾಹೇಬ್ರಿಗೆ ಕೊಡಾಕ ಒಂದು.
2 ಚಿಪ್
ಬೇಡ ಒಂದೇ ಸಾಕು. ಇದು ಒಂದು ಕೊಡು. 2022 ಡೇಟ್ ಐತಪ್ಪ ಈಗ. ಅವ್ರಿಗೆ ಕೊಡು ಅಂದ್ರೆ ಇಲ್ಲ ನಾನು ಅಲ್ಲಿ ಮಾಡ್ಕೊಡ್ತೀನಿ. ಅಲ್ಲಿದೆ ನೋಡೋದು. ಅಲ್ಲ ಮಾಡಲ್ಲ ಅಂತವ್ರು ಅದನ್ನ ಅವ್ರು ಅಲ್ಲೇ ಸೈನ್ ಮಾಡಿ ಕಳಿಸ್ತಾರೆ ಅಂತ ಇಲ್ಲಿ ಕೊಡ್ಲಿಲ್ಲ ಅವ್ರು. ಕೊಟ್ಬಿಡ್ರಿ ಬೇಕಂತ. ಶ್ವೇತಾ ಮೇಡಮ್. ಇನ್ನೊಂದ್ ಸರ್ತಿ ಅಂದ್ರೆ ನೀವ್ ಮತ್ತೆ ಹೆಂಗ ನೋಡಲ್ಲ ಇಲ್ಲ ಅಂದ್ರೆ
Suit was
He
instituted on.
submitted that such suit was barred by limitation. And accordingly, the trial court's finding on issue number 4
Sir.
huh,
Yes, madam.
is erroneous. Full stop. Matter requires consideration. In light of the same. What is your IA?
Judgment and decree be stayed, madam.
ಅಲ್ಲ FDP ಮಾತ್ರನಾ ಹೇಗೆ?
ಇನ್ನೂ ಹಾಕಿಲ್ಲ ಸರ್. Till at they are not filed.
Will be stay of the judgment and decree in the next date. Issue emergent notice to the respondents.
Respondents.
These are to be summoned forthwith.
Obliged, madam.
Before I could start with the PW6, my lord, one submission notes. As per the evidence of PW1, my lords, on the date of incident, he called, deceased had called the PW1 son over phone, intimated that we are coming back. But my lords, as per the spot Panchnama, nothing has been recovered. Phone, absolutely there is no phone has been recovered from the spot. Either in the inquest also. It could have been found from pocket for anywhere, my lords. Nothing has been traced out. ಜೇಬಿಂದಾನೆ ಫೋನ್ ಮಾಡಿ ಬಂದೆ ಅಂತ ಹೇಳ್ತಾರೆ. It was hardly about 3-4 years prior to the incident. But police have nothing has been traced from the spot, either the inquest. That is also one of the circumstances fatal to the case of the prosecution. It's a PW6, my lords, at page.
You can't deny the presence of PW1 after the incident.
No, he
Whether
was
he
there.
called or not, anyhow, presence of PW1 is there.
Yes, the story they have begun saying that my father was informed and coming over from the place, and because there is an inordinate delay in registration the FIR, that it could be one of the circumstances show that, because the way they have planted PW5, because he was not at all there, because few circumstances suggest that my lords, he was mum for a moment, and because if he would have been there, ಪುನಃ ಮೋಟರ್ ಸೈಕಲ್ ಮೇಲಿಂದ ನಾನು, ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ, ನನ್ನ ಆಯಿ ರಂಗವ್ವ ಹಾಗೂ ಪೂಜಾ ಕೊಡಿ ವಾಪಸ್ ಗುಣದಾಳಕ್ಕೆ ಹೊರಟಿದ್ದೆವು. ಆ ವೇಳೆಗೆ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ ಮೋಟರ್ ಸೈಕಲ್ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದರು. ಆ ವೇಳೆಗೆ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ TVS ಸ್ಟಾರ್ ಸೋ ಅಂಡ್ ಸೋ ನೆದ್ದು ಇದ್ದು ಗಲಗಲಿಯಲ್ಲಿ ಮೋಟಾರ್ ಸೈಕಲ್ ನಿಲ್ಲಿಸಿ ಸಂತೆ ಮಾಡಿದೆವು. ಫಾರ್ ಅ ಮೂಮೆಂಟ್ ಮಲಟ್ಸ್. Here I'd like to pause it for a moment, my lords. ನಿಲ್ಲಿಸಿ ಸಂತೆ ಮಾಡಿದೆವು. That show that they might have bought some grocery at the cloths, my lords. Here also, my lords, this is much contrary to the spot panchnama where they did not, my lords, recovered any kind of grocery or anything, my lords. That extent, my lords, because sante ಮಾಡಿದೆವು means ನಮ್ ಕಡೆ ಎಲ್ಲ they used to.
You in the cross examination, it has elicited that biscuit adi idu biddittu anta. Somewhere in the cross of this witness only, I think.
But as
You
per
only
spot,
suggested.
Accused number 4 and 5, advocate has suggested.
ಬಿದ್ದಿತ್ತು ಅಲ್ಲಿ ಅಂತ.
Biscuit ಗುಳಿಗೆ ಬಿದ್ದಿತ್ತು.
Your suggestion.
Yes.
ಆಯ್ತು ನೋಡೋಣ.
Oh, yes, please. ಸಂತೆ ಮಾಡಿದೆವು. ಈ ರೀತಿ ಗಲಗಲಿಯಲ್ಲಿ ಸಂತೆ ಮಾಡುವಾಗ PW5 ನಾರಾಯಣ್ ನಮ್ಗೆ ಭೇಟಿಯಾಗಿ ನಮ್ಮ ಅಜ್ಜ ಬಸಪ್ಪನೊಂದಿಗೆ ಮಾತನಾಡಿದರು. ನಂತರ ಪುನಃ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ನಾನು, ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ, ನಮ್ಮ ಆಯಿ ರಂಗವ್ವ ಹಾಗೂ ಪೂಜಾ ಕೂಡಿ ಗಲಗಲಿಯಿಂದ ಗುಣದಾಳ ಕಡೆಗೆ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಹೊರಟಿದ್ದೆವು. ಆ ದಿನ ಮಧ್ಯಾಹ್ನ 1:30 ಗಂಟೆಯ ವೇಳೆಗೆ ಹನುಮಗೆರೆಯಿಂದ ಹೊರಟಿದ್ದೆವು. PW10 ನಾರಾಯಣ್ ಭೇಟಿಯಾದಾಗ ಮಧ್ಯಾಹ್ನ 3 ರಿಂದ 3:30 ಸಮಯ ಆಗಿತ್ತು. ಇಂಟರ್ನ್ಯಾಷನಲ್ ಸ್ಕೂಲ್ ಹತ್ತಿರ ಬಂದು ಒಂದು ಕ್ರೂಸರ್ ಜೀಪ್ ನಾವು ಪ್ರಯಾಣಿಸಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಹಿಂಬದಿಗೆ ಡಿಕ್ಕಿ ಹೊಡೆಯಿತು. ಈ ರೀತಿ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಜೀಪ್ ಡಿಕ್ಕಿ ಮಾಡಿದಾಗ ಮೋಟಾರ್ ಸೈಕಲ್ ಸಮೇತ ನಾನು, ನಮ್ಮ ಅಜ್ಜ ಬಸಪ್ಪ, ನಮ್ಮ ಆಯಿ ರಂಗವ್ವ ಹಾಗೂ ಪೂಜಾ ಕೆಳಗಡೆ ಬಿದ್ದೆವು. ಆಗ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಡಿಕ್ಕಿ ಪಡಿಸಿದ ಕ್ರೂಸರ್ ಜೀಪಿನಿಂದ 1ನೇ ಆರೋಪಿ ಮಾಳಪ್ಪ, 2ನೇ ಆರೋಪಿ ಪರಮಾನಂದ, 4ನೇ ಆರೋಪಿ ಕೃಷ್ಣಪ್ಪ ಇಳಿದು ಬಂದರು. 1ನೇ ಆರೋಪಿ ಮಾಳಪ್ಪ ಜಾಲಿ ಬಡಿಗೆ, 4ನೇ ಆರೋಪಿ ಕೃಷ್ಣಪ್ಪ ಕಬ್ಬಿಣದ ರಾಡು ಹಿಡಿದುಕೊಂಡಿದ್ದರು. ಜೀಪಿನ ಹಿಂದಿನಿಂದ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ 3ನೇ ಆರೋಪಿ ಮೂರಪ್ಪ ಮತ್ತು 5ನೇ ಆರೋಪಿ ರೋಣಸಿದ್ದಪ್ಪ ಬಂದರು. 3ನೇ ಆರೋಪಿ ಮೂರಪ್ಪ ಸದರಿ ಮೋಟಾರ್ ಸೈಕಲ್ ಅನ್ನು ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದವರು.
Sanjay, tell us one thing. Whether this PW6 is the close relative of this accused? What's
Yes.
the relationship?
This 6, my lords.
Relationship between 6 and this accused.
Accused, no, my lords.
He happens to be the son-in-law, distant relative.
They are from the different.
Village,
Yes, yes.
Litigation is going on ever since then there is enmity. And this boy says he identifies everybody. There is no occasion for them to meet one another.
What is your cross examination? To that effect, any cross examination there?
Relations all the eyewitnesses and this witness.
Not a close relative.
ಇಲ್ಲ ಕ್ಲೋಸ್ ಇದೆ.
ನೋಡ್ಲೇ ಇಲ್ಲ. He has never seen it. This witness has never seen this accused before the incident. Before the incident. Right.
ಮೋಟಾರ್ ಸೈಕಲ್ ದೆನ್ ಮೆಲಾಟ್ಸ್ ಮೂರನೇ ಆರೋಪಿ ಮುರಪ್ಪ ಸದರಿ ಮೋಟರ್ ಸೈಕಲ್ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದನು. ಮೋಟರ್ ಸೈಕಲ್ ನಿಲ್ಲಿಸಿ ಕ್ರೂಸರ್ ಜೀಪಿಲ್ ನಿಂತಿದ್ದ ಸೀಸದ ಗುಂಡನ್ನು ತೆಗೆದುಕೊಂಡು ಬಂದನು. ಒಂದನೇ ಆರೋಪಿ ಜಾಲಿ ಬಡಿಗೆಯಿಂದ, ಮೂರನೇ ಆರೋಪಿ ಮುರಪ್ಪ ಸೀಸದ ಗುಂಡಿನಿಂದ ಮತ್ತು ನಾಲ್ಕನೇ ಆರೋಪಿ ಕೃಷ್ಣಪ್ಪ ಕಬ್ಬಿಣದ ರಾಡಿನಿಂದ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ ಮತ್ತು ನನ್ನ ಆಯಿ ರಂಗವ್ವಗೆ ಹೊಡೆಯ ಹತ್ತಿದರು. ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ ಮತ್ತು ನನ್ನ ಆಯಿ ರಂಗವ್ವ ಚೀರಾಡುತ್ತಿದ್ದರು. ನಾನು ಮತ್ತು ಪೂಜಾ ಓಡಿ ಹೋಗಿ ಮರೆಯಲ್ಲಿದ್ದ ಕಂಟಿಯ ಮರೆ ಕುಳಿತೆವು. ನನ್ನ ಆಯಿ ರಂಗವ್ವ ಸ್ಥಳದಲ್ಲಿಯೇ ಮೃತ ಆದಳು. ಐದನೇ ಆರೋಪಿ ಪ್ಲೀಸ್ ನನ್ನ ಆಯಿ ರಂಗವ ಸ್ಥಳದಲ್ಲೇ ಮೃತರಾದಳು. ಐದನೇ ಆರೋಪಿ ರೇವಣ ಸಿದ್ದಪ್ಪ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪನ ಕಾಲುಗಳನ್ನು ಗಟ್ಟಿಯಾಗಿ ಹಿಡಿದುಕೊಂಡಾಗ ಎರಡನೇ ಆರೋಪಿ ಪರಮಾನಂದ ಜೀಪನ್ನು ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪನ ತಲೆಯ ಮೇಲೆ ಓಡಿಸಿದನು. ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ ಆಗ ಸ್ಥಳದಲ್ಲೇ ಮೃತನಾದನು. ಆರೋಪಿಗಳನ್ನು ಗಾಡಿಯಲ್ಲಿ ತೆಗೆದುಕೊಂಡು ಫ್ಯಾಕ್ಟರಿ ಕಡೆಗೆ ಹೋದರು. ಆಗ ಸಮಯ ಸುಮಾರು ಸಾಯಂಕಾಲ 3:30ರಿಂದ 4 ಗಂಟೆ ಆಗಿತ್ತು. ಆರೋಪಿಗಳು ಹೋದ ನಂತರ PW10 ನಾರಾಯಣ್ ಘಟ್ಟನ ಸ್ಥಳಕ್ಕೆ ಬಂದರು. ನಾವು ಅಳುತ್ತಾಗಿದ್ದಾಗ ಮೂರನೇ ಆರೋಪಿ ಮುರಪ್ಪ ಪಿಕಪ್ ವಾಹನ ತಂದು ನಿಲ್ಲಿಸಿದನು. ನಾನು ನನ್ನ ಮಾಮ ತಮ್ಮಣ್ಣನಿಗೆ ಫೋನ್ ಮಾಡಿದೆ. ನಾನು ಫೋನ್ ಮಾಡಿದ ನಂತರ ನನ್ನ ಮಾಮ ತಮ್ಮಣ್ಣ ಸ್ಥಳಕ್ಕೆ ಬಂದರು. PW1 ತಮ್ಮಣ್ಣ ಬಂದ ಸ್ವಲ್ಪ ಹೊತ್ತಿನಲ್ಲೇ PW12 ಮಲ್ಲೇಶಿ ಮತ್ತು ಶ್ರೀಶೈಲ್ ಸಹ ಬಂದರು. ತಮ್ಮಣ್ಣ, ನಾನು, ಶ್ರೀಶೈಲ್ ಕೂಡಿ ಗಲಗಲಿಯ ದವಾಖಾನೆಗೆ ಹೋದೆವು. ಈಗ ಪುನಃ ಹೇಳುತ್ತೇನೆ, ನಾನು CW2 ಮಲ್ಲೇಶಿ ಮತ್ತು ಶ್ರೀಶೈಲ್ ಕೂಡಿ ಗಲಗಲಿಯ ದವಾಖಾನೆಗೆ ಹೋದೆವು. ನನಗೆ ಮೂಗು ಮತ್ತು ಬಲಕೆನೆ ಹಾಗೂ ಬಲ ಮೆಲ್ಕಿನ ಮೇಲೆ ಗಾಯಗಳು ಆಗಿದ್ದವು. ಗಲಗಲಿಯೆಲ್ಲ ವೈದ್ಯರು ನನ್ನನ್ನು ಪರೀಕ್ಷಿಸಿದರು. ನಂತರ ನಾನು CW12 ಮಲ್ಲೇಶಿ ಮತ್ತು PW1 ತಮ್ಮಣ್ಣ ಕೂಡಿ ವಿಜಯಪುರಕ್ಕೆ ಬಂದೆವು. ವಿಜಯಪುರದ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ವೈದ್ಯರು ನನಗೆ ಚಿಕಿತ್ಸೆ ನೀಡಿದರು. ಪೊಲೀಸರು ಸಹ ನನಗೆ ವಿಚಾರಿಸಿದ್ದಾರೆ. But this is very much contrary to the my lord's evidence of the doctor. Doctor would say it is the only Srishal accompanied this PW6, not the PW1. Because rest of the witnesses says that PW1 went along with PW6 to the hospital. But doctor says it is the only Srishal, the person who has been not even charge sheet witness has been accompanied this. Then the question arises, my lord. He says that reason for a delay of registration FIR is he was behind this my lord, treatment of this PW6. But neither he was present over there, nor he did not give the complaint. But what was doing about 10:30, my lord, that is the question, my lords.
4:30, incident caused at about 4 o'clock.
4:30, my lord. Even assuming 5 o'clock, my lords. They went to the doctor about 5:30, my lords. And he was not there at all, my lords.
And PW1 reached the spot after 6:30. I think.
Yes,
6:30. So thereafter he lodged the complaint.
please, my lord. But that
Probably this boy is aged about 80 years. How the police can register this one statement of this boy?
No,
So
no.
they waited to come, PW1 to come there, and thereafter they registered.
Definitely, my lords. No, along with this PW6, one Srishal was there in a hospital where police had come, my lords. But they did not record any statement of the Srishal. That is what the doctor says, my lords. Even wound certificate also suggests it is at the information from the Srishal. My lords, he was the person who brought, and he has suggested that it was an accident. A wound certificate exhibit P20L. Not the kid, my lords, who informed the doctor said it is an accident. It is the Srishal who informed it. That is what the doctor in cross-examination admits also. Police also are there. They inquired the Srishal also, but they did not record any statement.
Whose statement?
That is Srishal, my lords.
They both were in the hospital at that point.
ಅದಕ್ಕೆ ಅವಾಗೆ ಪೊಲೀಸರು ಬಂದ್ರು. Their police had come to that place. Hospital ಗೆ ಬಂದ್ರು. When? Yes. Then police had come.
Has to stay. PW6. This
Yes.
boy has to stay. He was under treatment at that point.
No.
Eh?
Srishal has.
Dead bodies are lying there, they are unattended. Till next day, who shifted the dead bodies is unknown. PW14 doesn't say that even after registering the case, and he deputed anybody to protect the scene of occurrence. Or PW14 says that then next day morning he came to know about this incident. Directly goes to Vijayapur hospital.
Immediately dead body shifted to the hospital. Huh?
That is
Where the dead body shifted, inquest and PM conducted in the hospital. In the hospital.
hospital.
That to another hospital. It was, bodies were shifted to government hospital. And they were transferred to another hospital. Alamin Medical College Hospital. There the biggest PM takes place. And he's not there at the time of inquest or the PM.
You are trying to dispute the time.
Yes, ma'am, very much, because the short take place 3 to 5 o'clock
Next day.
next day.
What way it is helpful to you?
Not so.
What way it will helpful to you?
Indian.
What way it will helpful to you?
Deliberation. These people have fixed. This PW6 child witness, since 98, they say that there is an enmity between them. And in fact, suit was filed as against by the daughters as against their father. These people, the PW 1 to number 1 to 3. Number 1 to 3 are the children of the second wife. Rangava's father. That ever since then, there is no contact between them. They are staying in different village and they are staying in different village.
You can dispute the death.
No, death may be there. What he says that we are not responsible for their death. We have been unlessly falsely implicated. That is our case, defense.
Jeep belongs to you, Cruiser.
Not so.
Cruiser belongs to you, Jeep.
No.
No. They're not established it. Yes, nothing has been produced. RC book or any like, absolutely no.
That is the exhibit P27, report of the PSI. Either Jeep number is mentioned or the name is taken. And 7/1, the date of registration of the FIR, till 17, no, there is no FIR of registration.
Oh, tell us one thing, why we have to discard the evidence of PW6?
He doesn't know anything about it. He names a particularly individual name he gave. He has no occasion to see any of us.
He categorically deposed that these people are assaulted. He has stated the entire incident.
Submission is.
I'll take a lordship to.
Seal. Kanbur. Seal is the son. Amneri village. When they say that in 1998 there is an enmity of the family member, and instantly the property which is disputed property has gone to them, what they say, that is disputed otherwise. Somebody. There is no evidence to show that any point of time after the dispute of litigation, these people had gone to interfere their portion of the
Enmity, that is your case also. That is, you also suggested your case also. See, motive in this case is a double-edged weapon. You can't say that for that reason, for a civil dispute, since there was a civil dispute, these accused were falsely implicated. Because for the reason that is your dispute, your defense also, yes, there was a civil dispute.
They themselves have stated.
So there is a possibility of, see, inference can be drawn there, inference can be drawn. So for that, the civil dispute only you assaulted. You made this incident.
Same time, it's a double edge.
Then what is the decree and judgment exhibit P1, P2, RSA?
6.
2006. And this incident takes place in the year 2014. And this gap of period, there is no any other incident. Who can interfere or position affect we are from another village.
We are not-
In Kambagi village.
We are not the party to that litigation. Not the party.
If at all any grudge, that could have been immediately after that 2006, my lord. That is what submission, because long gap of 8 years. Page 228 lordship mechanism. Page 228, it's cross examination, my lords. Last 3 lines.
228.
My lord. From the bottom, it is 4th line. ಕ್ರೂಸರ್ ಜೀಪು ತನ್ನ ಹಿಂಬದಿಯಿಂದ ಬಂದು ನಾವು ಕುಳಿತ ಮೋಟಾರ್ ಸೈಕಲ್ ಡಿಕ್ಕಿ ಹೊಡೆಯಿತು. ಆರೋಪಿಗಳು ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ ಆಯಿ ರಂಗೋಳಿಗೆ ಅರ್ಧ ತಾಸಿನ ಅವಧಿಯವರೆಗೆ ಹೊಡೆದಿದ್ದಾರೆ. ನನ್ನ ಅಜ್ಜ ಮತ್ತು ಆಯಿಗೆ ಎಲ್ಲೆಲ್ಲಿ ಗಾಯಗಳು ಆಗಿದ್ದಂದು ನಾನು ನೋಡಿಲ್ಲ. It is contrary to the evidence in a chief examination. He has stated that each and every what acts. And that is not possible also, my lords. Saying verbatim as it is the what acts, because the incident in such a way, my lords, even if I am there, I can't be in a position to explain each and every what act. The way he has explained that to corroborating with the other injuries, my lord, that shows that that is possible only in the case of false implications. Because as a kid sitting over some distance place, observing each and every what acts is absolutely not possible. PW7, my lords, next.
That is only if this court discards the evidence of PW5 in toto.
Yes.
If you discard the evidence of PW5 in toto, then you can claim that benefit or that contradiction.
That either of, because, my lords, his
The complete ಸುಳ್ಳು ಹೇಳೋದು and tutoring ಅಷ್ಟು ಸುಲಭ ಅಲ್ಲ.
that is what our defense also. They have suppressed the genesis of the crime. They have not come up with a clear version. That is the reason, my lords, maybe possibility of false implication is there. That is the reason, my lords, there is no examination of the tractor driver. There is nothing has been recorded from the spot. And PW5 has been, my lords, is a planted witness. That is the reason, my lords, there is no mention of A5's name in the exhibit P1. Next witness is PW7, my lords. He is a brother of deceased, my lords.
So in respect of motive,
Reached the spot, my lords, along with the, immediately after incident, he reached the spot. Malaysia.
Immediately after the incident.
Yes,
Who informed him about the incident now?
that is, my lords,
PW6,
6, my lords.
PW6
ಇಲ್ಲ.
ಕಲ್ಮೇಶನ್ ಗೆ ವಿಚಾರಿಸಲಾಗಿ.
PW1 ಹೇಳ್ತಾನೆ ಅವ್ರಿಗೆ. On the way to his. Kalmesh only intimated his PW1.
ಈ ವೇಳೆಗೆ PW1 come to 231.
Please.
The middle portion. ಆ ವೇಳೆಗೆ PW1 ತಮ್ಮನ್ನ ಸ್ಥಳದಲ್ಲಿ ಇದ್ದನು. ನಾನು PW6 ಕಲ್ಮೇಶನಿಗೆ ವಿಚಾರಿಸಲಾಗಿ
Yes, my lords.
ಅಜ್ಜ so and so ಬರ್ತಾ ಇರುವಾಗ ಹೇಳಿದ್ರು.
ಇಲ್ಲ, PW1 informed this guy. ಸುಮಾರು 4 ಗಂಟೆ ವೇಳೆಗೆ PW1 ತಮ್ಮಣ್ಣ ಫೋನ್ ಮುಖಾಂತರ ನನಗೆ ವಿಷಯ ತಿಳಿಸಿದನು.
ಸರಿ ಸರ್.
May I continue, my lords? This is relevant because starts with a 7-1. page 230, last line.
In respect of PW 229, that page, entire page, that is in respect of the motive.
Motive, that's other better.
Civil dispute.
Please,
Next.
only this extent, my lord. 231.
Hmm.
4 ಗಂಟೆ ವೇಳೆಗೆ PW1 ತಮ್ಮಣ್ಣ ಫೋನ್ ಮುಖಾಂತರ ನನಗೆ ವಿಷಯ ತಿಳಿಸಿದರು. ತಮ್ಮಣ್ಣ ಫೋನ್ ನಲ್ಲಿ ತನಗೆ ಕಲ್ಮೇಶ್ ಫೋನ್ ಮಾಡಿ ಈ ರೀತಿ ತನ್ನ ತಂದೆ ಬಸಪ್ಪ, ತಾಯಿ ರಂಗವಳಿಗೆ ಕಲ್ಮೇಶ್ ಮತ್ತು ಪೂಜಾಳೊಂದಿಗೆ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಹನುಮಗೆರೆಯಿಂದ ಬರುವಾಗ ನಂದಿ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಸ್ಕೂಲ್ ಹತ್ತಿರ ರಸ್ತೆಯ ಮೇಲೆ ಘಟನೆ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾನೆ. ಕಾರಣ ಬಾ ಎಂದು ನನಗೆ ತಿಳಿಸಿದ. ಕಲ್ಮೇಶನ್ನು ಫೋನ್ ನಲ್ಲಿ ಆರೋಪಿತರು ಕೂಡಿ ನಂದಿ ಸ್ಕೂಲ್ ಹತ್ತಿರ ರಸ್ತೆಯಲ್ಲಿ ಹೊಡೆಬಡಿ ಮಾಡಿ ಅಜ್ಜ ಬಸಪ್ಪ, ಆಯಿ ರಂಗವಯ್ಯವರಿಗೆ ಕೊಲೆ ಮಾಡಿದ್ದರೆಂದು ನನಗೆ ತಿಳಿಸಿದ್ದಾನೆ ಎಂದು ತಮ್ಮಣ್ಣ ನನಗೆ ಬೇಗ ಬಾ ಎಂದು ಕರೆದನು. ತಕ್ಷಣ ಗಾಬರಿಯಾಗಿ ನಾನು ನನ್ನ ಅಣ್ಣನ ಮಗ CW11 ಅಂಸಿದ್ದ ದಳವಾಯಿ, ಶ್ರೀಶೈಲ್, ಕಾಶಿಲಿಂಗ ಕೂಡಿಕೊಂಡು ಜೀಪಿನಲ್ಲಿ ಘಟನೆ ಜಾಗಕ್ಕೆ ಹೋದೆವು. ನಾವು ಘಟನೆ ಜಾಗೆ ಮೇಲೆ ಕಲ್ಮೇಶನ್ನು ವಿಚಾರಿಸಿದೆವು. ಆ ವೇಳೆ PW1 ತಮ್ಮಣ್ಣ ಸ್ಥಳದಲ್ಲಿ ಇದ್ದನು. ನಾನು PW6 ಕಲ್ಮೇಶರಿಗೆ ವಿಚಾರಿಸಲಾಗಿ ಆತನು ಈ ದಿನ ಅಜ್ಜ ಬಸಪ್ಪ, ಆಯಿ ರಂಗವ ಹಾಗೂ ಪೂಜಾ ತಾನು ಹಣಮೆಗೆರೆ ಗ್ರಾಮದಿಂದ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಊರಿಗೆ ವಾಪಸ್ ಬರುತ್ತಿದ್ದಾಗ ಅಜ್ಜ ಬಸಪ್ಪ ನಡೆಸಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ನಂದಿ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಸ್ಕೂಲ್ ಹತ್ತಿರ ಮೋಟಾರ್ ಸೈಕಲ್ ಹಿಂದಿನಿಂದ ಕ್ರೂಸರ್ ಜೀಪ್ ಬಂದು ಮೋಟಾರ್ ಸೈಕಲ್ ಹಿಂದೆಗಡೆ ಡಿಕ್ಕಿ ಮಾಡಿತ್ತು. ಆಗ ನಾವೆಲ್ಲರೂ ಕೆಳಗೆ ಬಿದ್ದೆವು ಎಂದು ಹೇಳಿದನು. ಜೀಪ್ನಲ್ಲಿ ಆರೋಪಿ 2, 1, 4 ಇದ್ದರು ಎಂದು ಹೇಳಿದನು. ಕ್ರೂಸರ್ ಜೀಪಿನ ಹಿಂದಿನಿಂದ ಇನ್ನೊಂದು ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಆರೋಪಿ 3 ಮತ್ತು ಆರೋಪಿ 5ನೇ ಆರೋಪಿ ಘಟನೆ ಜಾಗಕ್ಕೆ ಬಂದರು ಎಂದು ಕಲ್ಮೇಶ್ ನನಗೆ ಹೇಳಿದನು. ಕಲ್ಮೇಶನ್ನು 1ನೇ ಆರೋಪಿ MO 15 4ನೇ ಆರೋಪಿ MO 18 ರಿಂದ ಹಾಗೂ 3ನೇ ಆರೋಪಿ MO 12 ಅಜ್ಜ ಬಸಪ್ಪ, ಆಯಿ ರಂಗವಾಗಿ ಹೊಡೆದರ ಎಂದು ಹೇಳಿದನು. ಆಯಿ ಸತ್ಯ ಹೋದಳೆ ಎಂದು ಹೇಳಿದನು. ಅಜ್ಜ ಬಸಪ್ಪ ಓದಾಡುತ್ತಿದ್ದಾಗ 5ನೇ ಆರೋಪಿ ಅಜ್ಜನ ಕಾಲವನ್ನು ಹಿಡಿದುಕೊಂಡರು. ಆಗ 2ನೇ ಆರೋಪಿ ಕ್ರೂಸರ್ ಜೀಪನ್ನು ಹಿಂದಕ್ಕೆ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಹೋಗಿ ಅದರ ಗಾಲಿಯನ್ನು ಅಜ್ಜ ಬಸಪ್ಪನ ಮೇಲೆ ಹಾಯಿಸಿದರು ಎಂದು ಕಲ್ಮೇಶ್ ನನಗೆ ಹೇಳಿದನು. ಕಲ್ಮೇಶನು ಮೂಗು ಬಲ ಕಪಾಳದ ಮೇಲೆ ಗಾಯ ಆಗಿತ್ತು. ಆ ವೇಳೆಗೆ ಪೂಜಾ ಸಹ ಇದ್ದಳು. ಆ ವೇಳೆಗೆ PW5 ನಾರಾಯಣ್ ಇದ್ದನು. ನಾನು PW1 ತಮ್ಮಣ್ಣ, ಶ್ರೀಶೈಲ್ ಕೂಡಿ ಕಲ್ಮೇಶನಿಗೆ ದೊಡ್ಡ ಗಲಗಲಿ ದವಾಖಾನೆಗೆ ತೆಗೆದುಕೊಂಡು ಹೋದೆವು. ಹೆಚ್ಚಿನ ಉಪಚಾರಕ್ಕಾಗಿ ಕಲ್ಮೇಶನಿಗೆ ನಾನು ಮತ್ತು PW1 ತಮ್ಮಣ್ಣ ವಿಜಯಪುರಕ್ಕೆ ಕರೆದುಕೊಂಡು ಬಂದೆವು. ಕಲ್ಮೇಶನಿಗೆ ವಿಜಯಪುರದ ಜಿಲ್ಲಾ ಸರ್ಕಾರಿ ದವಾಖಾನೆಯಲ್ಲಿ ಚಿಕಿತ್ಸೆ ದಾಖಲು ಮಾಡಿದೆವು. ನಾನು ಕಲ್ಮೇಶನೊಂದಿಗೆ ದವಾಖಾನೆಯಲ್ಲಿ ಉಳಿದುಕೊಂಡನು. PW1 ತಮ್ಮಣ್ಣ ಫಿರ್ಯಾದಿ ಕೊಡಲು ಬಬಲೇಶ್ವರ ಠಾಣೆಗೆ ಹೋದನು.
When is statement recorded?
That is on 8/1.
8/1.
Yes, but which is very much contrary to the my lord's wound certificate as well as the evidence of Dr. my lords. Doctor said it is the only my lords that Seychelles, another Seychelles my lords, not this Seychelles my lords. And he say along with
The spot immediately after the incident.
after the incident. ಇಲ್ಲ ಹೇಳ್ತಾರೆ ಡಾಕ್ಟರ್ ಹತ್ರ ಹೋದ್ವಿ ಅಂತ along with PW1 in all the way, but doctor says it is only Seychelles who accompanied with the PW6, not this PW1 or this Seychelles.
Say evidence of this witness and this witness, even PW1 also, PW1 and this witness.
Is a hearsay.
To be cannot be treated as hearsay. There it's an rest gesture witness. They were there. Immediately they reached the spot. PW6 informed them. So section 6, rest gesture witness. So Supreme Court said the same evidentiary value as of eyewitness. Evidentiary value can be attached to the evidence of rest gesture.
But close.
Not examined as witness. Just examination by the doctor is suppressed. Why she was kept away? Who took her from the hospital?
Independent. Then page 236 is cross-examination of this witness, my lords. Second line, ಗುಣದಾಳದಲ್ಲಿ police outpost, police ಠಾಣೆ ಇದೆ. They crosses this and page 237, my lords. Next page, second line. 237 second line. ಕಲ್ಮೇಶನಿಗೆ ಚಿಕಿತ್ಸೆ ಕೊಡಿಸುವುದು ಅವಶ್ಯದ ಕಾರಣ ಗುಣದಾಳ ಮತ್ತು ಬಬಲೇಶ್ವರದಲ್ಲಿ ಫಿರ್ಯಾದಿ ಕೊಡಲು ಆಗಲಿಲ್ಲ. ರಸ್ತೆ ಬದಿಗೆ ಬಬಲೇಶ್ವರ ಪೊಲೀಸ್ ಠಾಣೆ ಇದೆ ಎಂದರೆ ನಿಜ. ನಾನು ಕಲ್ಮೇಶನಿಗೆ ಕರೆದುಕೊಂಡು ವಿಜಯಪುರ ದವಾಖಾನೆ ಹೋಗುತ್ತೇನೆ, ಕಾರಣ ನೀನು ಬಬಲೇಶ್ವರ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಫಿರ್ಯಾದಿ ಕೊಡು ಎಂದು ನಾನು ತಮ್ಮಣ್ಣನಿಗೆ ಹೇಳಿಲ್ಲ. Because the police station available on the side of the road, my lords. They crosses it, went to the Bijapur. They did not make, my lords, two different police stations have been missed out. One outpost of Gundal as well as Bableshwar police station. They crosses it, my lord. They did not register it. It is the contrary is that, my lord, so he says that PW1, it is a medical emergency, urgency. That is the reason we did not give it. And that is the strongest reason as per the case of prosecution. He did not register FIR in time. But which is much contrary to the, my lord's, wound certificate as well as the evidence of the doctor. Doctor says it is not the PW1 or this guy, my lords. It is the only Seychelles had accompanied with the PW6. That creates the doubt of the, my lords, case of the prosecution. Because, my lords, if not here or there, where was he? That is the question, my lords. For him, the only two things are the most important required things, my lords. One, he has to attend this medical emergency or to register an FIR, my lords. He crosses two police stations, one outpost as well as the Bableshwar police station. Neither he appeared before the doctor along with the PW6, nor he go to the police station and, my lords, register the complaint. That maybe it seems to be that inordinate, but the way, my lords, the circumstances which shows that, my lords, unexplained by the prosecution complaint, that, my lords, that shows that this is the inordinate delay. Deliberate and inordinate delay to fix this, my lords, planted witness PW5 to strengthen their case.
Tell us one thing.
Please.
The entire case of the prosecution, see evidence of this much witness and the police were falsely implicated you, the accused number 125, in a case of double murder. You were falsely implicated. What is your explanation, 313? Or have you examined any defense witness? What is your stand except denial? If that is so, you have to explain. What is your explanation? At least 313. Why the police were falsely implicated in a double murder case?
Silent.
313.
That is your defense. Your
Materials and that is being shown. Is falsely, it is demonstrated to the cross examination in each of the witnesses who are supported. That is not sufficient.
But those suggestions are denied. If those suggestions are denied by the witnesses, but you have to come up with your defense at least in 313 statement. 313 statement at least. See, that is an incriminating circumstance against you. What is your explanation except denial? Have you said anything?
Specific law, but when the questions that have been put to we have also around. ಅದಕ್ಕೆ ಸುಳ್ಳು ಅಂತ ಹೇಳಿದ್ರೆ ಯಾವ್ದೋ ಹೌದು ಅಂತ ಹೇಳಿದ್ರೆ ಅದನ್ನು ಹೇಳಿಕ
Say, any stretch of imagination, then it can be said that the police totally falsely implicated you in a double murder case.
Why there to be imagination not when the PW the state evidence of PW 14 and PW 12 is sufficient. They themselves are not unaware of the fact that that's how taken place, and they go unattended. Dead bodies till 10 p.m. One witness says that 7:30 p.m. itself, the dead bodies were taken. Where they were taken is not known to the police.
By whom also not
By
mentioned.
whom not known. And PW1 says, I don't know. I was at the Bijapur bullshit. Thereafter he came. Eyewitness says that I was there up to 10 p.m. He is a close relative. Even he doesn't inform it about the death of his own relative in his family. What inference can be drawn?
not the police, it is a complaint, my lords, a story to implicate it because it's a motive is double which.
At the instance of PW1 anta.
Because the way the police handled this case, my lords, after double murder, they did not even visit the spot. Next day till 1 o'clock, they did not even come to the spot. Few witnesses said, my lords, even doctor says, the police said after informing my lords MLC, he had been to the hospital, but he recorded some statements. After that, no action has been taken by the police, my lords. And so far this Kalmesh is concerned, there is an MLC that is also not brought to the my lords, record. And Pooja has been not examined. And what happened, the Pooja's MLC also, because she has been shown to the doctor, doctor treated her. Is all circumstances, my lords, to establish that this is a failure of the part of prosecution. It's not the police. The police has cooperated them in a such a way that it is naturally, my lord, two person have died on the main road itself because a very busy road. Admittedly, it is not undisputed fact. It was in front of the Nandi International School and the sugar factory was there. Many people, my lords, moving around there and heavy traffic. In spite of that, my lords, police did not visit the place on the same day. Doctor informs they did not go. Even one of PW5 says police visited but did not register it. No action has been taken. Till next day, only as if like my lords, they come only on a 8/1 at 1 PM for a spot examination.
When they were not recorded any statement of any other
No,
witness.
no statement has been recorded. Further statement also next day, my lords.
No, the other witnesses.
No.
They-
On 7/1, they have not recorded any statements.
Standing.
Yes.
That tractor driver.
Yes. Yes, that is, my lords, they are cooperated in such a way. It's quite unnatural because all three different police stations are on the way, my lords. Gandal outpost, Bableshwar police station was there. Bilgi outpost also there. Galgali.
PW9 Milan. He informed MLC to the police station Milan. Galgali outpost is there, which is part of Pidgi police station.
Usual
And
tendency.
he came and recorded the statement of that Shrishela and that injured Milan. No records have been collected.
Yes, produced. Doctor says that they recorded the statement of Shrishel in the hospital itself, but no record has been produced. And to link a chain, my lords, the entire case rests on the of this PW6 Kalmesh. He took the phone of the tractor driver, informed the PW1. The tractor driver statement should have been recorded. He should have been examined to show that chain, my lords. They did not do so.
Yes, let us see, yes.
Page 241, my lords, cross examination of this witness. Second para, my lords. ಕಲ್ಮೇಶನನ್ನು ಹೆಚ್ಚಿನ ಉಪಚಾರಕ್ಕಾಗಿ ನಾನು ಮತ್ತು PW1 ತಮ್ಮಣ್ಣ ವಿಜಯಪುರ ಜಿಲ್ಲಾ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ತೆಗೆದುಕೊಂಡು ಬಂದೆವು. ಜೀಪಿನಲ್ಲಿ ಬಂದಿದ್ದೆವು. ನಮ್ಮೂರಿಗೆ ಆ ಜೀಪಿನಲ್ಲಿ ಶ್ರೀಶೈಲ್ ಇರಲಿಲ್ಲ. ನಮ್ಮೊಂದಿಗೆ ಆ ಜೀಪಿನಲ್ಲಿ ಶ್ರೀಶೈಲ್ ಇರಲಿಲ್ಲ. ದೊಡ್ಡ ಗಲಗಲಿಯಿಂದ ವಿಜಯಪುರಕ್ಕೆ ಬರುವಾಗ ಚಿಕ್ಕ ಗಲಗಲಿ ಕ್ರಾಸ್ ನಂದಿ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಸ್ಕೂಲ್, ನಂದಿ ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿ, ಶಿರ್ಬೂರ್, ಕೆಂಗಲ್ಗುತ್ತಿ, ಗುಣದಾಳ್ ಮಾರ್ಗವಾಗಿ ಬಬಲೇಶ್ವರ್ ಮಾರ್ಗ ಮಧ್ಯದಲ್ಲಿ ಬರುತ್ತೇವೆ ಅಂದ್ರೆ ನಿಜ. ಈ ರೀತಿ ಬರುವಾಗ ಗುಣದಾಳ್ ಮತ್ತು ಬಬಲೇಶ್ವರ್ ಪೊಲೀಸ್ ಠಾಣೆಗಳು ಇರುವ ವಿಷಯ ನನಗೆ ಗೊತ್ತಿದೆ ಅಂದ್ರೆ ನಿಜ. ಕೆಲಸಗಳಿದ್ದಲ್ಲಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಹೋಗುತ್ತೇನೆ ಅಂದ್ರೆ ನಿಜ. ನಾನು ಗುಣದಾಳ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಠಾಣೆಯಲ್ಲಾಗ್ಲಿ ಅಥವಾ ಬಬಲೇಶ್ವರ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಆಗಲಿ ವಿಜಯಪುರಕ್ಕೆ ಬರುವಾಗ ಘಟನೆ ಬಗ್ಗೆ ಫಿರ್ಯಾದಿ ಕೊಟ್ಟಿಲ್ಲ. They crosses very much to those police stations. ಅಲ್ಲಿ ಡಾಕ್ಟರ್ ಹತ್ರನೂ ಇರ್ಲಿಲ್ಲ ಅವ್ರು.
Who is this PW8?
8, my lords, he is a witness to establish that there is a dispute among the he stood as in pancha. ಅದು ಯಾವುದೋ ಒಂದು ಜಗಳ ಆಗಿತ್ತು ಇದು ಲ್ಯಾಂಡ್ಗೋಸ್ಕರ ಅಂತ to show that
Earlier.
extent.
Earlier incident.
Earlier incident, civil dispute.
That deposed by PW6 also, no? PW5 or 6?
5.
PW5.
5. To show that he pacified the civil dispute. ಪಂಚನಾಮೆ ಇದು ಪಂಚ ಆಗಿ he acted, my lords. ಕರೆಸಿ ಹೇಳಿದ್ಯಾ that extent.
PW5 said, ಇದನ್ನು ತಗೊಳ್ಳದಿದ್ರೆ ನಿಮ್ಮನ್ನು ಏನು ಸಾಯಿಸ್ತೇವೆ ಅಂತ. What they have stated?
Yes, don't accept, I will kill ಅಂತ. If
Yes,
that is If that is the case, this RSA concluded in the year 2006, January itself. There should have been such a incidents.
So PW1,
Please.
PW7
Yes.
and PW8,
8.
PW8. They deposed about the motive.
Yes. Yes, madam.
Among these, PW1 and PW7 must be treated as a res geste. Yes.
Then
Now
PW9
come to the evidence. Who is PW9?
is a doctor, my lords. Yes.
Oh, before that, just come to the evidence of recovery, PW2 once,
Please. 2.
PW2. Ah.
$179.
179 minutes. ಈ ದಿನ 8/1/2014 ವಿಜಯಪುರ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಶವ ಪಂಚನಾಮೆ ಮಾಡಲು ನಾನು ಪಂಚ್ ಎಂದು ಕೆಲಸ ಮಾಡಿದ್ದೇನೆ. ಪಂಚನಾಮೆ ವೇಳೆಗೆ ನನ್ನೊಂದಿಗೆ CW4 ಸಿದ್ದವ್ವ, CW2 ದಿಲೀಪ್ ಕುಮಾರ್ ನನ್ನೊಂದಿಗೆ ಪಂಚರೆಂದು ಇದ್ದರು. ಮೊದಲು ಬಸಪ್ಪ ತಂದೆ ಸೈದಪ್ಪ ದಳವಾಯಿ ಇವರ ಮೃತದೇಹ, ರಂಗವ್ವ ಬಸಪ್ಪ ದಳವಾಯಿ ಇವರ ಶವ ಪಂಚನಾಮವನ್ನು ಮಾಡಿದ್ದೇವೆ. ಮೃತ ಬಸಪ್ಪನ ಎಡಕಪಾಳ ತಲೆಯ ಹಿಂಬದಿಗೆ ಗಾಯಗಳು ಆಗಿದ್ದವು. ಬೆಳಿಗ್ಗೆ 7:30ರಿಂದ 8:30 ಅವಧಿಯಲ್ಲಿ ಮೃತ ಬಸಪ್ಪನ ಶವ ಪಂಚನಾಮೆಯನ್ನು ಮಾಡಿದ್ದೇವೆ. ಮೃತ ರಂಗವನ ಎಡಕಪಾಳ ತಲೆಗೆ ಗಾಯಗಳು ಆಗಿದ್ದವು. ಮೃತ ರಂಗವರ ಶವ ಪಂಚನಾಮೆಯನ್ನು ಬೆಳಗ್ಗೆ 9ರಿಂದ 10 ಗಂಟೆ ಅವಧಿಯಲ್ಲಿ ಮಾಡಿದ್ದೇವೆ. ವಾಹನಗಳನ್ನು ಹಾಯಿಸಿ ಮೃತ ಬಸಪ್ಪ ಮತ್ತು ಮೃತ ರಂಗವನ ಕೊಲೆ ಮಾಡಿದ್ದರೆಂದು ಪಂಚನಾಮೆ ವೇಳೆಗೆ ತಿಳಿಯಿತು. ಈಗ ತೋರಿಸಿದ 2 ಇನ್ಕ್ವೆಸ್ಟ್ ಪಂಚನಾಮೆಯನ್ನು ನನ್ನ ಸಮ್ಮುಖದಲ್ಲಿ ಮಾಡಲಾಗಿದೆ. ಇವುಗಳನ್ನು ನಿಶಾನೆ 6 ಮತ್ತು 7 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಈಗ ತೋರಿಸಿದ ಸಹಿಗಳನ್ನು ನನ್ನವು. ಈಗ ತೋರಿಸಿದ 2 ಫೋಟೋಗ್ರಾಫನ್ನು ನಿಶಾನೆ 6, 7 ಪಂಚನಾಮೆಗೆ ವೇಳೆಗೆ ತೆಗೆದಿದ್ದಾರೆ. ಈ 2 ಫೋಟೋಗಳನ್ನು ಆರೋಪಿತರ ಪರ ವಕೀಲರ ತಕರಾರಿಗೆ ಒಳಪಟ್ಟು ನಿಶಾನೆ 8, 9 ಗುರುತಿಸಲಾಯಿತು. ಫೋಟೋದಲ್ಲಿ ನನ್ನೊಂದಿಗೆ ಇದ್ದ ಪಂಚರು, ಪೊಲೀಸರು, PW1 ಹಾಗೂ ಭಾವಚಿತ್ರಗಳು ಇವೆ. ನಿಶಾನೆ 6, 7 ಪಂಚನಾಮೆಗಳನ್ನು ಮಾಡಿದ ನಂತರ ಅದೇ ದಿನ ನಾನು ಗುನ್ನಾ ಜಾಗ ಪಂಚನಾಮೆ ಮಾಡಲು ಸಹ ಪಂಚನೆಂದು ಕಾರ್ಯ ಮಾಡಿದ್ದೇನೆ. CW2 ದಿಲೀಪ್ ಕುಮಾರ್ ಸಂತಿ ನನ್ನೊಂದಿಗೆ ಇನ್ನೊಬ್ಬ ಪಂಚ ಎಂದು ಇದ್ದರು. ಗುನಾ ಸ್ಥಳ ವಿಜಯಪುರದಿಂದ ಗಲಗಲಿ ಹೋಗುವ ರಸ್ತೆಯಲ್ಲಿ ನಂದಿ ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿಯಿಂದ 3 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿ ಇರುವ ಶಾಲೆ ಹತ್ತಿರ ಇದೆ. PW1 ತಮ್ಮನ ಪಂಚನಾಮೆ ವೇಳೆಗೆ ಗುನ್ನೆ ಜಾಗ ತೋರಿಸಿದರು. ಗುನ್ನಾ ಸ್ಥಳದಲ್ಲಿ 1 ಮೋಟಾರ್ ಸೈಕಲ್ ಸೋ ನಂಬರ್ ಮಹೇಂದ್ರ ಮ್ಯಾಕ್ಸ್ ವೆಹಿಕಲ್ ಇದ್ದವು. ಗುನ್ನಾ ಸ್ಥಳದಲ್ಲಿ ಮಣ್ಣಿನ ಮೇಲೆ ರಕ್ತ ಬಿದ್ದಿತ್ತು. ಗುನ್ನಾ ಜಾಗ ಪಂಚನಾಮ ವೇಳೆಗೆ ಪೊಲೀಸರು ಗುನ್ನಾ ಜಾಗದಲ್ಲಿ ಸ್ವಲ್ಪ ರಕ್ತ ಹತ್ತಿದ ಮಣ್ಣು ಮತ್ತು ರಕ್ತ ಹತ್ತಲಾರದ ಸಾದ ಮಣ್ಣು ಜಪ್ತಿ ಮಾಡಿಕೊಂಡರು. ಫಾರ್ ಎ ಮೂಮೆಂಟ್, my lord, I would like to pause it because, my lords, I can understand it was such a busy road, almost like a state highway road, my lords. They can saying that they recovered the, my lords, blood stain, mud and the things, my lord, from the spot. That too after, my lords, a day, that is next day. That would have been not possible, my lords, because many vehicles have, my lords, travel. That is undisputed fact. ಅಷ್ಟರವರೆಗೂ ಅಲ್ಲಿ ರಕ್ತ ಬಿದ್ದಿದ್ದ ಮಣ್ಣು ಸಿಕ್ಕಿತ್ತು, that is not at all possible. That too, my lords, there is nearby area, my lord, there is a sugar factory. Because vehicle movements are in such a way that, my lords, even off the road they move it. Tractor ಎಲ್ಲ ಲೈನ್ ಅಲ್ಲಿ ನಿಲ್ಸಿರ್ತಾರೆ, ಈ ಕಡೆ ಆ ಕಡೆ ಹೋಗ್ತಿರ್ತಾರೆ. If that would be the cases, collecting the blood stained mud from the spot after day, my lords, certainly it is not possible at all. ಸ್ವಲ್ಪ ರಕ್ತ ಹತ್ತಿದ ಮಣ್ಣು, ಸ್ವಲ್ಪ ರಕ್ತ ಹತ್ತಲಾರದ ಸಾದಾ ಮಣ್ಣು ಜಪ್ತಿ ಮಾಡಿಕೊಂಡೆವು. ಮೃತ ಬಸಪ್ಪ ಮೃತ ರಂಗವಳ ಕೊಲೆಯನ್ನು ಗುನ್ನೆ ಜಾಗದಲ್ಲಿ ಮಾಡಿದ್ದಾನೆ ಎಂದು ಪಂಚನಾಮ ಕಾಲಕ್ಕೆ ತಿಳಿಯಿತು. ಈಗ ತೋರಿಸಿದ ಗುನ್ನೆ ಜಾಗ ಪಂಚನಾಮ ನಮ್ಮ ಸಮ್ಮುಖದಲ್ಲಿ ಆಗಿದೆ. ಆ ಪಂಚನಾಮೆಯನ್ನು ನಿಶಾನ P10 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಈಗ ತೋರಿಸಿದ ಸಹಿಯನ್ನು ನಿಶಾನ P10A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಪಂಚನಾಮೆ ವೇಳೆಗೆ ಫೋಟೋ ತೆಗೆದಿದ್ದಾರೆ. ಈಗ ತೋರಿಸಿದ ನಿಶಾನ P5 ಯಲ್ಲಿ ಗುರುತಿಸಿರುವ ಫೋಟೋ P5 ಪಂಚನಾಮೆ ವೇಳೆಗೆ ತೆಗೆದಿದ್ದು ಇದೆ. ನಿಶಾನೆ P5 ಯಲ್ಲಿ ನನ್ನ ಮತ್ತು PW1, CW2 ಹಾಗೂ ಇತರ ಭಾವಚಿತ್ರಗಳು ಇವೆ. ಈಗ 2 ಪ್ರತ್ಯೇಕ ಬ್ರೌನ್ ಪೇಪರ್ ಅಲ್ಲಿ ಸುತ್ತಿ ಸೀಲ್ ಮೊಹರಿನೊಂದಿಗೆ ಸೀಲ್ ಮಾಡಿದ ವ್ಯಾಪಕದಿಂದ ಹೊರ ತೆಗೆದು ತೋರಿಸಿದ ರಕ್ತ ಹತ್ತಿದ ಮಣ್ಣು, ಸ್ವಲ್ಪ ರಕ್ತ ಹತ್ತಲಾರದ ಮಣ್ಣು ನಿಶಾನೆ P10 ಪಂಚನಾಮೆ ವೇಳೆಗೆ ಪೊಲೀಸರು ಜಪ್ತು ಮಾಡಿದ್ದಿದೆ. ಈ ರೀತಿ ಪ್ರತ್ಯೇಕ ಸೀಲ್ ಪ್ಯಾಕ್ ನಿಂದ ತೆಗೆದು ತೋರಿಸಿದ ರಕ್ತ ಹತ್ತಿದ ಮಣ್ಣನ್ನು MO1 ಎಂದು, ರಕ್ತ ಹತ್ತಲಾರದ ಮಣ್ಣನ್ನು MO2 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. MO1 ಮತ್ತು 2 ಪ್ಯಾಕ್ ಮಾಡುವಾಗ ಹಚ್ಚಿದ ಚೀಟಿಯನ್ನು ನನ್ನ ಸಹಿ ಇದೆ. ಮೋಟಾರ್ ಸೈಕಲ್ ಮಹೇಂದ್ರ ಮ್ಯಾಕ್ಸ್ ವಾಹನವನ್ನು ಪೊಲೀಸರು ನಿಶಾನೆ P10 ಪಂಚನಾಮೆ ವೇಳೆಗೆ ಜಪ್ತು ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ.
Then as far as recovery is concerned, PW2,
Yes, my lords.
PW4,
PW4, yes.
PW4. This is the same Sri Shaila?
No. the one who appeared along with PW6 before the doctor is the different Seychelles. He is not related to this deceased. He has been not examined as even charge sheet witness. And another thing, my lords, to establish that, my lords, we used the cruiser vehicle to commit offense. After that, we replaced it with some other vehicle. To show that, establish that chain, they must produce the RC records, whether that vehicle belongs to us or we are hired from somebody. Somebody's statement should have been recorded. Nothing has been established by the prosecution. Even accused vehicles also have been recovered, but no document has been produced. They must show that this vehicle is belonged to, because accusers are not that capable of, my lords, having their own vehicle. Or else if I hired it, the owner, who is the owner, my lords,
Who
his
released those documents, those two vehicles, PW, that the two Mahindra Jeep?
Yes.
ಯಾರು ರಿಲೀಸ್ ಮಾಡಿದ್ದಾರೆ? 457 ಯಾರು ಹಾಕಿದ್ದಾರೆ?
Yes, 457
ಬಿಫೋರ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ನೋಡಿದ್ರೆ
Magistrate.
Release ಆಗಿಲ್ಲ sir. Release ಆಗಿಲ್ಲ. ಆಗಿಲ್ಲ.
ಇಲ್ಲ, release
As far as my information is concerned, that has not been released. Because there is no document at all.
No document.
Yes.
because they are not established in paper to show that. Even my vehicle also. Yes, that,
PPR argument ಮಾಡುವಾಗ.
Yes.
please.
ಅದ್ ನೋಡ್ಬೇಕು ಎಲ್ಲಿದೆ ಅಂತ.
ನೋಡ್ಬೇಕು.
Yes.
Notes in,
PW4.
please, my lord. Now, one moment, my lord, 182, cross examination itself, yes. 182, from the bottom, my lords, third line. ಗುನ್ನಾಸ್ಥಳದಲ್ಲಿ ಬಹಳಷ್ಟು ವಾಹನಗಳು ತಿರುಗಾಡುತ್ತವೆ ಎಂದರೆ ನಿಜ. ಅಂತರದಲ್ಲಿ, ಲಾಸ್ಟ್ ಲೈನ್ ಮಾಡೋ, ಅಂತರದಲ್ಲಿ 10 ಫೀಟ್ ಅಂತರದಲ್ಲಿ ನಂದಿ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಸ್ಕೂಲ್ ಕಾಂಪೌಂಡ್ ಗೋಡೆ ಇದೆ ಎಂದರೆ ನಿಜ. ನೆಕ್ಸ್ಟ್ 183 ಮೆಲಾಟ್ಸ್, 6th ಲೈನ್ ಮೆಲಾಟ್ಸ್. ಗುನ್ನಾ ಜಾಗದಲ್ಲಿ ಟೈರ್ ಮಾರ್ಕ್ಗಳು ಇದ್ದವು. ಟೈರ್ ಮಾರ್ಕ್ಗಳು ಸುಮಾರು 2 ರಿಂದ 4 ಫೂಟ್ ಉದ್ದವರೆಗೂ ಇದ್ದವು. This is also unnatural. And my lords, in that 182 itself, second para, party ಸವಾಲು 1 ರಿಂದ 3 ವರೆಗೂ. May I read second para, my lord? ಈಗ ನಾನು ನೋಡಿದ ಮಹೀಂದ್ರ ಮ್ಯಾಕ್ಸ್ ಎಡ್ಸೋನೆದ್ದು ಎಡಭಾಗದ ಬಂಪರ್ ಬಾಗಿದೆ ಅಂದ್ರೆ ನಿಜ. ನಿಶಾನೆ P10 ರಲ್ಲಿ ಗುರುತಿಸಿರುವ ಪಂಚನಾಮ ವಿಷಯ ಗೊತ್ತಿದೆ. ನಿಶಾನೆ P10 ರಲ್ಲಿ ಎದ್ದರ ಮೋಟಾರ್ ಸೈಕಲ್ ಮುಂದೆ ಹೋಗುತ್ತಿದ್ದ ಟ್ರ್ಯಾಕ್ಟರ್ ಅನ್ನು ಓವರ್ಟೇಕ್ ಮಾಡಿಕೊಂಡು ಹೋಗುವಾಗ ಎಂದು ಬರೆಯುವ ವಿಷಯ ತಪ್ಪು ಇದೆ ಅಂತ.
ತಪ್ಪ ಅಂತ ಹೇಳಿ ಅವ್ರ ಕಡೆಯಿಂದ ಹೇಳ್ತಾರೆ.
Yes, yes.
When my lords, PW9 is a crucial witness, my lords.
9?
PW9.
4 ನೋಡ್ಬಿಡೋಣ. Recovery.
Please.
Recovery. PW4.
Please. Four, my lords, at 188. ಶ್ರೀಶೈಲ ಕಡಬೂರ್, my lords. CW8 ಬೀರಪ್ಪ ಹಂಚನಾಳಿ ಅವರ ಪರಿಚಯ ಇದೆ. ಸುಮಾರು 1.5 ವರ್ಷ ಹಿಂದೆ ಬಬಲೇಶ್ವರ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಪೊಲೀಸರು ಪಂಚನಾಮ ಮಾಡಲು ಕರೆದಿದ್ದರು. ವಿಜಯಪುರದಲ್ಲಿರುವ CPI ಆಫೀಸ್ನಲ್ಲಿ ಕರೆಸಿದ್ದರು. ನಾನು ಮತ್ತು CW8 ಬೀರಪ್ಪ ಕೂಡಿ ವಿಜಯಪುರ CPI ಇವರ ಆಫೀಸಿಗೆ ಬಂದೆವು. ಅಲ್ಲಿ ಪೊಲೀಸರು CPI ಅವರು ಇದ್ದರು, ಆರೋಪಿಗಳು ಸಹ ಇದ್ದರು. ಅಲ್ಲಿ ಪಂಚನಾಮ ಮಾಡಿದರು. ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ನಮ್ಮ ಸಮ್ಮುಖದಲ್ಲಿ ಕ್ರೂಸರ್ ವಾಹನ ಜಪ್ತಿ ಮಾಡಿದರು. ಆ ಕ್ರೂಸರ್ ವಾಹನ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಇತ್ತು. ಸದರಿ ವಾಹನ ನೋಡಿದಲ್ಲಿ ಗುರುತಿಸುತ್ತಾನೆ. ಸದರಿ ವಾಹನದ ಮೇಲೆ ಪರಮಾನಂದ ಪ್ರಸನ್ನ ಎಂದು ಬರೆಯಲಾಗಿತ್ತು. ಸದರಿ ಕ್ರೂಸರ್ ವಾಹನ ಸೋ ಅಂಡ್ ಸೋ ನೆದ್ದನ್ನು ಜಪ್ತಿ ಮಾಡಿ ಪಂಚನಾಮ ಮಾಡಿಕೊಂಡರು. ಈ ವಾಹನ ಪಂಚನಾಮ ವೇಳೆಗೆ ಫೋಟೋ ತೆಗೆದುಕೊಂಡರು. ಈಗ ತೋರಿಸಿದ ಜೀಪ್ ಜಪ್ತಿ ಪಂಚನಾಮ ನಮ್ಮ ಸಮ್ಮುಖದಲ್ಲಿದೆ. ಈ ಪಂಚನಾಮ ನಿಶಾನೆ 13 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಈಗ ತೋರಿಸಿದ ಸಹಿಯನ್ನು ನಿಶಾನ 13A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಈಗ ತೋರಿಸಿದ ಫೋಟೋ 13 ಅಂದು ಪಂಚ ವೇಳೆಗೆ ತೆಗೆದಿದ್ದು ಇದೆ. ಈ ಫೋಟೋವನ್ನು ನಿಶಾನ P14 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. P14 ರಲ್ಲಿ ನನ್ನ ಮತ್ತು CW8 ಮತ್ತು ಪರಮಾನಂದನ ಭಾವಚಿತ್ರಗಳು ಇವೆ. ಆರೋಪಿತರು ತಮ್ಮೊಂದಿಗೆ ಬಂದರೆ ಸಾಮಾನುಗಳನ್ನು ಇಟ್ಟಿದ್ದೇವೆ, ಅವುಗಳನ್ನು ತೋರಿಸುತ್ತೇವೆ ಎಂದು ಹೇಳಿದರು. ನಿಶಾನ P13
used for the commission of crime.
Yes.
P14 is the jeep.
Yes. That is a cruiser. ಆರೋಪಿತರು ತಮ್ಮೊಂದಿಗೆ ಬಂದರೆ ಸಾಮಾನುಗಳನ್ನು ಇಟ್ಟಿದ್ದೇವೆ, ಅವುಗಳನ್ನು ತೋರಿಸುತ್ತೇವೆ ಎಂದು ಹೇಳಿದರು. ನಿಶಾನೆ P13 ಪಂಚನಾಮ ಆದ ನಂತರ ಆರೋಪಿತರು, ನಾವು ಹಾಗೂ ಪೊಲೀಸರ ಜೀಪಿನಲ್ಲಿ
ಏನೊಂದು ಏನ್ ಯಾರ PP ಏನ್ ಮಾಡುದು ಎವಿಡೆನ್ಸ್? ಏನ್ ಸಾಮಾನುಗಳನ್ನ ಇಟ್ಟಿದ್ದೇವೆ? ಏನ್ ರೇಷನ್ ಸಾಮಾನು? ಏನ್ ಸಾಮಾನುಗಳು? ಆರ್ಡರ್ ಕೇಸ್ ಮಾಡುವಾಗ ಹೇಗೆ ಮಾಡ್ಬೇಕು, ಏನ್ ಕತೆ ಅಂತ ಒಂದು ಏನ್ ಎವಿಡೆನ್ಸ್ ಮಾಡುದು ಇದು?
ಆರೋಪಿತರು ತಮ್ಮೊಂದಿಗೆ ಬಂದರಿಗೆ ಸಾಮಾನುಗಳು ಇಟ್ಟಿದ್ದೇವೆ, ಅವುಗಳನ್ನು ತೋರಿಸ್ತೇವೆ ಎಂದು ಹೇಳಿದರು. ನಿಶಾನೆ P13 ಪಂಚನಾಮ ಆದ ನಂತರ ಆರೋಪಿತರು ಹಾಗೂ ನಾವು ಪೊಲೀಸರು ಕೂಡಿ ಪೊಲೀಸರ ಜೀಪಿನಲ್ಲಿ ಕುಳಿತುಕೊಂಡು ಸತಗುಂಡಿಗೆ ಹೋದೆವು. ಜೀಪ್ ನಿಲ್ಲಿಸಿದಾಗ ಆರೋಪಿಗಳು ಜೀಪಿನಿಂದ ಇಳಿದು ಹೊರಟಾಗ ನಾವು ಮತ್ತು ಪೊಲೀಸರು ಅವರನ್ನು ಹಿಂಬಾಲಿಸಿಕೊಂಡು ಹೋದಾಗ 1 ಮತ್ತು 2ನೇ ಆರೋಪಿತರ ಮನೆಯ ಒಳಗಡೆ ಹೋದೆವು. ಅಲ್ಲಿ ಒಂದು ಮೋಟಾರ್ ಸೈಕಲ್ ತೋರಿಸಿದರು. ಆ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ನಂಬರ್ ಇರಲಿಲ್ಲ. ಪೊಲೀಸರು ಆ ಮೋಟಾರ್ ಸೈಕಲ್ ಅನ್ನು ಜಪ್ತಿ ಮಾಡಿಕೊಂಡರು. ಪಂಚನಾಮ ಮಾಡಿದರು, ಫೋಟೋ ತೆಗೆದರು. ಕಟ್ಟಿಗೆಯ ಗೂಡಿನಿಂದ ಒಂದು ಸೀಸದ ಗುಂಡು, ಒಂದು ಕಟ್ಟಿಗೆಯ ಬಡಿಗೆ ಮತ್ತು ಒಂದು ಕಬ್ಬಿಣದ ರಾಡು ತೆಗೆದು ಹಾಜರು ಮಾಡಿದರು. ಆರೋಪಿತರ ರಕ್ತ ಹತ್ತಿದ ಬಟ್ಟೆಗಳನ್ನು ಸಹ ತೆಗೆದು ಹಾಜರು ಪಡಿಸಿದರು. ಅವುಗಳನ್ನು ನೋಡಿದಲ್ಲಿ ಗುರುತಿಸುತ್ತೇನೆ. ಇವುಗಳ ಬಗ್ಗೆ ಪಂಚನಾಮ ಮಾಡಿದರು. ಈಗ ತೋರಿಸಿದ ಮಾಲ್ ಜಪ್ತಿ ಮೇಲೆ ಇರುವ ಸಹಿ ನನ್ನದು. ಈ ಮಾಲ ಜಪ್ತಿ ಪಂಚನಾಮವನ್ನು ನಿಶಾನ P15 ಎಂದು ನನ್ನ ಸಹಿಯನ್ನು P15A. ಈಗ ತೋರಿಸಿದ ಫೋಟೋ 15 ವೇಳೆ ತೆಗೆದಿದ್ದು ಇದೆ. ಈ ಫೋಟೋವನ್ನು P16 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. P16 ನನ್ನ ಮತ್ತು CW8 ಬೀರಪ್ಪನ ಭಾವಚಿತ್ರ ಇವೆ. ನಿಶಾನ P15 ವೇಳೆಗೆ ಈಗ ತೋರಿಸಿದ 2 ಫೋಟೋವನ್ನು ಸಹ ತೆಗೆದಿದ್ದಾರೆ. ಈ ಫೋಟೋಗಳನ್ನು P17, 18 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. P13 ಮತ್ತು P15 ಪಂಚನಾಮವನ್ನು ಮಾಡಿದ ನಂತರ ಪುನಃ ಪಂಚನಾಮ ಮಾಡಿದ್ದೆವು. ಹೇಗೋ ನನಗೆ ತರ್ಕಿಗೆ ಬರುತ್ತಿಲ್ಲ. ನಂತರ ವಿಜಯಪುರಕ್ಕೆ ವಾಪಸ್ ಬಂದೆವು. ಕ್ರೂಸರ್ ಮತ್ತು ಜೀಪ್ ಮತ್ತು ಮೋಟಾರ್ ಸೈಕಲ್ ನೋಡಿದಲ್ಲಿ ಗುರುತಿಸ್ತೇನೆ. ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನನಗೆ ತೋರಿಸಿದ ಹಳೆ ಜೀಪ್ ನಂಬರ್ 77 ಅದನ್ನು P13 ರಡಿಯಲ್ಲಿ ಜಪ್ತಿ ಮಾಡಿದ್ದು ಇದೆ. ಈ ಜೀಪ್ ಅನ್ನು MO 10 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಈಗ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ತೋರಿಸಿದ ನಂಬರ್ ಇರಲಾದ
Substituted to exhibit
yes,
P14.
yes, that is MO 10, my lords.
Hmm.
ಈಗ ನ್ಯಾಯಾಲಯದ ತೋರಿಸಿದ ನಂಬರ್ ಇರಲಾದ ಮೋಟಾರ್ ಸೈಕಲ್ P15 ಪಂಚನಾಮ ಮಾಡಿಯಲ್ಲಿ ಜಪ್ತಿ ಮಾಡಿದೆ. ಈ ಮೋಟಾರ್ ಸೈಕಲ್ ಅನ್ನು MO 11 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಸಾಕ್ಷಿ ಪೊಲೀಸರೊಂದಿಗೆ 1 ರಿಂದ 3ನೇ ಆರೋಪಿತರ ಪರ ವಕೀಲರಾದ ಆವರಣದಲ್ಲಿ ಜೀಪ್ ಮತ್ತು ಮೋಟಾರ್ ಸೈಕಲ್ ನೋಡಲು ಸಾಕ್ಷಿಯೊಂದಿಗೆ ಕಳಿಸಿದಾಗ ಸಾಕ್ಷಿ ಅವರ ಸಮ್ಮುಖದಲ್ಲಿ ಜೀಪ್ ಮತ್ತು ಮೋಟಾರ್ ಸೈಕಲ್ ನೋಡಿಕೊಂಡು ಬಂದಿದ್ದಾರೆ. ಈಗ ತೋರಿಸಿದ ಸೀಸದ ಗುಂಡು ಮೇಲಿನ ಚರ್ಮವನ್ನು ಹೊಲೆದಿದ್ದು ಅದಕ್ಕೆ ಚರ್ಮದ ಬೆಲ್ಟ್ ಅನ್ನು ಜೋಡಿಸಿದ್ದು ಇದೆ. ಇದನ್ನು MO 12 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಈಗ ತೋರಿಸಿದ ಒಂದು ಹಳೆಯ ಪ್ಯಾಂಟ್, ಹಳೆಯ ಶರ್ಟ್ P15 ಪಂಚನಾಮ ವೇಳೆಗೆ ಜಪ್ತಿ ಮಾಡಿವೆ. ಇವುಗಳನ್ನು ಕ್ರಮವಾಗಿ MO 13 ಮತ್ತು 14 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಈಗ ತೋರಿಸಿದ ಒಂದು ಕಟ್ಟಿಗೆ ಬಡಿಗೆ ನಿಶಾನೆ P15 ಪಂಚನಾಮ ವೇಳೆ ಜಪ್ತಿ ಮಾಡಿದೆ. ಈ ಬಡಿಗೆಯನ್ನು MO 15 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಈಗ ತೋರಿಸಿದ ಒಂದು ಹಳೆ ಶರ್ಟ್ ಮತ್ತು ಒಂದು ಹಳೆ ಪ್ಯಾಂಟ್ ನಿಶಾನೆ P15 ಪಂಚನಾಮ ವೇಳೆಗೆ ಜಪ್ತು ಮಾಡಿದವು ಇವೆ. ಇವುಗಳನ್ನು ಕ್ರಮವಾಗಿ MO 16 ಮತ್ತು 17 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಈಗ ತೋರಿಸಿದ ಒಂದು ಕಬ್ಬಿಣದ ರಾಡು ನಿಶಾನೆ P15 ಪಂಚನಾಮ ವೇಳೆಗೆ ಜಪ್ತು ಮಾಡಿದ್ದು. ಈ ಕಬ್ಬಿಣದ ರಾಡನ್ನು MO 18 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಆರೋಪಿತರು ಹನುಮಂತಪ್ಪನ ಮನೆಯಲ್ಲಿ ಕುಳಿತು ಮಾತನಾಡಿದ ಜಾಗವನ್ನು ನೋಡಿ ಪಂಚನಾಮ ಮಾಡಿದರು. ಈಗ ತೋರಿಸಿದ ಒಳಸಂಚು ಮಾಡಿದ ಜಾಗ ಪಂಚನಾಮ ವೇಳೆ ಸಹಿ ನನ್ನದು. ಈ ಪಂಚನಾಮವನ್ನು P19 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. To establish conspiracy under section 120B, the evidence of the prosecution is this much, my lord. They shown the place where the conspiracy is.
Recovery ಮಾಡಿಕೊಂಡು these
All ಎಲ್ಲ ಅದೇ ಮನೆಯಲ್ಲಿ, ಒಂದೇ ಮನೆಯಲ್ಲಿ
ಆರೋಪಿಗಳ ಮನೆಯಲ್ಲಿ.
Yes, 1 to 2, 1 and 2 ಅಂತ. Again, they have not produced it.
1, 2 and 3.
1 and 2.
3 motorcycle.
3 also. ಇಲ್ಲ, ಮನೆ house belongs to 1 and 2.
Yes, yes.
Here, my lord, I would like to make one submission.
Hmm.
To establish the case that the recovery from my house and as well as to show that this place belongs, establish that this place where they sat and meeting of mind were there. But they have not produced any single document to show that, my lords, whether that house belongs to the accused. No document has been produced. Hatha extract, they should produce it from where they have, my lord, seized it. And page 197, cross-examination, my lords. 191, sorry. From the top, my lord, it is the 6th line. ನಿಶಾನೆ P14 ರಲ್ಲಿ ಗುರುತಿಸಿರುವ ಫೋಟೋದಲ್ಲಿ ಕಾಣುವ ಜೀಪಿನ ಚಿತ್ರದಲ್ಲಿ ಜೀಪಿನ ನಂಬರ್ ಕಾಣುವುದಿಲ್ಲ ಮತ್ತೆ ಜೀಪಿನ ಮೇಲೆ ಬರೆದ ಪರಮಾನಂದ ಪ್ರಸನ್ನ ಎಂದು ನಾನು ಮುಖ್ಯ ವಿಚಾರಣೆ ಸಾಕ್ಷಿಲಿ ಹೇಳಿದಂತೆ ಬರೆಯುವುದು ಕಾಣುವುದಿಲ್ಲ ಅಂದ್ರೆ ನಿಜ. He contradict. There he says that it written as Paramananda Prasanna. To show that, my lords, from the top 191 is itself, to show that he's an interested witness. ನನ್ನ ಮಗ ಮಲ್ಲಪ್ಪನ ಮೇಲೆ ಜಮಖಂಡಿ ಪೊಲೀಸರು ಸುಲಿಗೆ ಗುನ್ನೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕೇಸ್ ದಾಖಲು ಮಾಡಿದ್ದಾರೋ ಅಂದ್ರೆ ನಿಜ. ಸದರಿ ಕೇಸ್ನಲ್ಲಿ ನನ್ನ ಮಗ ಮಲ್ಲಪ್ಪನನ್ನು ಪೊಲೀಸರು ದಸ್ತಗಿರಿ ಮಾಡಿದ್ದಾರೋ ಅಂದ್ರೆ ನಿಜ. CW12 ಮಲ್ಲೇಶಿ ಆ ಕೇಸ್ನಲ್ಲಿ ನನ್ನ ಮಗ ಮಲ್ಲಪ್ಪನಿಗೆ ಜಾಮೀನು ದೊರಕಲು ಪ್ರಯತ್ನ ಮಾಡಿದ್ದಾರೋ ಅಂದ್ರೆ ನಿಜ. ಈ ಕಾರಣಕ್ಕೆ so and so he denied, but however we can establish that, my lords, at the instance of CW12
Respondent police are Jamakandi police or any other? Police?
ಇದರಲ್ಲಿ ಬಬ್ಲೇಶ್ವರ್ ಪೊಲೀಸ್.
Revelation.
Yes. No, he helped that this witness to come out of that. He given the surety for that. To show,
CW12.
CW12.
CW12 is a relative for this. Witness.
Yes.
To PW1.
No, this witness, PW4.
Connected. PW12, if PW12 is the relative of PW1, then you can infer.
ಇಲ್ಲ, ಇವರು in fact this witness has helped this punch witness in some other cases. Then it is quite natural, my lords, in retaliation he might have not come forward.
Merely assuming and submitting is different. Is there any
No, the
document
way they have
pertains to he has
investigated,
given
my
a
lords,
surety?
the
He has
way
given a surety. Only
Out of-
defense that has been taken. And even that has been denied by the witness.
PW9, my lords, page 246 is on doctor, my lords. Then I'll
240?
246, my lords. I think, my lords, here I'll take 247 itself, cross-examination.
Right.
Last para, my lords, cross-examination. I have treated injured Kamlesh as an outpatient. Police had not requested me to examine the injured Kalmesh. It is true to suggest that injured Kalmesh was brought to the PSC Galgali as medico-legal case. I informed to the Galgali Outpost Police Station police about my examining injured Kalmesh in the medico-legal case. On 7/1/2014 at about 5:30 PM, I have intimated to the Galgali Police Station police through phone, Srishal Yamnappa Sadapgod. This Srishal is different, my lords. Told me about the history of injured Kalmesh, sustained injuries in the road accident, traffic accident, except Srishal, nobody was accompanied injured Kalmesh. This contrary to the PW1, 5 and the 6, my lords. And it is true that I have not examined measurement of the so-and-so injuries. Witness volunteered that the nature of those injuries were not required to be measured and mentioned. It is true that the injuries 1 to 6 mentioned are super special injuries. It is true that injuries mentioned in the exhibit P20 were not danger to the life of the injured Kalmesh. After my intimation to the police, Galgali Outpost Police Station police had come to me at PSC Galgali. The Galgali Outpost Police Station police inquired to the Srishal Sadapgod and injured Kalmesh before examining the treating the Kalmesh. I did not inquire about him how the injury was caused. Kalmesh told me that while traveling on a motorcycle, Jeep dashed on a motorcycle and due to fall of the motorcycle, sustained the injuries.
Why is issue of these things?
Ali again, we can't deny that there was an accident, my lord, from our side. Might be, certainly there is an accident. We don't say that there is no death, there is no accident. Our case is defense, my lord, though they are not taken in 313. We say that as it was an accident. That is the reason he restricted his statement to that, my lords. Only accident. Police had been to the place. There was no action at all. And the photographer, my lords, and the PW12, my lords, is IO.
How
Page.
come to the evidence of next witness?
That is the next witness,
PM,
Vishnu, my lords, PW11.
PM,
No, no.
postmortem,
Dr.
postmortem,
Ramesh Patel.
PW10,
Ramesh Patel.
Yes,
Ramesh Patel.
yes, doctor. Page 250, my lords.
252, yes.
Yes, 252, last para, my lords.
Last para.
Yes. If a person being assaulted with lead ball marked at MO12, wooden club marked at MO15, and with the iron rod marked at MO18, now shown to me before the court, also due to fall from the moving motorcycle bike and passing on the wheel of the jeep on the head, like external injuries and internal injuries mentioned in the P22 may cause. He kept it as an balanced, my lords. It is possible either of the way.
Either way.
Yes, my lords. At the request of CPI, Rural PS Vijaypura and requisition dated so and so, I have conducted the PM of the dead body.
Next, page
Please.
256.
Please.
Page 257, my lords.
256 alone. It is true too.
Yes,
Right.
my lords.
Ah.
It is true that if a person is dragged through moving vehicle on a hard surface road, grazes, abrasion, brushes, lacerations may cause on the bony prominent areas. It is not true to suggest that if a person from the height of 5-6 feet on the hard surface ground, head down, like head injury is noticed by me on the head of the dead body of the Rangava may possible. It is not true to suggest like injuries I noticed on the dead body Rangava may possible on the vehicle accident. Police have not shown me the vehicle alleged to have been involved in this case. This is also faulty investigation. They did not even make an effort to show that which vehicle has been used.
On next para, on my own experience,
Yes.
I am deposing that.
Witness voluntary is that, my lords.
On my own experience, I am deposing that. Next para.
It is true
Like
that
injuries.
it is true to suggest that like injuries I noticed on the dead bodies of the deceased Basappa and deceased Rangava mentioned in exhibit P22-23 may possible in road accident, traffic accident cases. On my own experience, I am deposing that like injuries I noticed on the dead bodies of the Basava, Rangama, not possible in the road accident, traffic accident. It is true that at the time of conducting PM examination, dead bodies of the deceased Basappa and Rangava, I was not serving as a government district hospital Vijaypura. Witness voluntaries that at the time of said PM examination, he was serving as Al-Amin Medical College, but district government hospital. Vijaypura was not attached to the Al-Amin Medical College to conduct the autopsy. It is true that exhibit P22-23 I have assigned above seal affixed on the senior specialist district hospital Vijaypura. The police has not brought to show and MO 12 and 15 and 18. I have not examined the same, not issued any opinion on these weapons.
Next part also is there.
Yes.
The fracture injury.
The commuted fracture injuries may cause in a road accident, but depressed fractures not possible in a road traffic accident.
Traffic accident.
If a head come to contact with the hard portion of moving vehicle, there is no possibility of causing depressed fracture injury on head. It is not true to suggest that I am the deposing falsely, the depressed injury not possible on the said road accident. It is false. False that the instance of police I am deposing false to help the police.
Yes.
And the next.
PW 12 and 13 are the IOs, huh?
Yes,
12,
12 is the only
12,
IOS.
Only.
Who led the charge sheet also.
Who is PW 13?
13
who
is
has
my lord,
registered the case.
is one who registered the FIR.
Ah.
13 is the engineer
is
who prepared the
sketch.
sketch map. my lord.
Sketch map.
14 is the
Registered the case.
PSI who registered the FIR.
What you want to point out the faulty investigation?
That my lord,
In the, from the evidence of PW 12.
Chol, please. Page 261, my lords. They dina gunna sthalake bhetti kottu. That is my lords, almost 8th line starts with the 8th line from the top, my lords. ಅದೇ ದಿನ ಗುನ್ನಾ ಸ್ಥಳಕ್ಕೆ ಭೇಟಿ ಕೊಟ್ಟು ಇಬ್ಬರು ಪಂಚರ ಸಮ್ಮುಖದಲ್ಲಿ ಗುನ್ನಾ ಜಾಗೆ ಪಂಚನಾಮ ಮಾಡಿದೆ. ಫಿರ್ಯಾದಿ ತಮ್ಮಣ್ಣ ಗುನ್ನೆ ಜಾಗವನ್ನು ತೋರಿಸಿದನು. ಗುನ್ನೆ ಜಾಗ ಪಂಚನಾಮ ವೇಳೆಗೆ ಸ್ವಲ್ಪ ರಕ್ತ ಹತ್ತಿದ ಮಣ್ಣು, ಸ್ವಲ್ಪ ರಕ್ತ ಹತ್ತಲಾರದ ಮಣ್ಣು, ಮಹೀಂದ್ರ ಮ್ಯಾಕ್ಸ್ ವೆಹಿಕಲ್, ಮೋಟಾರ್ ಸೈಕಲ್ ಸೋ ಅಂಡ್ ಸೋ ನೇತುಗಳನ್ನು ಜಪ್ತಿ ಮಾಡಿಕೊಂಡೆ. ಈಗ ತೋರಿಸಿದ ಎಕ್ಸಿಬಿಟ್ P10 ಗುರುತಿಸುವ ಗುನ್ನೆ ಜಾಗ ಪಂಚನಾಮ ಪಂಚರ ಸಮ್ಮುಖದಲ್ಲಿ ಮಾಡಿದ್ದು ಇದೆ. This is contrary to the malords. The vehicle standing over there till next day, my lords.
8-1 or
Pardon?
7-1? Ade dina means?
Ade dina andre it is 8 for him, my lords. Yes.
Next day?
Yes, 8-1. ಅವತ್ತೇ 1 ಗಂಟೆ ಮಾಡಿರೋದು.
ಹಾ.
Till then, my lords, collecting the blood sample from the road, that to
When he
busy road.
visited the spot for the first time,
That is next day itself
Case
on the
only.
spot, 1 o'clock itself. That is what my submission. He did not even make an effort to visit the spot. Only for going, my lord, spot is punching.
first to say, come to his evidence.
Please.
ಗ್ರಾಮೀಣ ಈ ಪ್ರಕರಣದ ಮುಂದಿನ ತನಿಖೆಯನ್ನು CW 27 ಛಾಯಾಗೋಳ PS
He has been not examined.
not examined.
First IO, my lords, he has been not examined. I could have established that.
ಛಾಯಾಗೋಳ visited the spot.
That is also, my lords, it is unaware of it because prosecution has not made any effort to say that he should have examined.
Who drawn exhibit the spot muhazzar?
That is again PW 12.
PW 12.
Yes, everything done by the PW 12. ಅವ್ರಿಗೆ ಮಾಡಿದ್ರೆ it should have been clear whether he visited the spot.
SPP, what is the clarification on that aspect? Who visited the spot initially?
Well, let's let them complete.
Hi. If somebody has to visit the spot
Yes,
immediately
yes,
on
yes.
7/1. The 7/1 at about 4:30, the incident cost.
10:30.
4 PM.
Yes.
10:30 complaint has been given.
No, 10:30 complaint registered. So some investigation, you must have carried out some investigation, started the investigation.
In the
at
morning,
least.
3 o'clock, all the, this PW 14 my lords.
Well,
Each,
dead bodies, 2 dead bodies were there no, on the road.
they were there.
Oh,
They chased and arrested.
somebody
the
must have
accused.
cleared the dead body and the subsequent events.
That is
Yes.
also not
Yes, please.
clear. Who has shifted the bodies to the hospital? The investigation, that extent, it is silent. ಯಾರಂತ ಹೇಳಿಲ್ಲ ಅದು.
Alright, next. To clarify, SPP.
Please. ಇಲ್ಲಿ. Next, my lords. Then, my lords, page 271. Cross examination itself. From the top, my lords, 5th line. ಕಲ್ಮೇಶ್ PW 6 ಕಲ್ಮೇಶ್ ಈತನ ಹೇಳಿಕೆಯನ್ನು 8/1/2014 ಗುನ್ನೆ ಜಾಗ ಹತ್ತಿರ ತೆಗೆದುಕೊಂಡಿದ್ದೇನೆ. ಅದೇ ದಿನ PW 1 ತಮ್ಮಣ್ಣ ಇವರ ಪುನಃ ಹೇಳಿಕೆಯನ್ನು ಗುನ್ನೆ ಜಾಗ ಹತ್ತಿರ ತೆಗೆದುಕೊಂಡಿದ್ದೇನೆ. 8/1/2014 PW 7 ಮಲ್ಲೇಶಿ ಈತನ ಹೇಳಿಕೆಯನ್ನು ಗುನ್ನೆ ಜಾಗ ಹತ್ತಿರ ತೆಗೆದುಕೊಂಡಿದ್ದೇನೆ. PW 5 ನಾರಾಯಣ ಪಕೀರಪ್ಪಳ ಇವನ ಹೇಳಿಕೆಯನ್ನು 8/1/2014 ಗುನ್ನೆ ಜಾಗದಲ್ಲಿ ತೆಗೆದುಕೊಂಡಿದ್ದೇನೆ. 7/17/2014 PW 8 ರಂಗನಗೌಡ ಇರುವ ಹೇಳಿಕೆಯನ್ನು ಬಬಲೇಶ್ವರ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ತೆಗೆದುಕೊಂಡಿದ್ದೇನೆ. This is the identical, my lord, circumstances which demonstrate, substantiate the defense saying that PW 5 is, my lords, the planted witness. When he, my lords, come up with the story that, my lords, the PW 5 has seen it, then PW 1 gives the further statement. Then this rest of the things will start it. Till then, they will not record any statements. Almost close to, my lords, 24 hours. ಅದೇ 10 ಗಂಟೆಗೆ ತಗೊಂಡು ಹೋದ್ರು ಅಂತ ಯಾರು ತಗೊಂಡು ಹೋದ್ರು?
Must be in the morning, 8/1/2014,
Yes,
not in the evening, not 24 hours.
almost close to 24 hours because almost afternoon 1:30 the spot has been 3 to 5
3 to 5 spot inspection.
spot inspection, close to 24 hours. ಯಾವ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ until he gives further statement, nothing has been recorded. Further statement alle he mentioned the name of A5. Then, my lords, page 276, my lord. 276 from the bottom, second line, my lords. ಜನವರಿ ತಿಂಗಳಲ್ಲಿ ನಂದಿ ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿಯಲ್ಲಿ ಕಬ್ಬು ನೂರಿಸುವ ಕಾರ್ಯ ಸಾಗಿರುತ್ತದೆ ಅಂದರೆ ನಿಜ. ನಂದಿ ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿ ದೊಡ್ಡ ಫ್ಯಾಕ್ಟರಿ ಅಂದರೆ ಅಷ್ಟೇನು ದೊಡ್ಡ ಫ್ಯಾಕ್ಟರಿ ಅಲ್ಲ. ಪ್ರತಿ ದಿನ ನಂದಿ ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿಯಲ್ಲಿ 8 ರಿಂದ 10,000 ಟನ್ ಕಬ್ಬು ನೂರಿಸುತ್ತಾರೆ ಅಂದರೆ ಇರಬಹುದು. ಕಬ್ಬು ನೂರಿಸುವ ವೇಳೆಯಲ್ಲಿ ಈ ರಸ್ತೆಯಲ್ಲಿ ತುಂಬಾ ವಾಹನಗಳು ಓಡಾಡುತ್ತವೆ ಅಂದರೆ ರಾತ್ರಿ ವೇಳೆಗಳಲ್ಲಿ ಬಹಳ ವಾಹನಗಳು ಓಡಾಡುತ್ತವೆ, ಹಗಲಿನಲ್ಲಿ ಸ್ವಲ್ಪ ವಾಹನಗಳು ಓಡಾಡುತ್ತವೆ. ಕಬ್ಬು ನುರಿಸುವ ವೇಳೆ ನಂದಿ ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿ ದಿನ 24 ಗಂಟೆ ಕಬ್ಬು ನುರಿಸುವ ಕಾರ್ಯ ನಿರತವಾಗಿರುತ್ತದೆ ಅಂದ್ರೆ ನಿಜ. ವೆಹಿಕಲ್ ಮೂವ್ಮೆಂಟ್ಸ್ ಆರ್ ದೇರ್, collecting blood stain from the spot, and my lords, not clearing the vehicle of Mahindra Max and the two-wheeler from the spot till next day, my lords, it is unnatural. Because traffic movement irutte, ಅಲ್ಲೇ vehicle ಇಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ that could have been not possible. ಎರಡು ವೆಹಿಕಲ್ ತಗೊಳ್ಳೋದಿಲ್ಲ.
ರೋಡ್ ಬಿಟ್ಟು ಬಲಗಡೆ ಅಂತ.
ಇಲ್ಲ, ಬಲಗಲೆ ಅಂದ್ರೆ tractors and all movements will be there. It is unnatural. And the PW 13, my lords, 283, the one who prepared a spot sketch, my lord, engineer, my lords. 284 is his cross-examination, my lords.
They are confronted, see, page 279. PW 5, from, it starts from 278.
Yes.
PW,
ಈ ವಿಷಯವನ್ನು
ಹೇಳಿದ್ದಾನೆ. ತನ್ನ ಹೇಳಿಕೆಯಲ್ಲಿ ಎರಡನೇ ಆರೋಪಿ ಜೀಪಿನ ಹಿಂದಿನ ಗಾಳಿಯನ್ನು ಬಸ್ ಮೇಲೆ ಹೇಳಲಿಲ್ಲ ಅಂದರೆ
ಹಾಯಿಸಿದರೆ ಎಂದು ಹೇಳಿಕೆ ಹೇಳಿಲ್ಲ.
So they confronted.
Confronted.
Next, PW 13.
13, my lords. The engineer who prepared the sketch of the spot, my lords. In page, I'll take your lordship attention to page 284, cross-examination part, my lords. Second para, my lords, from the top, 6th line, my lords. ನಾನು ಗಿಡ ಗಂಟೆಗಳನ್ನು ನಿಶಾನೆ P44 ಅಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಅಂದರೆ ನಿಜ. ಅಲ್ಲಿ ಗಿಡಗಂಟೆಗಳು ಇಲ್ಲದ ಕಾರಣ ನಾನು ನಿಶಾನೆ 44 ಅಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಅಂದರೆ ನಾನು ಅಂತ ಗಿಡಗಂಟೆಗಳನ್ನು 44 ಅಲ್ಲಿ ತೋರಿಸಿಲ್ಲ. ಅಲ್ಲಿ ಮುಳ್ಳು ಕಂಟೆಗಳು ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ಮುಳ್ಳು ಕಂಟೆಗಳ ಬಗ್ಗೆ ಅಷ್ಟಾಗಿ ಗಮನ ಕೊಟ್ಟಿಲ್ಲ. The entire version of the prosecution hiding behind the bush and observing the entire incident, my lords.
Insisting, ಮುಳ್ಳು ಗಂಟೆಗಳು ಇಲ್ಲ.
ಇಲ್ಲ.
Cross examination ಅಲ್ಲಿ are insisting that ಮುಳ್ಳು ಗಂಟೆಗಳು ಇಲ್ಲ.
Insisting. Then, my lords, next witness is next witness is page 286. That is a PSI who registered the FIR, my lords. The SHO, page 288.
Yes, Ramesh Chayagol examined as PW 14.
Like.
Yes, he is the PSI. Yes. Come to his evidence. How in ಹೇಳ್ತಾನೆ ನೋಡೋಣ.
Please. Page 286. Page ದಿನಾಂಕ 31/10/2013 25 ನಾನು ಬಬಲೇಶ್ವರ PS ಆಗಿ ಕೆಲಸ ಮಾಡಿದ್ದೇನೆ. ದಿನಾಂಕ 7/1/2014 ನಾನು ಬಬಲೇಶ್ವರ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ SHO ಕರ್ತವ್ಯದ ಮೇಲೆ ಇದ್ದೆನು. ದಿನಾಂಕ 7/1/2014 ರಾತ್ರಿ 10 ಗಂಟೆಗೆ PW 1 ತಮ್ಮಣ್ಣ ಬಸಪ್ಪ ದಳವಾಯಿ ಇವತ್ತನ್ನು ಬಬಲೇಶ್ವರ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಬಂದು ಲಿಖಿತ ಫಿರ್ಯಾದಿ ಪಡೆದುಕೊಂಡ. PW 1 ಎದ್ದನ್ನು ಕೊಟ್ಟ ಲಿಖಿತ ಫಿರ್ಯಾದಿ ಆಧಾರ ಮೇಲೆ ಬಬಲೇಶ್ವರ ಪೊಲೀಸ್ ಠಾಣೆ ಗುನ್ನ ಸೋ ಭಾರತೀಯ ದಂಡ ಕಲಂ ಸೋ ಅಡಿಯಲ್ಲಿ ಪ್ರಕರಣವನ್ನು ದಾಖಲಿಸಿದನು. ಅದೇ ದಿನ ರಾತ್ರಿ 10:30 ಗಂಟೆಗೆ ಬಬಲೇಶ್ವರ ಪೊಲೀಸ್ ಠಾಣೆ ಸೋ PC ನೆದರ ಮೂಲಕ ಫಿರ್ಯಾದಿ ಮತ್ತು FIR ಅನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕಳಿಸಿಕೊಟ್ಟೆ. ಮೇಲಾಧಿಕಾರಿಗಳಿಗೆ FIR ಕಾಪಿಯನ್ನು ಕಳಿಸಿಕೊಟ್ಟೆ. ಈಗ ತೋರಿಸಿದ ನಿಶಾನ ಪಿಯಲ್ಲಿ ಗುರುತಿಸಿದ ಫಿರ್ಯಾದಿ PW 1 ತಮ್ಮಣ್ಣ ಕೊಟ್ಟಂತೆ ನಾನು ಪಡೆದುಕೊಂಡಿದ್ದೆ. ಈಗ ತೋರಿಸಿದ ಸಹಿ ಅನ್ನೋದು ನನ್ನ ಸಹಿಯನ್ನು ಗುರುತಿಸಲಾಯಿತು. ಈಗ ತೋರಿಸಿದ FIR ನಾನೇ ದಾಖಲಿಸಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕಳಿಸಿಕೊಟ್ಟಿದ್ದೆ. FIR ನನ್ನು P45 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಈಗ ತೋರಿಸಿದ ಸಹಿ ನನ್ನದು, ನನ್ನ ಸಹಿಯನ್ನು 45A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನಿಶಾನೆ P1 ಅನ್ನು ಪಡೆದುಕೊಂಡು ಬಬಲೇಶ್ವರ ಪೊಲೀಸ್ ಠಾಣೆ ಗುನ್ನ 2/14 ಗುನ್ನೆ ದಾಖಲೆ ಮಾಡಿದ ಬಗ್ಗೆ ಗ್ರಾಮೀಣ ವೃತ್ತ CPI ವಿಜಯಪುರ ಇವರಿಗೆ ತಿಳಿಸಿದೆ. ತಡವಾಗಿ ಫಿರ್ಯಾದಿ ಕೊಟ್ಟದಕ್ಕೆ ಫಿರ್ಯಾದಿ PW 1 ಕಾರಣಗಳನ್ನು ತಿಳಿಸಿದ್ದಾನೆ. ಪ್ರಕರಣದ ಮುಂದಿನ ತನಿಖೆಯನ್ನು PW 12 BP ಚಂದ್ರಶೇಖರ್ CPIಗೆ ವಹಿಸಿಕೊಟ್ಟನು. ದಿನಾಂಕ 7/1/2014 PW 12 ನೇದವನ್ನು ನನಗೆ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಆರೋಪಿಗಳನ್ನು ಹುಡುಕಿ ತಂದು ಹಾಜರು ಮಾಡಂತ ಆದೇಶಿಸಿದರು. 17/1/2014 ನಾನು ಮತ್ತು ನನ್ನ ಜೊತೆಗೆ ಪೊಲೀಸ್ ಸಿಬ್ಬಂದಿಯನ್ನು ಕರೆದುಕೊಂಡು ಆರೋಪಿಗಳನ್ನು ಜಮಖಂಡಿ, ಸತ್ತಗುಂಡಿ ಹಾಗೂ ಜಮಖಂಡಿ ತಾಲೂಕಿನ ಕೆಲವು ಹಳ್ಳಿಗಳಲ್ಲಿ ಹುಡುಕುತ್ತಾ ಹೋದೆವು. ಬೆಳಗಿನ ಜಾವ 3 ಗಂಟೆ ವೇಳೆಗೆ ಜಮಖಂಡಿ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಹತ್ತಿರ ನನ್ನ ಪೊಲೀಸ್ ಜೀಪ್ ಅನ್ನು ನೋಡಿ ಒಂದು ಕ್ರೂಸರ್ ಜೀಪು ಕೆಲವರು ಜೋರಾಗಿ ಮುಧೋಳ ಕಡೆಗೆ ಹೊರಟಿದ್ದರು. ನಾನು ಮತ್ತು ಸಿಬ್ಬಂದಿಯರು ನನ್ನ ಜೀಪ್ ನಲ್ಲಿ ಆ ಕ್ರೂಸರ್ ಜೀಪ್ ಅನ್ನು ಬೆನ್ನು ಹತ್ತಿಕೊಂಡು ಹೋಗಿ ನಿಲ್ಲಿಸಿದೆವು. ಸದರಿ ಕ್ರೂಸರ್ ಜೀಪ್ ನಲ್ಲಿ 5 ಜನರು ಇದ್ದರು. ನನಗೆ ಸಂಶಯ ಬಂದ ಕಾರಣ ಕ್ರೂಸರ್ ಜೀಪ್ ನಲ್ಲಿದ್ದ 5 ಜನರಿಗೆ ವಿಚಾರಿಸಲಾಗಿ ಅವರು ತಾವು ಸತ್ತಗುಂಡಿ ಗ್ರಾಮದವರು ಇದ್ದೇವೆಂದು ಹೇಳಿ 7/1/2014 ಪ್ರಕರಣದಲ್ಲಿ ಕೊಲೆ ಆದ ಬಗ್ಗೆ ಮಾಹಿತಿ ನೀಡಿದರು. ಸದರಿ 5 ಜನರೇ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಕೊಲೆಗೆ ಸಂಬಂಧಿಸಿದ ಆರೋಪಿಗಳೆಂದು ಖಚಿತವಾದ ಮೇಲೆ 5 ಜನರನ್ನ ವಶಪಡಿಸಿಕೊಂಡು ಬಂದು PW 12 ನೇದರ ಸಮ್ಮುಖದಲ್ಲಿ ಅವರ ಕಚೇರಿ ಹಾಜರುಪಡಿಸಿದನು. ಈಗ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ 1-5 ಆರೋಪಿಗಳಿಗೆ ನಾನು ಮತ್ತು ನಮ್ಮ ಸಿಬ್ಬಂದಿಯರು ಅದೇ ದಿನ ಅವರಿಗೆ ಹಿಡಿದುಕೊಂಡು PW 12ರ ನೆದರ ಮುಂದೆ ಹಾಜರುಪಡಿಸಿದ ಆರೋಪಿಗಳು ಇದ್ದಾರೆ. 1-5ನೇ ಆರೋಪಿಗಳು ಅವರನ್ನು ನಾವು ಹಿಡಿದ ವೇಳೆಗೆ ಅವರು ಪ್ರಯಾಣಿಸಲು ಉಪಯೋಗಿಸುತ್ತಿದ್ದ ಕ್ರೂಸರ್ ಜಿಮ್ ಸೋ ಅಂಡ್ ಸೋನ್ ಇದನ್ನು ಸಹ ಆರೋಪಿಗಳ ಸಮೇತ ತೆಗೆದುಕೊಂಡು ಬಂದಂತೆ PW 12ರ ನೆದರ ಸಮ್ಮುಖದಲ್ಲಿ ಅವರ ಕಚೇರಿಯಲ್ಲಿ ಹಾಜರುಪಡಿಸಿದೆವು. ಈ ಬಗ್ಗೆ ನಾನು PW 12 ನೆದರಿಗೆ ವರದಿ ಕೊಟ್ಟಿದ್ದೇನೆ. ಈಗ ತೋರಿಸಿದ ನಿಶಾನೆ P27 ಗುರುತಿಸಿದ ವರದಿ ನಾವು PW 12 ನೆದರಿಗೆ ಕೊಟ್ಟದ್ದು ಇದೆ. ಈಗ ತೋರಿಸಿದ ಸಹಿ ನನ್ನದು. ನನ್ನ ಸಹಿಯನ್ನು ನಿಶಾನೆ P27B ಎಂದು ಗುರುತಿಸಲಾಯಿತು. Then my lords, in the same paragraph notes, cross examinations. ನಿಶಾನೆ P1ರಲ್ಲಿ ಗುರುತಿಸಿದ ಫಿರ್ಯಾದಿಯನ್ನು ಕೊಡಲು PW 1 ತಮ್ಮಣ್ಣ ಒಬ್ಬನೇ ನನ್ನ ಚೇಂಬರ್ನಲ್ಲೇ ಬಂದಿದ್ದನು. ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೊರಗಡೆ ಆ ವೇಳೆಗೆ ಜನರು ಇದ್ದರು. PW 1 ತಮ್ಮಣ್ಣ ಎಕ್ಸಿಬಿಟ್ P1ರಲ್ಲಿ ಗುರುತಿಸಿದ ಫಿರ್ಯಾದಿಯನ್ನು ಬರವಣಿಗೆಯಲ್ಲಿ ಬರೆದನ್ನು ನನಗೆ ಕೊಟ್ಟನು. PW 1 ತಮ್ಮಣ್ಣ ನಿಶಾನೆ P ಅನ್ನೋ ವಿಷಯವನ್ನು ಎಲ್ಲಿ ಕುಳಿತು ಬರೆದಿದ್ದಾನೆ ಅಂದ್ರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಿಶಾನೆ P1ರಲ್ಲಿ ಫಿರ್ಯಾದಿಯನ್ನು ಕೊಟ್ಟ PW 1 ಘಟನೆ ಈ ರೀತಿಯಾಗಿದೆ ಎಂದು ನಿಶಾನೆ P1ರಲ್ಲಿ ಬರೆದಂತೆ ವಿಷಯವನ್ನು ಮೌಖಿಕವಾಗಿ ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಹೇಳಿದನು. PW 1 ನೇದನ್ನು ಮೌಖಿಕವಾಗಿ PW 1ರ ವಿಷಯವನ್ನು ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಹೇಳಿದ ವಿಷಯವನ್ನು ನಾನು ಸಿಡಿಯಲ್ಲಿ ಬರೆದಿಲ್ಲ. FIR, ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ನೋಟ್ಸ್. FIR ಅನ್ನು ದಾಖಲಿಸಿದ ನಂತರ ನಾನು ತಕ್ಷಣ ಗುಣಸ್ಥಳಕ್ಕೆ ಹೋಗಲಿಲ್ಲ. ಗುಣದಾಳದಲ್ಲಿದ್ದ ಔಟ್ಪೋಸ್ಟ್ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಫೋನ್ ಮಾಡಿ ಅಲ್ಲಿಯ ಪೊಲೀಸರಿಗೆ ಗುಣಸ್ಥಳಕ್ಕೆ ಭೇಟಿ ಕೊಡಬೇಕೆಂದು ನಾನು ಹೇಳಿಲ್ಲ. ದಿನಾಂಕ 7/1/2014ರಂದು ಸುಮಾರು 11:30 ಗಂಟೆಗೆ ರಾತ್ರಿ PW 12 ನೆದರ್ಗೆ ಫೋನ್ ಮೂಲಕ ವಿಷಯ ತಿಳಿಸಿದನು. ಆ ವೇಳೆಗೆ PW 12 ನೆದರು ವಿಜಯಪುರದಲ್ಲಿ ಇದ್ದರು. ರಾತ್ರಿ 11:30 ಗಂಟೆಗೆ PW 12 ನೆದರು ಬಬಲೇಶ್ವರ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಬಂದರು. ಯಾವುದೋ ಪತ್ತೆಯಾಗದ ವಾಹನ ಮೃತರಂಗವ ಬಸಪ್ಪ ಇವರಿಗೆ ಅಪಘಾತ ಪಡಿಸಿ ಅವರ ಮರಣಕ್ಕೆ ಕಾರಣವಾದ ವಿಷಯ ಗೊತ್ತಿದ್ದರೂ ಸಹಿತ ಇದರ ಮಾತು ಕೇಳಿ ಆತನ ಸುಳ್ಳು ಫಿರ್ಯಾದಿ ವೇಳೆ ಸುಳ್ಳು FIR ದಾಖಲಿಸಿದೆ ಅಂದ್ರೆ ನಿಜವಲ್ಲ. He did not even go to the my lord's spot. He informed the PW 12. Even arrest also morning 17 ಇದೆ 3 ಗಂಟೆ ಅಂತ 9 ಗಂಟೆ ಆಗಿದೆ 9 ಗಂಟೆ ಇದೆ ನೋಡಿ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ದಸ್ತಗಿರಿ ಅದರಲ್ಲಿ ಇಲ್ಲಿ ಸರ್ ಎಲ್ಲಿದೆ ಸರ್ 27 ಇಲ್ಲ ಸರ್ ಅದೇ ಹಾ ರಿಪೋರ್ಟ್ 110 ನಾನು ನೋಡಿ ರಿಪೋರ್ಟ್ ಇಲ್ಲಿ Yes, 9:14. ಎಷ್ಟು ಗಂಟೆಗೆ ಅಂತಾರೆ 3 ಗಂಟೆಗೆ ಅಂತಾರೆ ಬಟ್ ಇದು ಬೇರೆ ಇದೆ ನೋಡಿ ಸರ್ ಇದು ನೋಡಿ ಸರ್ ರಿಮೈಂಡ್ ಅಪ್ಲಿಕೇಶನ್ 9 ಗಂಟೆಗೆ ಹಿಂಗಿರ್ಬೇಕು ಇದೆ
Whether he is in service, SPP, PSI and PI, they are in service still?
PSI is in service, my lords, but PI I don't know. I'll shall I call him?
Get the information.
Yes. Yes, day after tomorrow.
Why they not visited? Why he has not? Not visited?
10:30. 11:30, he informed to PW2. PW2 came to the Bableshwar police station and he informed to this PW14 to trace out the accused and the vehicle.
Before tracing out the accused, at least he has to visit the spot.
Yes, my lord, because of,
4:30 incident happened.
yes,
So 4:32 till 10:30, they were
10:30.
there in the spot. It's a
10:30.
double murder.
Yes, my
That
lord.
too in a highway, in a road, busy road.
Easy road.
And that too, my lord,
So nobody visited the spot. So you have not received any information till 10:30. Is it so? You have not received any information.
there must be, my lords.
Huh?
They might have
Even
received
after
that
receiving information also, you are not ventured to go there,
because,
visit the spot.
because there is a outpost also. my lords.
Now, who shifted the dead bodies
That is
to
not,
the
so.
hospital?
That has not been narrated in the entire evidence, and I'll once again check. Day after tomorrow, my lords. I'll call him and take all the information. And also, my lords, even but by 11:30 PW12 has come to the Publisher police station. He would have visited the spot, my lords. But next day morning at 1 o'clock, directly he went over there and conducted spot panchana. After recording the further statement of the PW1.
Further statement all been recorded at the spot next day afternoon. All witnesses statement recorded.
When they went over, they called it to police station and thereafter they recorded inside spot. Conducted spot.
Beside evidence and merits of the case, in this case, we will pass some orders in respect to your officers are concerned. The manner in which they casually conducted the investigation in a double murder, we will take a serious note of that.
My first submission would be, my lords, the another injured Pooja, she would have been cited as a witness. Of course, there is no cross-examination pertaining to that aspect, my lords. Even defense has not suggested that is different. But as far as prosecution is concerned, she would have been narrated as in charge sheet witness or else. She has not been narrated as in charge sheet witness. Even she was injured on that particular incident.
See, this is if this is the conduct of the police officials, your officials.
Yes,
then
madam.
you'll be
And so
unlucky.
many
ನೀವು
cases.
ಸಮಾಜ ಹಾಳು ಮಾಡ್ತೀರಿ ನೀವು.
Okay.
Page 114, Lordship may kindly look at exhibit P27, the report which is given by this 14 to PW12, my lords. Arrest of accused.
40 page.
114, 114, my lords. ತಮ್ಮ ಆದೇಶದಂತೆ ನಮ್ಮ ಠಾಣೆಯ ಗುಣ ಸೋ ಅಂಡ್ ಸೋ ಕಲಂ ಸೋ ಅಂಡ್ ಸೋ ಅಲ್ಲಿ ಪರಾರಿ ಇದ್ದ ಆರೋಪಿತರಿಗೆ ತಂದು ಹಾಜರುಪಡಿಸುವಂತೆ ಈ ಮೊದಲು ತಿಳಿಸಿದ ಪ್ರಕಾರ ಆರೋಪಿಯನ್ನು ತಪಾಸು ಮಾಡುತ್ತಾ ಇದ್ದಾಗ ಈ ದಿವಸ ನಸುಕಿನ ಜಾವ 3 ಗಂಟೆ ಸುಮಾರಿಗೆ ಜಮಖಂಡಿಗೆ ಹೋದಾಗ ಅಲ್ಲಿ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಹತ್ತಿರ ನಮ್ಮ ಸರ್ಕಾರಿ ಜೀಪ್ ಅನ್ನು ನೋಡಿ ಒಂದು ಕ್ರೂಸರ್ ಜೀಪ್ ಜೋರಾಗಿ ಮುದೋಳ ಕಡೆಗೆ ಸಂಶಯಾಸ್ಪದ ರೀತಿಯಲ್ಲಿ ಹೊರಟಿದ್ದು ಅದರ ಬಗ್ಗೆ ಸಂಶಯ ಬೆನ್ನು ಹತ್ತಿ ಹೋಗಿ ವಾಹನ ನಿಲ್ಲಿಸಿ ಒಳಗಡೆ ಇದ್ದವರನ್ನು ನೋಡಿ ವಿಚಾರಿಸಲು ಅವರು 5 ಜನರಿದ್ದು ತಾವು ಸತಗುಂಡಿ ಗ್ರಾಮದವರು ದಿವಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ಸುಮಾರಿಗೆ ನಂದಿ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಸ್ಕೂಲ್ ಹತ್ರ ರಂಗವ ದಳವಾಯಿ ಮತ್ತು ಆಕೆಯ ಗಂಡ ಬಸವ ದಳವಾಯಿಗೆ ತಾವೇ ಕೊಲೆ ಮಾಡುತ್ತಾ ಅಂತ ತಿಳಿಸಿದ್ದು ಅವರ ಕೊಲೆ ಮಾಡಿದ ಬಗ್ಗೆ ಖಾತ್ರಿ ಆಯಿತು. ಕಾರಣ ಅವರ ಜೀಪ್ ಸಮೇತ ಈ ದಿವಸ ನಸುಕಿನ 5 ಗಂಟೆಗೆ ಕಾರ್ಯಾಲಯದಲ್ಲಿ ಮುಂದಿನ ಕ್ರಮ ಕುರಿತು ತಂದು ಹಾಜರುಪಡಿಸಿದ್ದು ಅವಕಲನ ಮಾಡಲು ವಿನಂತಿ ಇದೆ. He did not even mention who were 5 minutes. Name of the accused also he did not even mention in report. Vehicle number also not been mentioned.
It has been narrated that there is no number of that particular vehicle by that
Reported.
time.
After arrest of the accused, you commence the investigation.
Yes.
Yes. Now. Yes, Sanjay, what are the
Please.
bullet points in ಹೇಳಿ ನಿಮ್ದು?
Let's though my lords, the PW5 my lords may make it a chart and submit it my lords. Shall I mention it orally? My lords?
Yes, just you can say.
Please. Though my lords,
Short as bullet.
please. Though my lords, PW5 was very much available on the spot when the PW1 had come to there, my lords. PW
PW5 is a planted witness.
Yes,
according-
yes. He is a
Hmm.
planted eyewitness to the incident, my lords.
Hmm.
Though he was very much available on the spot, he is a close relative of the deceased. He informed the PW1, but he did not, my lords. Though in spite of that, my lords, the PW1 did not mention the name of A5 in the exhibit P1, my lords.
Hmm.
And my lords, second,
PW1 not stated,
in a
PW6 also.
Six-
PW1
one did not mention name of A5
mention the name.
in exhibit P1 complaint.
Hmm.
And second, my lords,
Mention the presence of PW5.
5,
Hmm.
A5, presence of A5 in the alleged crime. my lords.
PW5.
5,
PW.
Yes.
So PW5 must be planted witness.
yes,
That is one aspect.
yes.
Hmm.
So he is very close relative, my lords. He did not make any venture to call the PW1. Though Kalmesh has taken, my lords, the phone from the tractor driver, he called it. Not, my lords, giving any call informing the relative from the PW5 is, my lords, doubtful.
Hmm. Hmm.
And second thing, my lords, the tractor driver, my lords, who helped this PW6 to call PW1 has been not examined by the prosecution to show the chain
Hmm.
of circumstances that
Not cited,
not cited,
cited as a charge sheet witness.
charge sheet witness.
Hmm.
And my lord, as per the evidence of PW1,
Hmm.
5, 6, and 7,
Hmm.
the PW1 and Seychelles went along with the PW6 to the hospital.
PW1 and
5, 6, and 7.
PW1 and Srishaila PW1
Yeah, 1
and
and
Seychelles.
Seychelles,
Went along with the PW6.
6 to the hospital.
Hmm.
But that is very much contrary to the evidence of doctor, who would say that it is the only PW1, PW6, Kalmesh, and 1 Seychelles had visited the hospital.
After PW9,
Yes, my lord. PW9, my lord.
PW9. According to him, PW6 and
PW6 and 1 Seychelles, not cited as a charge sheet witness. And as per the case of the prosecution, as per PW1, 5, 6, 7, the PW went along with the my lord's hospital, but as per the doctor, it is failed. He is not present in the hospital. Neither he went to the my lord's to register in a complaint, nor he was with the Kalmesh. That gap is, my lord, that's inordinate and deliberate gap to falsely implicate this accused with the help of PW5. That is one of ground, my lords.
delay in FIR
Yes, my lords.
for the genesis of the case.
Genesis of the crime, my lords. And he had an opportunity to register at Gundal. He crosses Gundal police station outpost and Bableshwar police station, though it was available on the side of the road, did not make an venture to register it, my lords. And my lords, not producing the my lords RC details, vehicle details of the either of the vehicle from the both side by the prosecution is fatal to the case of the prosecution to establish their case that these all 5 accused, my lords, with the help of cruiser, we have, my lords, committed the murder of deceased.
Yes.
That did not establish that that belongs to us. And my lord, so far recovery is
Motorbikes.
MEA report also.
Cruiser and motorbikes.
Pardon, my lord.
Cruiser ಮತ್ತು bikes.
Bike, cruiser, Mahindra Max vehicle, and 2 bikes. One belongs to the accused, one belongs to the deceased. And MEA report that should have been produced, that did not do so. And while recovering, my lord, they have not produced any document to show that house from where it has been recovered. They have not produced any document at the khata extract to show that that house belongs to the accused.
That is not required. Accused presence is sufficient. Whether accused is shown the place, need not be a place of accused, the house of accused, from anywhere. 27.
ಅವ್ರ ಮನೆ ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ಪೆಸಿಫಿಕ್.
ಅಲ್ಲ ಮನೆ ಅಂತ ಹೇಳ್ತಾರೆ ಸಾಕಲ್ಲ 27 ಏನ್ ಬೇಕು ಸೆಕ್ಷನ್ 27 ಏನ್ ಬೇಕು ರಿಕವರಿ ಅಷ್ಟೇ ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ಎಸ್ ನೆಕ್ಸ್ಟ್
Next, my lords,
PW6
6.
PW Kalmesh.
Kalmesh.
PW 5.
Six, sir.
PW 6.
Yes, my lords.
Uh.
Non-examination of the puja,
Hmm.
though he was shown to the doctor,
Hmm.
not producing the MLC is also fatal, my lords. Yeah.
Non-examination of puja.
Puja, because she has been mentioned in FIR exhibit P1 ಅಲ್ಲಿ ಇದೆ ಅವಳದು.
Madam, PW 6 evidence again, ಏನ್ ಹೇಳ್ತೀರಿ?
Six, my lords, the moment he has been shown to the doctor, three things, my lords.
Hmm.
One, he said that he witnessed the entire incident
Hmm.
by hiding behind the bush.
Hmm.
As per exhibit, my lords, sketch map, that falsify the case of the PW 6, saying that he hid behind the bush because there was no bush at all.
Hmm. PW 13, huh?
Yes,
Who states that?
that is 13. ಲಕ್ಷ ಇಲ್ಲಿ ಇದ್ರಲ್ಲ ಎಕ್ಸಿಬಿಟ್ ಇದ್ರಲ್ಲಿ ಸ್ಕೆಚ್ ಮ್ಯಾಪ್ ಅಲ್ಲೂ ಇಲ್ಲ. ಇವನ್ ನಾವು ಅದರ್ವೈಸ್ ಎವಿಡೆನ್ಸ್ ಲಕ್ಷ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಲ್ಲ, ಇಲ್ಲ ಅಂತಾನೆ ಹೇಳ್ತಾರೆ. ಟೇಕ್ ಯು ಲಾರ್ಡ್ಶಿಪ್ ಟು
PW 13.
13
SPP.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಲಾರ್ಡ್ಸ್. ಲಕ್ಷ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಆಮೇಲೆ ಹೇಳ್ತಾರೆ, ಬಟ್ ಇಲ್ಲವೇ ಅಂತ ಹೇಳ್ತಾರೆ. ಇವನ್ ಸ್ಕೆಚ್ ಆಲ್ಸೋ ಶೋಸ್ ದಟ್ ದೇರ್ ಇಸ್ ನೋ ಬುಷ್ ಅಟ್ ಆಲ್.
PW 13 ಹೇಳ್ತಾರಲ್ಲ 284 ಅಲ್ಲಿ ಪೇಜ್. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್. No bush ಒಂದು.
No bush was there.
Hmm.
And my lord, though PW 5 was available on the spot immediately after the incident, he was witness to the eyewitness to the incident, but PW 6 did not seek any help from the PW 5 to inform PW 1. That is suspicious. Our relation and bitu has taken somebody's help who is not known to them.
PW 6 would have accompanied PW 5 ಅಂತ ಹೇಳೋದು.
ಇಲ್ಲ, ಅವ್ರ ಹೆಲ್ಪ್ ತಗೊಂಡು accompanied as well as he could taken the help of PW 5 to inform his PW 1.
Phone.
Yes. ಅವರಿಗೆ PW 1 inform ಮಾಡಕ್ಕೆ ಟ್ರ್ಯಾಕ್ಟರ್ ಡ್ರೈವರ್ ಇಂದ ತಗೊಳ್ಳೋ ಬದಲು he could have taken the help of PW 5 if at all PW 5 was there. And my lords, the first version of the PW 6 before the doctor, even after inquiry, he says that it is a road accident as per the evidence of the doctor. Because doctor inquired that Kalmesh, what happened on the case, it is caused due to fell from the vehicle.
But his evidence doesn't say something else regarding nature of injury. It says it cannot be caused by road accident.
Yes.
Yes.
And not producing that MLC of Kalmesh in a prosecution paper is totally fatal, my lords. And the police ಇಲ್ಲ ಇದು MLC ಇದೆ. ಅದರಲ್ಲಿ ಮೆನ್ಷನ್ MLC ನಂಬರ್ has been mentioned in exhibit P20 wound certificate ಅಲ್ಲಿ. That is not part of the proceedings.
Next.
And though he has mentioned, PW1 mentions that prior to the incident, my lords, his father, deceased Basappa, has called him over phone. Naturally, my lords, phone should have been fell on the ground. No recovery from the spot of a phone. From the spot, neither from the inquest Mahajar, my lords. If it should have been in a pocket, should have recovered it. Nothing has been traced out, my lords.
ನೋಡಿ ಅವ್ರು ಮಾಡ್ಲಿ, ಮತ್ತೆ ನೀವು ಉಳಿದ್ರೆ ಏನಾದ್ರು ಹೇಳಿ.
Please.
Yes, sir. Start.
Citations.
Next ಯಾರು ಮಾಡ್ತೀರಿ? ಮಾಡಿ start ಮಾಡಿ.
Citations, I'll
Yes,
just
yes.
leave it.
My friend has covered everything, Milan.
Yes. You adopt the same, huh?
Yeah.
Yes, yes. ಸತ್ಯನಾರಾಯಣ ಸರ್, ನೀವು ಕೂಡ ಹೇಳ್ಬಿಟ್ಟು
One last.
ಮುಗಿಸ್ಬಿಡೋಣ ಇವತ್ತು ನಿಮ್ಮ ಸೈಡ್. ನಾಳೆ SPP ಕೇಳ್ಬಿಟ್ಟು ಮುಗಿಸ್ಬಿಡೋಣ.
One last submission so far. So for PW6 is concerned, my lord, mentioning the name of each and every vote tax on the deceased, my lord, by hiding behind the bush as a kid, 8-year-old. Verbatimly, it is not possible at all. That to such a conditions, my lord, because his grandfather have been attacked. Ella kutkondo as it is, he mentions like A1 assaulted with the A2 assaulted. That is absolutely, it is quite unnatural. That is also one of grounds. It is possible only when, my lords, in a case of false implications,
Tutoring.
tutoring.
Yes. You just state you, this, argue your points, ಅಷ್ಟೇ ಸಾಕು. Evidence ನೋಡಿದ್ದೀವಿ.
Yes, ma'am. I'll just refer to the part of the, some of the part of the investigation also. Reason being that concerning to my client, accused number 4, involvement in totality, where things have gone wrong and whether it's a case for, could have been a case for conviction or not, first thing. And we are in appeal assailing that. Now, first and foremost thing is that there was an enmity between the parties on account of the civil litigation. That civil litigation, it is daughters, that is deceased Rangava and her sister had filed a suit as against their father. The accused 1, 2, 3 were not at all in picture in that litigation. That litigation ended in disposal of the RSA of 2439 of 2005 in on 19 January 2006 as per Exhibit P4. Now thereafter, that virtually culminated the litigation. Well, what they say is there was a strained relation. Accepting that also, admittedly, the accused family 1 to 3 are residing in a different village, and the complainant and others are residing in another village. Disputed property is situated in another village, Kambagi, 2, 3 different places. It is not their case that now and then there used to be interference by these accused after the death of their father at Kambagi in cultivation of the land. Therefore, that enmity, whatever they said, that terminated, and they had an occasion to see one another. More particularly, this PW5 Kalmesh. Kalmesh is 8 years then. The litigation itself ended more than 8 years back. Not that they used to come for social functions, that we had that meeting, and this PW5 Kalmesh had the occasion to see any of these accused. Because he names, by identification, he names every one of them and also says about their overtax plate.
Had no occasion.
No occasion, absolutely. It is not disclosed in the complaint. My lordship has said while inquiring, because other witnesses come under section 6 based on the statement of this accused number, PW5. If that were to so, say, lordship, he must have personal knowledge about the persons involved in that. And I had seen them. I had an occasion. There used to be a social gathering. They used to come to our house, etc. Nothing of that sort. Now, this is one strong circumstances. Now, coming to the in crime itself, now what they say, there was a conspiracy. For that enmity, they say they had a conspiracy. Accused themselves had a conspiracy at a particular place where, as shown, alleged to have been shown by them, and the note Panchanama has been drawn as per Exhibit P19 in the house. Now again, accused number 1 to 3 are from one place, and accused number 4 and 5 are another village. Conspiracy, how long it was going on? And conspiracy for this incident more particularly, what PW1 says, that in the morning on the 5/1/2014, he had received a phone call from his father to his 2 SIM numbers, that which has been elicited in the evidence of PW1, 5/1. And on 7/1, again, his father called him, Basappa, deceased Basappa called him, saying that they are leaving the Hanmageri to come over to Gundal. Now, the so-called conspiracy, are they going over to Hanmageri? Are they leaving Hanmageri and coming towards this particular road to reach to their destiny of Gundal? Was known to the accused persons, and they had formed a conspiracy meeting on anywhere in between 5/1 to 7/1. Nothing is there on record. Now that conspiracy suspect
falling short of this annuity, forgetting for this annuity, this conspiracy aspect also goes away. Now, actually coming back to the crime itself, what they say that
It's
they,
not the case of prosecution that there is following the
yes,
decision, following the decision.
or through anybody, they got the information
Hmm.
that these people are moving from this road.
Hmm.
So let us come together, have a meeting and do something.
Hmm.
There is no meeting of mind
Hmm.
prior to the incident,
4 and 5 from different village, 1, 2, 3 different village.
different village.
Hmm. Hmm.
Yes, no person has been examined from either of the village
Hmm.
or from the Hanamagiri to say that the coming over to the deceased and his grandchildren coming over to Hanamagiri was known to accused, or they leaving the Hanamagiri on that particular 7-1 was that message was flashed to these accused.
Hmm.
They in turn had a meeting
Hmm.
and then they did this act.
Hmm.
So as to appreciate the evidence of PW5. PW5, to say that PW5 had met this man at Galgali, Pig Gully. What he says, he met them in front of a Kirana shop as they had stopped for purchasing Kirana. And then they left. Now, if we come to the crime and forget, let us accept that whatever has happened at the crime and there was a death, whether it is due to accident or homicidal death. Now, all of them fell down. And they were they were tossed. What his PW5 says, they were tossed due to the dash with that speed.
Impact.
They were tossed and everything fell down and the vehicle also fell down. They were that grocery items.
No, that is the evidence of PW 5 or 6, some biscuit packet and other things were there in the spot,
That is missing.
That is what, yes.
That is missing in the
cross examination
No,
itself.
no, spot Panchanama.
Spot Panchanama.
Spot Panchanama.
PW 5 state.
No.
Biscuit packet mattu matin something, huh? Something there on.
Spot Panchanama, nothing is there.
Yes.
On the contrary, in the spot Panchanama exhibit P10, the prosecution has elicited from the cross-examination of PW2 to say that what has been written, particular portion written in the Panchanama is wrong. That is one of this.
Even otherwise, there is no such hard and fast rule that they have to purchase something.
Certainly not. Certainly, I am not coming. Sante ಮಾಡಿದ್ರು ಅಂತಂದ್ರೆ ಸಂತೆ something. Yes.
Purchase.
Even forgetting that. Now, what PW1 says, he received phone call from his father both on 5-1 and on 7-1. That goes to show that phone was with deceased Basappa. That phone is not recovered either from the spot or during the course of inquest from his body person.
The case of PW5 there, tractor now in the phone ಮಾಡಿದೆ ಅಂತ.
ಅದೇ ಹೇಳ್ತಾ ಇರೋದು ನಾನು. deceased ಹತ್ರನೇ phone ಇತ್ತು. PW1 says on 5-1 also he received phone call from his father. 7-1 means before leaving Hanmagiri he called and informed that they were leaving. So phone was with Basappa. That phone, of course, yes, that is not recovered. My submission is that, Lordship, that this PW1, in addition to saying that he came to know about the crime through PW5 Kalmesh, he had also information through his father that they are living from Hanmagiri. It is not there. So this is all cooked up story.
Along with Puja.
Puja is not neither cited nor examined. And she is shown to have been examined by the doctor, but that material evidence is not placed before the court for the best reasons known to the prosecution. Not only that, the doctor has specifically said that he informed the concerned police. Concerned police came and recorded the statements of both Kalmesh and Srishal. Srishal Sadap Gold. Why that is suppressed? It might not have led to anything, but why that is suppressed? That gives an indication that the police all the while knew about this accident. They kept quiet till 10:30 to deliberate things. To create perfect complaint of the requirement of PW1. PW1 in his evidence says he went to Galgali for immediate attention, giving attendance to Kalmesh injuries. But other witnesses do not say it. PW, again, he says that he allowed the PW1 5 Kalmesh to be in Bijapur hospital along with another person attendant, but he came back. Where he went then, if he had left Galgali itself, why did not go to police station immediately? What was necessity for him to wait for all up to 10:30? Now, even apart from that, now in the PW5 himself in the chief, at one point, he says that the police, he says that up to 10 p.m. I was there. Your Lordship, kindly see in the first paragraph of the chief examination, he narrates all details of his relationship with the deceased and that of the accused. He's so close to the family, both family. Very unfortunately, he doesn't bother to take care of the deceased, forgetting for a moment that at the time of assault, he may have in fear psychosis. After that, he up to 10 p.m. he's there. He doesn't bother to care about the dead bodies. He leaves that place at 10 p.m. and on the way, he meets so many people and informs. In the family, after going to his house, he doesn't inform his own family members about the death of his own relatives. And next 2 p.m. till police, what he says, till police called him, he did not make a reference of it anywhere. So if the police had not come, probably he would not have gone at all to the spot. So this creates doubt and shows, clearly demonstrate that systematic knitting work has been done right from the beginning of the crime. Now, thereafter, now coming back to the last portion of the investigation is, as I already intervened with, I may be excused for that while my friend was arguing now and then I was intervening. PW12, PW14, Ramesh Shahagol, he is specific that PW1 came to police station at 10:30 p.m. and received written complaint. He registered it and sent FIR as per exhibit P45. He is also very specific, but by immediately after that, he informed the PW14 who was then at Bijapur. Sorry, PW12 CPI who was at Bijapur. He immediately came to Bableshwar police station. Neither this PW14 PSI makes any arrangement to take the dead bodies, shift the dead bodies from that place and protect the scene of incident by deputing anybody. He never even, he doesn't inform the any of the outpost police station. PW 12 in his cross-examination.
Who is the guard watches the dead body?
Lordship?
Dead body watch ಮಾಡಿದ್ಯಾರು? Who is the guard?
Yeah, nobody was there. ಯಾರು ಶಿಫ್ಟ್ ಮಾಡಿದ್ರು ಏನಿಲ್ಲ. PW5 ಒಂದ್ ಕಡೆ ಹೇಳ್ತಾರೆ 7:07 ಪೊಲೀಸರು ಬಂದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾರು ಹೇಳಿಲ್ಲ. PW1 doesn't know. PW14 PSI doesn't know who shifted the dead bodies. PW12 second IO of the rank of CPI, he doesn't know who shifted. He says that immediately after receiving information on the next day at 6 a.m., he directly went to Vijaypur hospital, government hospital, and conducted the inquest Panchanama between 7:30 to 10. And they made arrangement to shift the dead bodies to another hospital. What was the reason for that shifting? That has been cross-examined. He knows that there are doctors in the government hospital to conduct the inquest. It is not that it was taken in the night. There was not sufficient light or or there was some other infirmities in the government hospital to shift the dead bodies to another hospital.
Non-availability. Must be non-availability of the doctor.
Everything has to be now assumed so. It is not
Who has conducted the now PM?
A PM is conducted by another doctor in the Al-Amin Medical College Hospital. He was not there. When PM was conducted, he was not there. He was all along free. He visits, he says that I visited the spot thereafter, shown by PW1. Now, during the course of inquest, PW1 statement is not recorded. It's only that of Kalmesh, as already recorded, column number 4, and another lady, Kalmesh mother. In fact, PW2, who happens to be punch witness to the spot panchama, is also witness to the inquest. Inquest of that of Basappa. He is not in fact punch witness to the inquest of Rangama, but his signature is there. His name is not there. That is admitted in the cross-examination.
That is sufficient.
That of course we are not disputing the identity of the dead bodies for that matter, or of the injuries that were caused. Now, with all this cumulative effect of this, my submission is that whether there was any. Now, another point is the PW9 doctor has said that he referred Kalmesh to government hospital Vijaypur. Vijaypur doctor has not been examined. Whatever report that is forwarded to him, that report along with his own certificate is produced and placed at exhibit P20. Now already that point has been.
Certificate of Kalmesh.
Kalmesh.
The author of exhibit P20 some other.
No, ಇವರೇ ಅವ್ರದ್ದು ರಿಪೋರ್ಟ್ ಬಂದ ಮೇಲೆ ಇವರು ಅದನ್ನ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವರು ಕ್ರಾಸ್ ನಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. After my intimation to the police of Galgali outpost, police station police had come to me at PHC Galgali. The Galgali outpost police station police inquired to Srishal Sadgopal and injured Kalmesh. After 2014, this incident take place. PW5 is examined. PW5, Kalmesh, date of examination. 11-1, PW6, Kalmesh. He is examined before the court on 12-1-17.
Who examined?
Kalmesh is examined before the court after 3 years. On that day, his statement has been recorded by the police, according to the doctor, PW9. If really his memory was so strong, or that there is a material evidence to show that he knew all these accused persons by name and be able to identify them and who played what overt act in committing this offense, then definitely that statement should have been there. One recorded by the outpost police. That has been suppressed. Now, in the absence of object, what importance can be attached to the evidence that he has given after 3 years?
What about his statement on 8-1?
That is there. But why that statement is suppressed? Definitely it must have been something different than what has been stated here.
Statement is fixed.
No, sir. Lordship.
Statement of Kalmesh.
Statement of Kalmesh recorded by PW12 later on.
Statement recorded on 8-1 only.
8-1. That's on 7-1 also there is a statement.
Yes.
7 also there is a statements as admitted by PW. There is no cross-examination to this PW9 saying that you are falsely deposing by the prosecution. Is not treated as hostile. Then while that suppression, in the absence of that statement, what this is to be, what is the information that can be drawn? He's perfectly tutored witness. Not a piece of paper is produced to show that at any point of time after his birth till this incident, he had an occasion to see all these accused at any point of time in any social gathering for that.
Did require.
No, he must.
They are close relatives.
Lordship, my submission is not that they are residing in the same village.
That is there, but it is your admitted case that they are the close relatives.
No, maybe. What about this PW8 for 6? Kalmesh.
Civil, according to you only, civil dispute after it's attained finality, culmination, all the, it's over. Now they were both the accused and deceased were in good terms.
No,
So that is your case only.
no, my
It's your
sir.
case.
Enmity ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ನಮ್ enmity ನಾವು ಬೇರೆ village ನಾಗ we have never thought of that earlier litigation. We have forgotten that litigation. They had no connection at all. Particularly about PW6, I am saying. PW1, of course, he might have had an occasion to see many times. But this PW6, because it is PW6 based on his statement, the entire case is developed. If evidence of PW1 and that of PW7 Malaysia, and for that matter, even PW8 Rangangoda is to come under the parameters of section 6. That we must ensure, the prosecutor must say that this PW6 had definite knowledge and information about the who is who.
That is there. He is a stranger. When they are close relatives.
No, sir, lordship. Relatives ಎಲ್ಲರೂ ಇರ್ತಾರೆ, relatives ಇದ್ದಾರೆ. ನನಗೆ ಗೊತ್ತೇ ಇಲ್ಲ, ಪರಿಚಯ ಇಲ್ಲ. I had no occasion to see them.
Relative ಗೆ ಒಬ್ಬ 7-year, 8-year boy ಗೆ ಒಬ್ಬ ಕ್ಲೋಸ್ ರಿಲೇಟಿವ್ ಗೊತ್ತೇ ಇಲ್ಲ ಅಂತ ಹೇಳಲಿಕ್ಕೆ ಆಗುತ್ತಾ? Whether we can presume that?
No, that can't be. It can't be Ben, because relations are strained. There is no contact at all. ಅವರಾಗೆ ಹೇಳೋದಿಲ್ಲ ಅಂದ್ರೆ now and then they were saying that they were threatening that you will be taken to task. ಬೇರೆ ಅಥವಾ ಅವ್ರ ವಿಲೇಜ್ಗೆ ನಾವು ಹೋಗಿದ್ವಿ, ಐ ಹ್ಯಾವ್ ಸೀನ್ ದೆಮ್, ಅಥವಾ ಅವ್ರು ನಮ್ಮ ವಿಲೇಜಿಗೆ ಬಂದಿದ್ರು ಏನಿ ಸೋಷಿಯಲ್ ಗ್ಯಾದರಿಂಗ್ಗೆ, ಅವಾಗ ನಾನು ನೋಡಿದ್ದೆ, ಅವ್ರಿಗೆ ನನ್ಗೆ ಗೊತ್ತಿದೆ, ನೋಡಿದೀನಿ, ಅಂಥದ್ದೇನೂ ಇಲ್ಲ ಇಲ್ಲಿ. ಅವ್ರು ಹೇಳೋದು ಪರವಾಗಿಲ್ಲ, PW1 ಆದ್ರೂ ಹೇಳ್ಬೋದಾಗಿತ್ತಲ್ಲ. No, this is all about, this is the incrimination, material contradictions.
To avoid the motive, your submission would be they are in good terms. They were in good terms.
ಇಲ್ಲ ಹಾಗೆ ಹೇಳಿಲ್ಲ, ನಾವು ಎಲ್ಲಿಯೂ ಹೇಳಿಲ್ಲ. ಗುಡ್ ಟರ್ಮ್ಸ್, ಎನಿಮಿಟಿ ಇಸ್ ಡಬಲ್ ಎಡ್ಜ್ ವೆಪನ್. ಬಟ್ ಅದನ್ನ ಯೂಸ್ ಮಾಡಿದ ಅನ್ನೋದು ಬೇಕಲ್ಲ ನಾ ಹೇಳೋದು. 8 ವರ್ಷ ಡಿಸ್ಪೋಸಲ್ ಆದ್ಮೇಲೆ, ಕೇಸ್ ಡಿಸ್ಪೋಸಲ್ ಆದ್ಮೇಲೆ ಏನ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಇತ್ತು, ನಾವು ಮತ್ತೆ ಅವ್ರಿಗೆ ಏನ್ ಕೆದಕಿದ್ರು ಅಥವಾ ಏನು ಬಂದು ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಮಾಡಿದ್ರು ಅಪೋಸಿಷನ್ ಮೇಲೆ, ಅಂತದ್ದೇನೂ ಇಲ್ಲ. ಕಮಿಂಗ್ ಟು A4,
there is no occasion to identify PW5 ಅಂತ, that is your contention.
PW1 in his chief examination paragraph 2.
PW6.
6 Kalmesh.
Yes, Kalmesh.
Now, so far as the accused number 4 is concerned, PW1 in his chief examination paragraph 2, on page number 158 of the paper book. 158. ನನ್ನ ಅಕ್ಕನ ಹೆಸರು ಮನೆಯಲ್ಲಿ ದ್ಯಾಮವ್ವ ಎಂದು ಮತ್ತು father-in-law had purchased the land in the name of his There is no any litigation. They have not filed any suit for partition, either against their father or against their sister-in-law. Nothing of that sort. ನಮ್ಮ ತಂದೆ ತಾಯಿಗಳು ನಮ್ಮ ಅಕ್ಕನ ಮಾವ ಮೊಗಪಕ್ಕ ಮುಟ್ಟಿಗೆ ನಮ್ಮ ಅಕ್ಕನ ಹೆಸರಲ್ಲಿ 9 ಎಕರೆ ಜಮೀನು ಖರೀದಿ ಮಾಡಲು ಕಾರಣರಾಗಿದ್ದಾರೆಂದು 4ನೇ ಆರೋಪಿ ನಮ್ಮ ತಂದೆ ತಾಯಿಯ ಮೇಲೆ ಸಿಟ್ಟಾಗಿದ್ದರು. ಏನು ಸಿಟ್ಟಾಗಿದ್ರು ಅಂದ್ರೆ ಏನಾಗಿತ್ತು? ವಾಸ್ ದೇರ್ ಎನಿ ಕ್ವಾರಲ್? ನಥಿಂಗ್ ಆಫ್ ದಟ್. ಈ ಘಟನೆಗೂ 4-5 ವರ್ಷಗಳಿಗೆ ಮೊದಲಿಂದಲೂ 4ನೇ ಆರೋಪಿ ಹಣಮಗೇರಿ ಗ್ರಾಮ ಬಿಟ್ಟು ಬಂದು ನಮ್ಮ ಮಾವಂದಿರ 1ರಿಂದ 3ನೇ ಆರೋಪಿತರೊಂದಿಗೆ ಸುತುಗುಂಡು ಗ್ರಾಮದಲ್ಲೇ ಇರುತ್ತಿದ್ದರು. ಏನು ವಾಟ್ ಈಸ್ ದ ಎವಿಡೆನ್ಸ್? He has got his own landed property at his village, Hanmageri. Now, in the complaint, as per the say of this PW6 Kalmesh, he names one Iresh, accused number 1, 2, 3, and one Iresh. He has not named Krishnappa. Krishnappa or Karappa ಅಂತ ಹೇಳಿದ್ದಾರೆ. Not an accused.
ಅಲ್ಲ, ಇನ್ನು ಕಂಪ್ಲೇಂಟ್ ಸದದಗುಂಡಿಯ ಪರಮಾನಂದ, ಮಾಳಪ್ಪ, ಮುರೆಪ್ಪ, ಕೃಷ್ಣಪ್ಪ. ಅದು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದು ಕರೆಪ್ಪ ಅಂತ, ನಾಟ್ ಇನ್ ಎಕ್ಸಿಬಿಟ್ P1.
ಎಕ್ಸಿಬಿಟ್ P1 ಬಂದಿದೆ.
ಎವಿಡೆನ್ಸ್ ಆಫ್ PW6 ಅಲ್ಲಿ ಕರೆಪ್ಪ ಅಂತ ಹೇಳಿದ್ರು.
ಅದು ಅಲ್ಲಂತಿಗೆ ನಮ್ದು FIR ನಲ್ಲಿ ಅವಾಗ ಹೆಸರು ಬಂದಿರಲಿಲ್ಲ. FIR ನಲ್ಲಿ ಅವನು ಹೇಳಿಲ್ಲ.
ಕೃಷ್ಣಪ್ಪ ಅಂತಲೇ ಬಂದಿದೆ, ಆ ಹೆಸರು ಬಂದಿಲ್ಲ. ಕರೆಪ್ಪ ಅಂತ ಬಂದಿಲ್ಲ, ಕೃಷ್ಣಪ್ಪ
ಅಂತ ಬಂದಿದೆ.
So your name is Krishnappa.
Yes.
Whose evidence? Karappa ಅಂತ ಹೇಳಿದ್ದು
PW6 ಕಲ್ಮೇಶ್.
ಅಲ್ಲ, ಕಲ್ಮೇಶ್ ಅಲ್ಲ, 5 ಎವಿಡೆನ್ಸ್ ಅಲ್ಲ ನೋಡಿ. PW5 ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಕರೆಪ್ಪ ಅಂತ. Anything else?
This is FSL report. In the FSL report, all the seized items have been forwarded. All the items except the sample soil. All items were shown to have blood stain of human blood and that of O group. So, yardu blood. The spot Panchanama took place almost 24 hours after the incident. And it is admitted by all the witnesses, including the IO, that there is a traffic throat. Whether they could have really collected the blood stains from that place is a point in question. So that
FSL exhibit ಎಷ್ಟು ಅದು?
Exhibit last 42.
Exhibit 42. The items, blood stain ಆದದ್ದು items ಯಾವುದು? Clothes of the deceased.
Clothes of the deceased
and the weapons. So these weapons are, say, it is only to point out that these weapons were used for the commission of crime. To show that only these weapons were used for the commission of crime anta. So same blood stain, the clothes of the deceased and
clothes of deceased yardu which deceased ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಇಲ್ಲ. Blood group of Kalmesh, PW6 Kalmesh is also not taken. It said that he had also blood injuries, bleeding injuries, and that person's blood group is sample is not taken.
Not required. Why?
No, in given circumstances. ಅವ್ರದೇ ಇತ್ತು ಬೇಕಲ್ಲ, ಇಂಪ್ಲಾಂಟ್ ಅವನು ಎಲ್ಲ ಇಂಪ್ಲಾಂಟ್.
Grouping is blood stay ಅಗತ್ಯ ಇಲ್ಲ. What is the necessity? Then accidental injury, that is stated.
No, all right.
Even otherwise, PW5 specifically stated that you do accident in the other than.
Now we are challenging the recovery also under exhibit
recovery.
recovery under exhibit P15.
Yes.
Blood stains were to be found ಅಂತ ಹೇಳ್ಬೇಕಾದ್ರೆ ಆ blood stains ಯಾರು ಯಾವ ಇಂಪ್ಲಾಂಟ್ ಉಪಯೋಗ ಮಾಡಿದ್ರು ಯಾರು ಮಾಡಿದ್ರು is a question that we are disputing it. To tag us that it is we who have used those material objects.
Weapons were used at your instance. PW4 is the witness for that.
Yes.
Under different masses.
Yes.
Those weapons were stained with the human blood of O group. The blood group which found in the clothes of the deceased also same that of O group, human blood O group. That is the corroboration.
That is corroboration provided the seizure is proved. Seizure at the instance of accused is proved. PW4 what he says, ಮನೆ ಒಳಗೆ ಕರ್ಕೊಂಡು ಇಲ್ಲಿ ಪಂಚನಾಮ ಹೇಳ್ತದೆ ಮನೆ ಹಿಂದ್ಗಡೆ ಇಟ್ಟಿದ್ರು ಅಂತ ಹೇಳಿ ವೆಹಿಕಲ್ ಸೊ ಫಾರ್ ಆಸ್ ವೆಹಿಕಲ್ ಇಸ್ ಕನ್ಸರ್ನ್. ಇವು ವಿಟ್ನೆಸ್ ಹೇಳ್ತಾನೆ ಮನೆ ಒಳಗಡೆ ಕರ್ಕೊಂಡು ಹೋದ್ರು ಒಳಗಡೆ ಎಲ್ಲ ವೆಹಿಕಲ್ ಇತ್ತು ಅಂತ ಹೇಳಿ. ಇಟ್ ಇಸ್ ಅನ್ನಂಬರ್ಡ್ ವೆಹಿಕಲ್. ಅದು ಯಾರ್ದು ಎಲ್ಲಿಂದ ಬಂತು ಅಥವಾ ಅವ್ರದೇ ಅಕ್ಯೂಸ್ಡ್ ಅವ್ರು ಏನು ಹೇಳಿದ್ರು ಇಂಥವ್ರ ಕಡೆಯಿಂದ ನಾವು ತಗೊಂಡಿದ್ವಿ ಫಾರ್ ಕಮಿಷನ್ ಆಫ್ ದಿಸ್ ಅಫೆನ್ಸ್ ಆರ್ ಸಿನ್ಸ್ ಲಾಂಗ್ ವಿ ಹ್ಯಾವ್ ಬೀನ್ ಯೂಸಿಂಗ್ ಇಟ್. IO has not taken pains to search for that part of evidence. Now, so far as the seizure regarding bloodstained clothes are concerned, or illinda ellaru tegudukotru anta ಹೇಳ್ತಾರೆ. Individual statement is that of individually. All statements leading last sentence nalli exhibit P28 to P35, 38, 35. A particular portion is same. ಯಾರ್ ಬ್ಲಡ್ ಸ್ಟೇನ್ ಎಲ್ಲಾರ್ದು 5 ಮಂದಿದ್ ಬ್ಲಡ್ ಸ್ಟೇನ್ ಕ್ಲಾತ್ಸ್ ಯಾರ್ದು ಯಾವ್ದು ಅದಕ್ಕೆ ಅವ್ರು ಕ್ರಾಸ್ ನಲ್ಲಿ ಕೇಳಿದಾರೆ ಆ ಕ್ಲಾತ್ಸ್ ನೀವು ಅವ್ರಿಗೆ ಹಾಕಿ ನೋಡಿದಿರಾ ಅಂತಂತ ಅವ್ರು ಅಂತಂತೇಳಿ ಇಲ್ಲ.
ಜಾಯಿಂಟ್ ರಿಕವರಿ ಅಂತ
ಜಾಯಿಂಟ್ ರಿಕವರಿ and even
recovery is believable. That is the
joint recovery is not believable.
After that Bombay blast case, Supreme Court said the joint recovery also is it can be relied on. ನೀವು ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೇಸ್ ನಂತರ
ಬಂದಿದೆ ಅದು ಬಂದಿದೆ. ಬಟ್ ಅದರಲ್ಲಿ ಏನಾಗ್ತಿದೆ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸಸ್ ಇಟ್ ವಾಸ್ ಸೀನ್ ವಾಸ್ ಸೀಲ್ಡ್. Scene was sealed. It was not disturbed. It is not so here. After almost after 24 hours, they go to the scene of occurrence. And 10 days thereafter, Lordship may kindly see 7-1 incident ಆಗ್ತದೆ. And this CPI, PW12 comes in picture, investigation starts on next day. He says that I gave instructions to PSI to search for the accused. Between 7-1-8-1 to 16-1, what PSI did to search them, where all he searched, had he gone to their house, they were not available, or what they did they arrest anybody as a precautionary measure to get them? Nothing is there. ಈ ಮನೆ ಕರ್ಕೊಂಡು ಹೋಗ್ದೇನೆ ಅಂತ ಹೇಳಿದ್ರೆ ಮನೆಯಲ್ಲಿ ಯಾರಿದ್ರು? Is it abandoned house?
Who opened the door?
Open the door. So these are the questions that arise. They are almost unanswered. These gaps, which are very much there on record, they cannot be just plugged by without there being any explanation either by the witness, punch witness, or by the IO himself. 17-1 they go and they say that PSI says, PW14 says, now duty ಮೇಲೆ ಹೋಗಿದೆ ಜಮಖಂಡಿ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ನಲ್ಲಿ. ಜಮಖಂಡಿ is not over there, ಅವ್ರದ್ದು jurisdiction ಅಲ್ಲ. ಜಮಖಂಡಿ is not their jurisdiction. ಬಾಗಲಕೋಟೆ ಹೋಗ್ಲಿ ಪರವಾಗಿಲ್ಲ, let them show it on their report ಬಗ್ಗೆ ಮೆಮೊ ಏನಾದ್ರು ಹಾಕಿದ್ದಾರೆ. No report is memo is filed. ಪರವಾಗಿಲ್ಲ ಹೋಗಿದ್ದಾರೆ ಸರಿ. What is the exhibit P27? Names of these accused.
Out of jurisdiction search
ಮಾಡಬಾರ್ದು ಹೇಳೋದಿಲ್ಲ. ನೀವು ಹೋಗಿದಿರಿ ಮಾಡಿದಿರಿ, what should have been done? immediately that police station jurisdiction should have been informed that under your jurisdiction, we have apprehended these persons. They are involved.
Not necessary.
Not necessary, forgetting for that moment. Forgetting for that. What is your exhibit P27, my lord? Exhibit P20 ನಾವು ಅವ್ರು ಹೇಳಿದ್ರು, ಎಲ್ಲ ಹೆಸರು ಹೇಳಿದ್ರು, ಅವರೆಲ್ಲ ಹೇಳಿದ್ರು, ಅವ್ರ ಕ್ರೈಮ್ ಬಗ್ಗೆ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಬಗ್ಗೆ ಹೇಳಿದ್ರು. Therefore, we apprehended them. PW27, exhibit P27 ಅಲ್ಲಿ ಬರ್ಬೇಕಾಗಿತ್ತು, ಅವ್ರ ಹೆಸರು ಬರ್ಬೇಕಾಗಿತ್ತು. ವೆಹಿಕಲ್ ನಂಬರ್ ಇಲ್ಲ, ಅವ್ರ ಹೆಸರು ಇಲ್ಲ. So arrest and then producing before CPI, then they giving these statements. It's all farce. Therefore, my submission is all created story is to falsely implicate so far as accused number 4 is concerned. Absolutely had no any grievance against the family of the whatever he, even if suppose he had, he would have had his grievance against his father-in-law, that too if his wife wishes to file any suit for partition. Not only she alone, along with other sisters. Why she would have again enmity with her sister-in-law's father and mother? It's most imaginary things. As pointed out earlier, PW2 ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಅಲ್ಲಿ ಮತ್ತೊಂದು ಲ್ಯಾಬ್ಸ್ ಹೇಳ್ಬೇಕಂದ್ರೆ ಸ್ಪಾಟ್ ಪಂಚನಾಮದಲ್ಲಿ ಅಲ್ಲಿ ಅವರು ಜೀಪ್ ಅನ್ನ ದಿಸ್ ಡಿಸೀಸ್ಡ್ ಓವರ್ ಟು ಕೆ ಟ್ರ್ಯಾಕ್ಟರ್. ದೇರ್ ಆಫ್ಟರ್ ಆಕ್ಸಿಡೆಂಟ್ ಟುಕ್ ಪ್ಲೇಸ್. ದಟ್ ಪೋರ್ಷನ್ ಹ್ಯಾಸ್ ಕಮ್ ಇನ್ ದಿ ಸ್ಪಾಟ್ ಮಾಜರ್. ಅದನ್ನ ಇವರು ವಿಟ್ನೆಸ್ ಕಡೆ ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಂತ ಆ ಪೋರ್ಷನ್ ಅದು ತಪ್ಪು ಅಂತ ಬರೀತಿ ಹೇಳ್ತಾರೆ. ಕಂಟೆಂಟ್ಸ್ ತಪ್ಪು, ಇವ್ರು ಹೇಳೋದು ತಪ್ಪು. ಆರ್ ದ ಪರ್ಸನ್ ಹೂ ಸೂಪರ್ವೈಸ್ಡ್ PW12 is a mistake. It is his mistake. Whose mistake it is? Anyway, these are the things which have gone into in the investigation. Srishal Kanbur, so far as his case is PW4 is concerned, already my friend has elaborately submitted, read. A motorcycle bagge and a vehicle that was seized in the police station. You seize my exhibit P27 alli ಏನು ಹೇಳ್ತಾರೆ, ಅವರು ವೆಹಿಕಲ್ ನಲ್ಲಿ ಜಮಖಂಡಿಯಲ್ಲಿ along with the vehicle they came. Witness doesn't say that it was produced by accused number 2 Parmanand. Police station a vehicle seize ಮಾಡಿದ್ರು, ಅದಾದ್ಮೇಲೆ police accused took them to let them to their house ಅಂತ ಹೇಳ್ತಾರೆ. House ಅಂತ ಅವ್ರು ಹೇಳಿದಾಗ, ಅವ್ರ house ಅಂತ ಹೇಳಿದಾಗ it was expected to show that it belongs to them, or there it was locked, or some inmates were there. Nothing is there. Evidence that of PW5 is concerned is most he's a planted witness is very much evident. From his chief examination, cross-examination. The last sentence I would like to read from his evidence. In the first sentence of his cross-examination of 200, again he is reiterated that he is very close relative. But and the last portion, he admits that he doesn't have a license, motorcycle license. And he even does not redact. He says that he saw the incident from a distance, from 50 meters and 50 feet and one kade 150 meters, 150 feet and he has not reacted. He may have fear psychosis. It's quite possible seeing such an incident. But after that, what is his conduct? That is not acceptable to any prudent man for that matter. In his cross-examination, he has even admitted that even he did not disclose it before his own family members after going. And he doesn't, his own relatives, dead bodies are there, he leave them and go to his house. Till next day afternoon, he doesn't bother about that. What happened to them? And he doesn't want to, even he has not contacted PW what he made, whether he did lodge any complaint or not. He doesn't inquire at all. So these are the circumstances, my lord. It goes root of the case that this is, it is very systematically created story suppressing the genesis of crime. Now, from the evidence of PW 10 doctor, as read earlier, yesterday, even homicidal death, not that is also not, there is no clarity.
You are disputing very homicidal death itself.
There is from the records, from the records, it might have happened. So these are the, I'll be relying upon three decisions. I was under the impression that my turn will come and the reply. I will
Judgment
just-
you can, yes, yes, reply
Got it.
judgment put to bed.
Got it.
Huh?
Yes, sir.
SPPS tomorrow.
Yes, sir.
I'll call that office.
You call or that we not pass any order, but anyhow, you have to complete by tomorrow.
Yes.
Tomorrow your argument, morning.
Yes.
We will take up your argument and day after tomorrow dictation ಮಾಡಬಾರದು. So ನೀವು ನಾಳೆ finish complete ಮಾಡಬೇಕು. ಒಂದು ಕೇಸಿಗೆ ಒಂದು ವಾರ ಆಗುತ್ತೆ, ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಕೊಡುವಾಗಿಲ್ಲ. Same or same?
A5 is also same.
Yes, yes. Yes, yes. Yes.
You want to come or do through VC?
So, sorry, my lord.
You want to physically come or do through VC?
I am interested to VC also, but I am ready to do with this VC.
ನೋಡೋಣ. Anyhow, you are marking your presence, we'll see. Mostly Monday ಮೇಲೆ. Let us.
SPP, you made some valid points, you have to reply properly.
Yes.
Tomorrow, you have to assist
Preventive
proper.
proceeding.
Huh? This series. But you have to assist properly by tomorrow. Huh?
When there is lacunas and some. बैठो ऐसा भी आया थोड़ा कुड़ी फुल फाइल कुड़ी ಇದು ತಗೊಂಡು
TCR sir ಅದು.
ಇದು TCR ಐತೆ ಫೈಲ್ ಕೆಳಗಿನ ಕೋರ್ಟಿಂದ ಇರುತ್ತಲ್ಲ ಇಲ್ಲಮ್ಮ ಕೆಳಗಿಂದ ವೆಹಿಕಲ್ ರಿಲೀಸ್ ಮಾಡ್ಕೊಂಡಿದಾರ ಏನ ಅವೆಲ್ಲ ನೋಡ್ಬೇಕ್ರಿ ಅದು ಇದೆ ಮೇನು ಯಾದಕ್ ಬರ್ತೀರಿ ನೋ 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 ಸಾಧ್ಯ ಇಲ್ಲ ಈ ಕಡೆ ಒಂದು ಬ್ಲಾಂಕೆಟ್